Okay, we'll get started. Welcome to today's public hearing for the 2022 reviews of the Compulsory Third Party Insurance and Lifetime Care and Support Schemes. These reviews form part of the committee's regular reviews of the two schemes in accordance with its oversight role under Section 27 of the State Insurance and Care Governance Act 2015. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians on the lands on which we are meeting today. I pay my respects to elders past and present and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. Today, we will be hearing from a number of stakeholders, including road user groups, legal representatives, representatives of the Insurance Council of Australia, iCare, the Independent Review Office, and the State Insurance Regulatory Authority. I thank everyone for making the time to give evidence to this important inquiry. Before we commence, I would like to make some brief comments about the procedures for today's hearing. Today's hearing is being broadcast live via the Parliament's website. The proceedings are also being recorded and a transcript will be placed on the committee's website once it becomes available. In accordance with the broadcasting guidelines, the House has authorised the filming, broadcasting and photography of committee proceedings by representatives of media organisations from any position in the room and by any member of the public from any position in the audience. Any person filming or photographing proceedings must take responsibility for the proper use of that material. This is detailed in the broadcasting resolution, a copy of which is available from the Secretariat. While parliamentary privilege applies to witnesses giving evidence today, it does not apply to what witnesses say outside of their evidence at the hearing. I therefore urge witnesses to be careful about comments you may make to the media or to others after you complete your evidence. Committee hearings are not intended to provide a forum for people to make adverse reflections about others under the protection of parliamentary privilege. In that regard, it is important that witnesses focus on these issues by the inquiry terms of reference and avoid naming individuals unnecessarily. All witnesses have a right to procedural fairness according to the Procedural Fairness Resolution adopted by the House in 2018. If witnesses are unable to answer a question today and want more time to respond, they can take a question on notice. Written answers to questions taken on notice are to be provided within 21 days. If witnesses wish to hand up documents, they should do so through the committee staff. In terms of the audibility of the hearing today, I remind both committee members and witnesses to speak into the microphone. For those with hearing difficulties who are present in the room today, please note that the room is fitted with induction loops compatible with hearing aid systems that have telecoil receivers. Finally, could everyone please turn their mobile phones to silent for the duration of the hearing? And I now welcome our first witnesses. If each witness could please state their name and position title and swear either an oath or affirmation. I'll start with the witnesses in the room, starting from my left.
Good morning, everyone. Michael Timms, Deputy Chair, Australasian College of Road Safety, New South Wales Chapter. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Brian Wood, Secretary of the Motorcycle Council of New South Wales. I solemnly, sincerely and truthfully declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Martin Rogers, CEO of the New South Wales Taxi Council. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Nick Abraham, Deputy CEO, New South Wales Taxi Council. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Excellent. And I'll now go to the witnesses online. Have you been provided with a copy of the oath or affirmation? Yeah. Ms. Cohen, would you like to start?
Thank you. Michelle Cohen. I'm the Principal Solicitor at the Public Interest Advocacy Centre. And I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Sheetal Balakrishnan, Senior Solicitor at the Public Interest Advocacy Centre, and I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Excellent. Thank you to all the witnesses joining us today. I would like to start by inviting any of the witnesses to make a short opening statement, no more than a couple of minutes each. Mr. Timms, would you like to?
Yep. Thank you,
do have
Mr.
a
Chair.
opening statement?
The Australasian College of Road Safety is focused on saving lives and preventing serious injuries on our roads. The committee's work in overseeing compulsory third party and lifetime care is vital for road safety. It's the target of national and state road safety strategies to reduce road crash injuries by 30% by the end of 2030. To put that into perspective, in 2021, more than 10,000 people were hospitalised in New South Wales as a result of a crash, according to the latest data. Each one of those 10,000 represents a life changed and a potential demand for lifetime care. Sadly, in every year since 2013, more than 10,000 people have been hospitalised as a result of a crash. At the previous inquiry, ACRS argued the best way to sustain post-crash care and lower premiums is by reducing the burden on the scheme. Filling the Sydney Football Stadium with road crash victims every 4.5 years is not sustainable. It's no cause for celebration just yet, but the provisional hospitalisation figure for the March quarter of 2022 did fall by 29% compared to the same period last year. ACRS is pleased to read about CIRA's support for a range of road safety initiatives. We also note CIRA is monitoring electric scooter trials and automated vehicle policy. In our submission, ACRS calls upon the CTP sector to show leadership and innovation. Help customers of all ages make better decisions when purchasing a new vehicle or protective motorcycle gear. Eliminate economic inequality and find ways of increasing the share of policies held for 5-star vehicles. Finally, ACRS calls upon the CTP sector to formally adopt official road safety targets as corporate policy.
Thank you. Mr. Wood, would you like to?
Yes, I would like to make an opening statement. Motorcycle Council, we still have concerns about the excess profit and loss mechanism, in that the 10% profit is for the whole of the scheme, not for individual vehicle classes. So there's still a possibility that motorcycles in some of those categories could be paying more than 8%, but there is no way of knowing whether that is the case. There is Class 10, which is the largest capacity motorcycle. In that one, the most expensive premiums are those in the country, whereas in all other capacity classes, it's Metro which is the highest. We've not had an explanation as to why that difference is, but has been suggested that it may be because there have been some large claims in that Class 10H, the country, large claims which have put the premiums up. But if that's the case, perhaps is the same thing happening with the profits, that the profits are not easily across those classifications, because we have 25 classifications. In some of those, there's only about 1,000 vehicles. This compares with probably Metro car. There might be somewhere like a million. So, how do you sort of deal with a scheme which in one class has got 1 million policies and in others only has about 1,000? So how do you make it equitable across the whole scheme? We still have concerns about what compensation you receive when you crash interstate. We have worked closely with CIRA, and they've produced information both in a pamphlet and also online about what compensation you get if you do crash interstate. Our main concern is still Tasmania, because there, if it's a crash that doesn't involve a Tasmanian registered vehicle, you get no compensation. So while we put the information out to riders, it's probably not all that evident that people would be aware that if they do crash in Tasmania, they could be get no compensation at all. Victor Dominello, the Minister, did suggest you take out additional insurance to cover it, but it has also been suggested that you can't take out two insurance policies which cover the same risk. So we're not really quite sure, well, what type of policy should you take out so you don't fall foul, or when you need to rely on it, find that there's a technicality and that you're trying to cover the same risk with with two different policies. We have written to the Premier of Tasmania to ask him what he might suggest is the solutions to this problem. And we've also suggested to CIRA that perhaps a scheme should be like that in Victoria, where TAC top up what you receive as compensation from another state. They top it up as if the crash occurred in Victoria. We would very much like to see that type of scheme introduced into New South Wales, but I think that probably would require a legislative change to permit that. We would really like to see calculations on what difference it might make to premiums if that sort of mechanism was introduced. We're still, I guess, concerned about crashes that are really the result of road defects, that the road authority, who is responsible for that part of the road, you know, if you crash as a result of gravel or a pothole or a slippery steel plate, that really should be the responsibility of the road authority to pay the compensation. The compensation shouldn't come out of the CTP scheme, because that then just puts the premiums up. Because we do have this scheme called a safe system. I'll note that it's called safe system, not safer system. So that should be, so the road network should be safe to use, and it should be safe to use by all road user groups. We do put in our submission a case that one of our delegates approached us. He had perhaps not a very good experience, or his wife didn't have perhaps that good an experience making a claim. There were a number of factors that happened there. One was that it occurred just before Christmas, so being able to engage with people after Christmas, getting medical appointments with specialists during that sort of holiday period, and also being self-employed. So there are a number of factors that made it difficult for them to be able to put forward a claim. So whether there needs to be a mechanism by which some of these sort of high risk or factors are taken into consideration so that they get priority when trying to get their claims resolved. I'd also like to express appreciation to CIRA for the ongoing quarterly meetings that we have with them. They're able to provide us with quite a lot of information on how the scheme is progressing. You know, we're really looking for trends as to where the scheme lands. COVID has somewhat upset that, so that the trends, it's not quite clear yet, just where we're going to land with premiums for motorcycles. All right, thank you for the opportunity.
Excellent. Is there an opening statement from the Taxi Council? And thank you for joining us today. I know it's probably been a very busy couple of weeks for you.
It has. Thanks for allowing us to attend this morning. The New South Wales Taxi Council welcomes the opportunity to review and respond to the terms of reference paper released by the New South Wales Legislative Council Standing Committee on Law and Justice for the review of the Compulsory Third Party Insurance Scheme. The New South Wales Taxi Council acknowledges the current challenges in the competitive set within the point-to-point transport sector. Hence, we are grateful for the ongoing collaboration and consultation between the New South Wales Taxi Council and the State Insurance Regulatory Authority, CIRA, working towards addressing some of these challenges. We acknowledge the work being undertaken by CIRA towards reforming the framework for CTP. It is vital that this reform is completed ASAP to ensure delivery of a competitor-neutral scheme between rideshare, hire cars and taxis. Whilst there have been some developments already made in the point-to-point sector in relation to CTP, more is required to achieve a true level playing field for all participants. The New South Wales Taxi Council, together with its members, strongly believe that a truly levelling of the playing field will only be achieved if all point-to-point service providers, including taxis, were grouped into Class 1 for CTP or in the same class. We have seen this evident in other states, such as Queensland, where all personalised transport service providers have been put in the same class, ensuring competitor neutrality. We thank the Honourable Rod Roberts from One Nation for his recent efforts and the support of others, including Ms Abigail Boyd, who is also part of this committee, in looking to find a resolution to this disparity that is yet to be adequately resolved for the taxi industry. In addition to CTP inequities, there is also a significant issue in the disparity of workers' compensation between taxis and rideshare. Taxi operators are mandated to take out workers' compensation policies for any drivers they bail a taxi to. However, rideshare operators and the equivalent do not have the same requirement for any drivers they lease or provide a vehicle to. We have seen the rideshare model evolve over the recent years, from an individual choosing to drive part-time to earn some additional income, to now seeing more full-time participants enter rideshare on a full-time basis. This has led to a large number of individuals operating fleets of vehicles and leasing out to drivers, in the same manner a taxi operator bails a taxi to a driver. So why are taxi operators required to take out workers' compensation and yet a rideshare operator is not? How are rideshare drivers being protected? We look forward to continuing to work with the State Insurance Regulatory Authority as we aim to achieve a more competitor-neutral scheme within the point-to-point transport sector, delivering better outcomes for the travelling public.
Wonderful, thank you. And Piak, any opening statement?
Thank you very much, and thank you for the opportunity to address the committee today. I'll speak for a minute and then hand over to my colleague Sheethal. The Public Interest Advocacy Centre is a social justice law and policy centre that works with people and communities who are experiencing disadvantage to tackle injustice and equality. We have a long history of working on the rights of people with disability. Earlier this year, PIAC was approached by Disability Voices Tasmania, an advocacy organisation in the context of the current e-scooter trial in Tasmania, to support Disability Voices Tasmania's advocacy for better safety measures. DVT shared with us numerous examples of incidents resulting in injury involving people with disability that occurred in Tasmania. Through our work with DVT, we became aware of the ineffectiveness of insurance policies provided by the hire and ride e-scooter operators. We made our submission to this inquiry to bring this discrete issue to the committee's attention, to be considered in relation to any amendments to the scheme. In making our submission and comments to the committee today, we want to note that PIAC is not an expert on CTP insurance, nor does providing advice in relation to CTP cover fall within our legal practice areas. In addition to this issue being an issue that disproportionately affects people with disability, these issues are relevant to all members of the public as pedestrians or third parties in the event of an e-scooter related incident. It's important to note as well that as part of the current e-scooter trial in New South Wales, that it's illegal to ride e-scooters on footpaths. However, there is a real likelihood, and it is the case, that e-scooter riders are breaching this requirement.
The ineffectiveness of the insurance policies basically relates to the e-scooter providers do provide insurance, and that does include for accidents involving a third party. However, the insurance policies contain various exclusions. So, for example, if the rider was not following the road rules, such as that they were riding on a footpath, that would make the insurance policy void. If the insurance policy is void, the option for an injured third party could be to sue the negligent rider. However, the outcome of any negligence claim would depend on the cooperation of the negligent rider, as well as the rider's means to compensate the third party. So without an insurer to claim from, the limitations associated with suing a negligent rider, and there being no access to a CTP insurance scheme, a third party injured in an accident involving an e-scooter can be left with significant out-of-pocket expenses and no legal recourse. As the use of e-scooters continues to increase, the risk they present to pedestrians in New South Wales also increases. Even though it's illegal to ride them on the footpaths in New South Wales, there is a real likelihood that riders will breach the rules and cause an injury to pedestrians. This has been reported in Victoria, another jurisdiction where it is illegal to ride them on the footpaths. So this, we say, is a significant problem which requires a proper solution. And where the New South Wales government regulates e-scooter use, the government should ensure that members of the public are covered if they are injured from an e-scooter accident. An example of a solution would be to extend the CTP insurance scheme or establish a similar no-fault scheme to ensure that pedestrians injured in an accident involving an e-scooter can claim compensation. By learning from the lessons in the other jurisdictions, this is an opportunity for the government to be proactive rather than reactive. Thank you.
Excellent. Thank you. I might start with a couple of questions and then I'll hand over to the other committee members. Just while we're talking e-scooters, I might start on that. So how would you suggest that it works? So at the moment, if you're in an accident with two motor vehicles, for instance, you know basically the two insurers talk to each other about making a claim. If it's a pedestrian or if it's someone using an e-scooter, currently they wouldn't have a CTP policy. So would are you suggesting then the pedestrian or the person using the e-scooter would claim on, like, who would they be putting the claim in with if there's no insurance currently to that section of the community?
The way that in which it currently works is what we can comment on best, which is that the injured person will need to sue the negligent rider, and then the rider would then need to sue on the CTP cover. But we've got concerns about that approach due to the difficulties that pedestrians may face in suing a negligent rider, and in fact identifying that rider as well. If you're in an e-scooter accident, and particularly if you've got a disability and you're injured, it's very difficult to even identify who is riding the scooter and to stop that person as well. So there are real difficulties. So it does need to be something that the e-scooter companies take responsibility for, in our view. But in terms of how that works technically, we're not the best qualified to do that. But we can comment on the fact that people with disability that we've been speaking to have been saying that it is extremely difficult in practice to identify who the rider of the scooter was, and that even the e-scooter companies themselves can't provide this information due to the nature of the device.
And I might just add to that as well, we understand that the Victorian government's also been asked to consider a similar expansion of its no-fault accident scheme as well. So if there is consideration to expanding the scheme to include accidents that involve e-scooters, it might be worth, of course, as part of the government's consultation, to also consider what other jurisdictions are doing in this space.
Yeah, no, thank you for that. Obviously, one of the options, which I think would be quite onerous, would be to extend CTP to e-scooters, but I think that is quite a significant barrier then to people using e-scooters. If you said that every single person would have to have some form of CTP, it would just become unworkable. I don't know if you've looked at that in any great detail.
We haven't. The purpose of our submission was really to raise the issue with the committee. But yes, I think it really would need to be a matter for the e-scooter companies to see what they can do to step in to assist with that cover.
I might just turn to road safety. I was just wondering if you've looked at all at telematics and the future of using telematics to reduce accidents on our roads, which could benefit the CTP scheme in terms of fewer accidents and potentially even reducing premiums as a result of people using telematics in the future.
Thank you, Mr. Chair. Vehicles are increasingly sophisticated nowadays, and they do provide a lot of evidence to crash investigators and allow insurance companies and other people to have a look at how their customers are actually driving their vehicles. So telematics, the trial, there was a trial run a couple of years ago through CIRA where they installed devices in the vehicles owned by young people, and that monitors how they drive to make sure there's no harsh braking, harsh acceleration, loss of sideways traction, and that then allows in the long run insurance companies to make a more informed assessment of risk as to whether this person's worth insuring. We had a Australasian College of Road Safety in New South Wales. We actually hosted a webinar in 2021, which is still online. I think I put a link to that webinar in our submission. The interesting thing at the time, it was highly acclaimed by a number of ministers. The results of the trial were highly acclaimed. It was described as a game changer, and that was back in 2019, and it's been crickets since then. And we haven't heard anything about it. It'll be very interesting when you speak to CIRA later today if you can find out what they intend doing about that trial, because their website does still talk about how it's reviewing the findings. There's even a portal where you can provide your email address, and CIRA will provide you with an update. But when you try to access that, it bounces back saying it's an invalid email address. So it'd be very interesting to see what the future is there with that. So that's just one type of incidents where technology can assist.
Great. We might ask you about that later today. And then I've just got one on taxis. So at the moment, how would it work between, and this often comes up, but how would it work between the workers' compensation scheme and the CTP scheme? So for taxi drivers in an accident, when would they put in a claim to the CTP scheme, and when would they put in a claim to the workers' comp scheme? Because I assume in the with ride sharing, it's every single accident would be done through the CTP scheme because, as you said, they don't have workers or aren't required to use workers' compensation. So, is it even necessary to have workers' compensation for taxis, or are you suggesting that ride sharing needs workers' compensation? Which way would you suggest? Is it removing workers' comp from taxis or putting workers' comp onto ride share?
Yeah, thank you. Thank you, Mr. Chair. Very, very good question. And what we are calling for is a competitive, neutral approach to the issue that you raise. And we are not asking for the requirement for taxi drivers to not have workers' compensation, because that would be the irresponsible thing to do. We are calling on the responsible thing, and that is for rideshare drivers to be covered under the workers' compensation, because as we understand it, a driver, whether a driver who is an owner driver or whether a driver who works under an operator, is not covered under workers' compensation if there is no cover taken either by the operator or the driver themselves. So just to explain that in a bit more context. So from a taxi perspective, if you're an owner driver yourself, you don't have any other drivers, then you are required to take out your own. It's not a mandatory requirement, but it's an optional requirement and a sensible one for you to take out your own cover. However, under the Clause 10 of the Schedule 1 of the 1998 Workplace Injury Management and Workers' Compensation Act, as soon as you bail the taxi to a driver, whether it be for one shift or many shifts, then you are required, and it is mandatory, to take out workers' compensation for that driver. In relation to rideshare, they sit outside of any framework or requirement under any legislative requirement, and the difference there, Mr. Chair, is that under that legislation that I've just referred to, there is reference to contract of bailment, which is what a taxi operates under. However, rideshare are excluded from that. And our major concern is, while we talk about competitive neutrality, is around the safety of rideshare drivers, who we understand. And we've seen quite a development in the operation space or operator space of multiple operators growing in the rideshare space. However, no change in regards to the workers' compensation requirement. So the modelling of rideshare is very much aligned with the taxis. However, you've got one requirement on one hand, but none on the other.
Excellent. I might hand over to some of my colleagues. Mr. Roberts?
Yeah, if you don't mind. Thank you. Thank you, Mr. Rogers, and I thank you for acknowledging the work of myself and some of my colleagues yesterday in attempting to rectify some issues with the compulsory third party scheme for taxis. I don't have an intricate knowledge, but I have a knowledge. But unfortunately, my knowledge will not form evidence before this committee. So I'm going to put a proposition to you, and you can answer it however you see fit. Is it a fair statement to make to say that under the current legislation at the moment, taxis sit within a class 7, I think it is, for compulsory third party insurance, and therefore pay an extreme premium in the metropolitan area for somewhere around $5,500 to $6,000. Conversely, though, a rideshare operator operating in the same Sydney metropolitan area, to my understanding, operates under a Class 1 third-party insurance scheme with a significant cost-saving factor to the rideshare operator. So we've heard this week and we've seen legislation passed to finally deregulate the industry and what is purported to be create a level playing field. But clearly under this third-party arrangement, it is not a level playing field at all, and taxis are at an extreme financial disadvantage. You know, having to pay out thousands and thousands of dollars more before they even turn a wheel, so to speak. Could you comment on that and provide detail on that?
Yeah,
for
thank
us,
you,
please?
thank you, Mr. Roberts. So I'll give you a couple of different scenarios, but you are correct in that there is a disparity in the CTP that is being paid between taxis and rideshare. One is the collection model. So in the taxi industry, the operator or the owner of the vehicle is responsible for actually paying the whole premium. In the rideshare space, the owner of the vehicle only pays the Class 1. There is a variable model that comes into the rideshare business that has to remit a variable component, but that's not for all of the rideshare operators. There's 1,751 booking service providers currently authorised under the Point-to-Point Transport Commission. Only a handful of them would actually be paying the variable component. So any vehicle that is under those smaller BSPs are actually only paying Class 1. That says a complete disparity between the taxis of $5,000 and someone of $500 in terms of that component, because the variable model isn't there. When you look at where the indications of CIRA is moving to, is to be bringing in a variable model, but also having it limited to saying if you don't do under 100,000 trips, then you don't have to pay any variable premium. So that means you only pay Class 1 if you are a private vehicle. That will have a huge impact, in particular in regional New South Wales, because if you opt out and you have to pay a premium under 100,000 trips in regional New South Wales for a taxi, you'll be paying over $3,000. If you are a private vehicle, you'll pay Class 1. If you're a rideshare vehicle, you'll pay Class 1 of $500. If I look at the risk factors that people talk about, why is taxis in Class 7 versus rideshare in Class 1, let's just take an example of someone in regional New South Wales who is running a wheelchair accessible taxi. They're the driver, they own a vehicle, they transport a passenger, same 3 people from point A to point B. They have a roof light that says they're a taxi. They pay $3,000. If they take that roof light off, same driver, same vehicle, same passenger, and go from point A to point B, same trip, they pay $500. This policy direction will see a significant decrease in people registering wheelchair accessible taxis and other vehicles in regional New South Wales. Same trip, same risks. Why would I pay more commercially from a point of view of $3,000 versus $500? And it's already happening now. Milton Ulladulla no longer have wheelchair accessible taxis, and one of the main reasons is because of the cost of CTP. If we also look then at the other vehicles under the hire car scheme. So hire cars actually, I believe, sit in Class 8. Currently, they still, in the reforms of 2015, 2016, the hire car plates were to be removed and go back to private vehicles. Currently, hire cars sit in Class 8. They pay a premium above Class 1 for their risk factor. When the new regulations roll through, hire car plates will no longer be available and they'll revert back to standard plates, Class 1. So the hire car provider will still be delivering the same level of service, the same level of risk. They were paying a higher premium, but the new regs come in, they'll automatically get a price discount doing the same types of service. So where we're heading is not in a direction where we're going to get neutrality. We're actually going to have more complexity where taxis will be at a complete disadvantage, and CTP will be a significant factor in determining whether a taxi is actually registered. I hope I've provided some clarity for you.
Could I just one further question, Chair, and I'll let it go. Very simple question. Would you describe the current system as it is at the moment as fair and equitable?
We wouldn't describe the current system as fair and equitable.
That's all I have, Chair, at the moment. Thank you.
So just questions while we're on it. So an Uber vehicle, for instance, a vehicle that's used for Uber, it's always class 1?
Yes, so Uber vehicles, so in the rideshare space, it's class 1 for the vehicle. The variable model is paid by Uber, which is currently 10 cents per fare paying kilometre. And because there are over 100,000 trips per year, then they'll still pay that variable amount. But we are moving into a scheme where they want to bring in some risk factors, and we have some concerns about the variables that are being used. You mentioned telematics before, but those variables that are going to be looked at for that variable component that they may pay into the future have to be ensured that they don't bring in commercial advantage to those that are larger providers, because it potentially puts at a disadvantage those that are smaller in nature. So the CTP scheme, as it moves forward, actually looks like it's going to benefit those that are larger providers and not those that are smaller. And we need to make sure we've got a scheme that captures all, not captures most.
Yeah, I mean, I suppose I'm just interested in that. If, say, you own a private vehicle, you occasionally use it for, say, Uber on the weekends or something like that, but it's not the sort of primary use of your vehicle, is very different to, say, someone that uses their vehicle almost solely for the purpose of rideshare. So what I'm suppose asking is that currently, is that calculated as a risk factor at the moment compared to, people who very rarely ever use it for rideshare versus those who use it almost as the sole purpose of their vehicle? Or is that not even looked at in terms of number of trips, for instance?
That's where the variable model comes in at the moment.
Okay.
And what you have to make sure is that the person who has it as a private vehicle is actually registering it under the business term as opposed to private, so actually registering it correctly from a point of view of the rideshare space. Just remember, from a taxi point of view, you have to pay the premium from the first kilometre and the first trip, regardless of how much you use it for. Our view is if you want to participate in the point-to-point transport sector, then be committed to the sector and come in and pay like taxis do. In the future model, if I'm in regional New South Wales and I want to offer one trip, just one trip in a taxi, I'll have to pay $3,000. In a rideshare space, I'll pay $500 from one trip, 1 kilometre. There's no variable option in that space that protects the taxis.
Yeah.
Mr. Chair, can I just add to that? You made a very, very important point there, noting what about somebody who uses a rideshare, uses their own vehicle seldomly, or even if you say someone that drives maybe only two nights a week, wouldn't be someone who would drive it regularly. But when and how are they driving those 2 nights a week? They're driving it generally on the Friday, Saturday night. So during the peak and busiest times in their locations, particularly around the Sydney CBD, where the risks are at the highest, where people are out and about. So, and this is the problem. And you're absolutely right. This is where we're seeing the highest volume of vehicles operating, particularly on those Friday, Saturday night, because they can pick and choose when they work, when it is at the highest risk, and when there are those people driving. And the data talks to that as well. When you look at the spike of accidents and incidents when they happen, it is during those Friday, Saturday nights, and it is predominantly around the Sydney CBD, and that's where predominantly a lot of those rideshare vehicles are congregating. Just want to say that.
I'll hand to Mr. Donnelly now.
Thank you, Chair, and through you, Chair. We've got limited time, so I'll need to share questions as best I can. And some I think will be helpfully responded to by us placing some questions on notice to give the time for a response. And can I particularly thank all submitters and all organisations represented today. Just starting with Ms. Cohen and Ms. Balariction. Can I say thank you very much for raising the matters with respect to the e-scooters. It raises a number of issues, and you did say, of course, that you're seeking to place them on a table, and we thank you for doing that. With respect to the recommendation, your recommendation on page 3 of your submission, just in the first paragraph, you say, and I'll just quote directly from it, where the New South Wales government allows and regulates e-scooter use, the New South Wales government should ensure that members of the public are covered in the event they are injured because of an e-scooter accident. I'm wondering, in a summary way, can I invite you to answer, that in terms of what you understand now, is the regulation of e-scooters in this state, that is formal regulation in this state by the New South Wales government, what do you understand that regulation to be?
Thank you, Deputy Chair. So the understanding of that regulation is, of the framework, is essentially that the New South government has introduced certain rules. So, for example, where the e-scooters can be ridden, so the different types of paths they can be ridden on, the different speed limits that apply to those different paths, and other regulatory rules, including whether helmets are to be worn, and what side of the path you ride on. I hope that answers your question.
Can I just press you a little bit further? These are regulations that have been actually formally put through the Parliament by the government? In other words, the government have passed formal, what stands as regulations of the Parliament for these matters, or are these guidelines, or are these expectations that have been put out in documents or what have you?
I might have to take that question on notice, Deputy Chair, but from what I haven't specifically located a particular regulation, but not for an inability to find it, just from haven't gone down that path yet. But certainly it is on the Transport for New South Wales website as stating that these are the particular rules that need to be followed.
Thank you very much. Sorry, Ms. Cohen.
What I can add to that is that we are aware that the e-scooters are currently being trialled in certain council locations, and that a number of councils have said that they are not prepared to trial the scooters because of the absence of, or the insufficiency of safety regulations.
Yeah.
So there are a number of councils that haven't taken that step.
And it is true, is it not, that e-scooters, whilst we're seeing more of them, in fact have been being used on footpaths now in New South Wales, particularly in the metropolitan areas, for some time. That is a true statement, isn't it?
Sorry, could you repeat that, please,
Yes,
Deputy Chair?
that with respect to the use of e-scooters in New South Wales, particularly with respect to metropolitan areas, whilst we're seeing more and more of them, they have been out there for some time, haven't they, being used by individuals on footpaths and elsewhere. Is that correct?
Well, the trial has only commenced since July this year, and the trial is only in relation to the shared scooter scheme, so ones that are provided by operators. Private e-scooters are not legal in New South Wales, so again, not to say that people don't use private e-scooters, but they're not legal. Only the shared scheme operator ones are legal, and while the regulatory framework says that they're not allowed on footpaths, the anecdotal reports indicate that people are seeing them on footpaths.
Okay, I might leave it there for the moment and some further questions to come on notice. Thank you for that. With respect to Mr. Timms, once again, thank you for the helpful submission. With respect to that SIRA trial that you referred to, I think, in your last contribution, can you just elucidate a bit on that to give us it was a rather
good answer, short, so I'd just like you to elucidate a bit on it. What was the basis of the trial? Who initiated it? When did it start? Et cetera, et cetera.
Look, you're probably better off asking Sarah that because it was their trial run with the Centre for Road Safety. It wasn't an ACRS trial, but from memory, they recruited a number of younger drivers, which is one of the key demographics in terms of road trauma, and they installed a device in the vehicle which measured, as I said, harsh braking, harsh acceleration, loss of traction, those types of events, and sought to try to generate a picture of what a safer driver looks like.
But given the standing of your organisation, were you surprised that you weren't invited to participate in the trial?
Look, I mean,
be frank.
Well, be frank. There's certain things that that we aren't involved in. We probably would have liked to have had some involvement with the e-scooter trial. We know that there's been a number of presentations and information days given, so we probably would have liked an invitation, an opportunity to come along and be more informed in that space as well. The Road Safety Action Plan 2026 also talks about research and impact of telematics-based feedback. So it is part of the Transport for New South Wales Road Safety Action Plan as well. So unfortunately, it doesn't provide a delivery timetable or a schedule of future works in regard to telematics.
So with this Sierra trial that I've just asked you to elucidate on, what do you understand it was called?
It was called the Young Driver Telematics Trial.
Well, thank you for that.
2018 to 2019.
2018 to 2019. My colleague, the Honourable Anthony Denham, sorry, did you want to add anything to the question?
Yeah, I wanted to ask about this technology, this telematics technology. Is it expensive to install?
Oh, look, again, we're not the providers of the technology, so you're probably better off trying to seek advice from Sarah. But there are insurance companies worldwide where they either provide this type of technology or they can subsidise it. And the theory is that having a big brother in your vehicle helps people drive safer. Whether that happens all the time, well, we're not quite sure. There are driving studies, naturalistic driving studies, they call them, held all the time, where cameras and other devices are fitted in vehicles, and people do seem to forget that they're there over time and continue on some of their reckless ways. But this is why we need to look further at these type of technologies. We do, as we said at the introduction, we have the National Road Safety Strategy and the State Road Safety Strategy. They want to reduce deaths by 50% and serious injury by 30% by the end of the decade. So we need to start innovating. Otherwise, we'll be sitting here in 2030 scratching our heads, wondering why there's still 10,000 people hospitalised as a result of road crashes.
So is it technology that provides real-time information to the driver, or is it a technology that just gathers data and then is analysed at a later point in time?
Well, it depends on the technology. In the heavy vehicle space, there's considerable work providing real-time technology. There are a number of products in the heavy vehicle space which offer live monitoring, and the drivers, say for arguments, a truck driver drifts out of their lane. The technology, there's cameras at the front of the vehicle, it notices that the vehicle's drifting, and the driver can receive a warning, either a beep or even the seat vibrates for the truck driver, and that alerts the truck driver that perhaps they're about to depart the road and they should correct their vehicle. So there are a number of products and a number of options that are available for a range of markets.
And this is technology that's available sort of for post-manufacture installation, as opposed to something that's embedded in the vehicle design and manufacture. Is that right?
Look, most of the products that I've encountered that I have knowledge are aftermarket devices, and there's considerable commercial interest at stake in promoting these type of things. Whether they may eventuate into manufacturers, Ford, for example, has a MyKey product, which if your young novice driver is taking out your vehicle for the night, you give them the MyKey as opposed to your key, and the MyKey regulates speed, it regulates volume controls on the radio, and it can regulate a number of features of the motor vehicle. So manufacturers have gotten on board this space as well.
So can you just elaborate how that technology might integrate with, I suppose, the safety classification? I think in your submission you talk about high safety rated vehicles, this kind of technology seems to suggest that, there's opportunities there in terms of enhancing the safety of vehicles with
ANCAP,
sort of post-manufacture.
yeah, thank you. ANCAP,
Yes.
ANCAP, which is the Australian New Car Assessment Program, they continue to raise the bar in terms of technology. A vehicle won't get a 5-star rating if it doesn't have autonomous braking, if it doesn't have traction control, if it doesn't have a range of features. I suspect that ANCAP is watching this space as well, and they'll probably continue to raise the bar in regards to what features go towards vehicles. The whole notion, autonomous braking is a great example. It detects vehicles, and it detects when your vehicle is about to have a crash or a pedestrian is about to jump out in front of you, and it applies the maximum braking force at that time. And the latest research, we have a Journal of Road Safety, which only just came out this week, and it identifies that it certainly prevents these type of crashes, particularly in low speed environments. So we're talking about pedestrians, injuries to bicyclists, motorcyclists, and we're not going to hear about those type of incidents. They're not going to be reported to CIRA as injuries because they don't happen. Unfortunately, we continue to see the novice drivers being put into the least safe vehicles, and until we overcome that type of thinking, unfortunately, we're still going to be seeing some tragedies which have been played out all too often on our roads in recent times.
My line of question is really directed to trying to understand whether, identifying that situation that you refer to, where you've got younger drivers in more unsafe vehicles, older vehicles, and whether there's a capacity to sort of incentivise retrofitting this kind of technology in these older vehicles to bring them up to a higher safety standard. Is that technologically possible?
Well, it is possible. We're not going to pretend that these things aren't without challenges. How do you ensure that a person, once the device is fitted and they leave the shop, that they continue to use it and it continues to be monitored? Certainly, these issues need to be looked at. But as I said, we need some innovation. Now's the time.
I'll just hand to Mr. Fang. You had a question, I think.
Yes. Thank you. Mr. Wood, I noted during your opening statement you talked about the difficulties in having small groups and the way that the profit and margin relates to those groups. And I know you mentioned in Class 10 motorcycles where there was a low number of riders, and obviously it's more expensive in country areas than city areas, which is unusual given the majority of motorcycle insurances are lower in regional areas. Is it and you actually said, I think also that obviously when you've got a scheme where you've got a larger number of users, for example, city-based cars, I think you said there was about 1 million, whereas you've got thousands in some of those other smaller ones. Is it not better though to have, the system amortised over a scheme instead of classes? Because where you would have a smaller class, the fluctuations, should you have a major incident, would be much higher given the lower number of users. Where, by amortising those costs over a scheme, you don't have those fluctuations where you've got a small number of users, where you might have no incidents and then a lower cost, but then one incident raises the cost for everybody because of the low number of the people that you can amortise that cost over.
Yeah, well, I think our main concern is regard to the profit. And while some of those groups may be paying higher levels than 8% in the profit, so we really would like to see it so that the scheme identifies if there are particular classes who are paying well above 8%, yet as the scheme as a whole, it may only be 8%.
Well, I accept that. I guess the point I'm making is that 1 year, 8% could be X, but then an incident in that class would put the costs dramatically higher if you've got a small number of people, creating a large fluctuation. Whereas if you're amortising it over a whole scheme and a much larger number of people, you get less fluctuations because you're amortising that cost over everybody. So isn't it better to have a profit viewed over a scheme as opposed to a class?
As I think it's really that those people in those small classes are not being disadvantaged. That they're
And
not
that's-
haven't for some reason ended up paying a higher rate of interest, higher than that 8%.
Yeah, while I accept that, you know, they might be higher in some years, if there is a major incident, then they haven't got those. Anyway, I was just curious as to see the methodology and whether you're perhaps open to looking at it in another way.
I think probably the first step is, can we see some of the numbers? Can we actually see, you know, what each class is perhaps paying as a way of profit? You know, is it really an issue? We might be concerned about something that's perhaps not really an issue, but without seeing some data on it, we're not sure.
Understood. Did you have a question?
No, I'm good.
Just noting the time, that's probably us done.
Quick one.
Mr. Donnelly wants to
Quick-
quick one. Yeah.
Yes.
I have another question.
I just read motorcycles, and thank you for the answer, for the submission and comments to Honourable Wes Fang. On the matter of potholes, of which obviously it's an issue that's a significant one, arising, you know, certainly in recent time, significantly because of natural causes, rain, and indeed flooding. Can you please explain to the committee, and sorry, this might seem like a naive question, but a motorcyclist hits a pothole and has a bad spill, so to speak. What normally happens, and I'm talking about in terms of the injury, the damage to the motorcycle, etc. So that scenario of hitting a pothole, let's take it as a big one, and having a spill, how does it all play out in terms of the consequences?
Well, they'd put in a CTP claim to cover their injuries. Now that it's a no-fault scheme, then even because in the case of hitting a pothole, because it's a single vehicle crash.
That's what it's referred to as a single.
So that they're covered by their CTP in that case. Most cases, bikes would have comprehensive insurance, so the damage to the bike would be covered by that policy. But our point is more that if the pothole is there as the result of negligence of the road authority, then rather than the CTP scheme picking up those...
Sorry, sir, can you just say that last phrase? You're referring to the consequences or the circumstances, if it was what?
Well, if it was as a result of negligence of the road authority.
Negligence of the road authority. That's formal legal language, is it? That's...
I would imagine so.
No, sorry, I'm just checking that. I thought that might relate to a piece of legislation.
But in the case where the road authority is aware that the pothole is there and they've done nothing about it, and I guess it's also prioritising repair of potholes.
Right.
You know, if a pothole is in a corner or somewhere where you need to brake, it's a higher risk to a motorcyclist. Yet when they prioritise going around fixing potholes, they're not sort of saying, well, there's a road user class who this pothole is a higher risk for.
Namely motorcyclists.
Yes. But I guess the main point is that the cost of the injuries should go to the road authority rather than to the CTP scheme, because when it goes to the CTP scheme, riders are paying for that in their premiums.
No, thank you.
If it was negligence on behalf of the road authority, then they should be paying.
Thank you, that's helpful evidence.
Unfortunately, we have run out of time, so I'd like to thank all of the witnesses for coming along today. The committee members may have additional questions for you after the hearing. The committee has resolved that the answers to these, along with any answers to questions taken on notice, be returned within 21 days, and the Secretariat will contact you in relation to these questions. Thank you for your time today.
Thank you.
Welcome our next witnesses. Could each witness, starting from my left, please state their name and position title and then swear either an oath or an affirmation.
Andrew Stone, Senior Counsel. I appear on behalf of the Australian Lawyers Alliance. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
John Turnbull. I appear on behalf of the New South Wales Bar Association. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Jana Gumbert. I appear on behalf of the New South Wales Bar Association. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Lee Davidson. I appear on behalf of the New South Wales Law Society. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Wonderful. I'd like to start by inviting each of the witnesses to make a short statement. Mr. Stone, did you have a short statement?
We were going to go from the other end, if we might.
Okay, sure. Mr. Davidson, would you have a short statement?
Yes, thank you. Thank you for inviting the Law Society to give evidence at today's hearing. I'm representing today in my capacity as Deputy Chair of the Injury Compensation Committee. The Standing Committee will be aware that the statutory review of the Motor Accident Injury Act 2017 was conducted by consultants Clayton Utz and Deloitte and assessed the performance of the scheme over the first 3 years. The statutory review culminated in a report published in September 2021, which made many recommendations. The Law Society commends the Clayton Utz and Deloitte report to the Standing Committee as a comprehensive and balanced commentary of the major issues currently facing the C2P scheme. While it is pleasing to see the progress, the Law Society emphasises that some of the important recommendations made from the Clayton Utz Deloitte report were not included in the bill that subsequently passed overnight. In particular, we draw the Standing Committee's attention to the outstanding recommendations, particularly those referenced in our submission. For example, the Law Society has particular concerns around the minor injury framework, which in its current form we consider to be too restrictive and which results in claimants being cut off from statutory benefits prematurely. We'd also like to take this opportunity to comment on the issues of the legal support in the C2P scheme and legal costs. As set out in our primary submission, the Law Society considers that the experience of injured persons in the C2P scheme will often benefit from early access to the services of a legal advisor and advocate. This much has been recognised in the Clayton Utz Deloitte report and the Taylor-Fry review of legal supports. The scheme is complex and access to a lawyer can lead to better outcomes, including access to entitlements, and may enhance the claimant's experience of the operation of the scheme. For a long time, the Law Society has pointed out the way in which the current level of regulated legal costs is insufficient to meet the actual costs of providing advice in motor accident matters. We consider the unsatisfactory way in which costs are provided for in the scheme has the potential to exacerbate barriers to justice, as lawyers will be disincentivised from working in motor accident cases and claimants will be expected to navigate complex legal issues in a procedural system at the Personal Injury Commission without professional advice and support. Thank you for extending the opportunity to the Law Society to give evidence today.
Excellent. Is there an opening statement from the Bar Association?
There is. Thank you for inviting the Bar Association along to address this committee. The Bar Association's paper highlights 4 issues in what I agree with my colleague, Mr. Davidson, is a very complex and difficult, often difficult to manage process. But the 4 issues we've highlighted are firstly, members may be aware there's an issue about if you're a minor injury, you don't get certain benefits. One of those, and minor injury is defined, one of those definitions is that a minor injury is where a doctor says you have a neck or back injury less than 10%. That excludes, therefore, a lot of injured people in the 5 to 10% range, and it's our submission, the Bar submission, that that should be reduced down to the lower level, down to 5%. Even then, you've still got disabled people, and certainly between 5 and 10% impairment in your neck or back is a significant disablement. The second issue we highlight is the way that causation of injuries, that is, was an injury caused by a motor vehicle accident, how's that dealt with? It's dealt with at the moment by doctors, basically, sitting in a surgery, relying upon various codified rules. That is not, from the Bar Association's perspective, a very good way of dealing with it. These are complex issues, causation, whether an injury was caused by an accident or not. It's the Bar's view that issues of causation, what caused a particular injury, should be held in an open court or tribunal so that competing arguments can be put forward and decided by a legally qualified person. The third issue the Bar points to is an increase in the legal costs allowed for statutory benefits. It's just been increased to $1,800 for a particular claim. That is to say, if you act as a lawyer for a claimant in a statutory benefits claim, which can involve a lot of work trying to convince an insurance company that you're entitled to these benefits, you get paid $1,800. It's not a lot of money in the scheme of things for what can be hours and hours of work. That means solicitors are unwilling to represent claimants, and that's a problem because you're then going to have injured claimants, as in fact happens now, unrepresented, dealing with insurance companies who may not use lawyers, but they use very experienced people to deal with you, and that's a problem. You can't have unrepresented people just appearing before these against these insurance companies. It's unfair to them. They don't know what their rights are. As Mr. Davidson said, and as I've said, this is a complex scheme. Now, I'll come back to the costs in a moment, but if you read paragraphs 55 and 56 of the Bar's paper, in May last year, Ernst & Young estimated that the total legal costs for all claims, not just statutory benefits, but for the claims that go to assessors and courts, they estimated the total legal costs for a year would be $274 million. In fact, in the previous 12 months, legal costs have been $95 million. So it was a vast overestimate by Ernst & Young. Of that $95 million, unsurprisingly, 60% were insurers' costs, legal costs. I say unsurprisingly because most of the statutory benefits claims do not have lawyers involved for the claimant. The insurance companies, of course, are entitled to have their own lawyers. So you don't have people turning up with lawyers appearing against insurance companies because lawyers just aren't going to see it as being something that they're going to get properly paid for. The fourth issue the Bar raises is that the Personal Injury Commission, the PIC, be empowered to hear reviews of treatment and care disputes. At the moment, the only way to have a hearing about a review is to go to the Supreme Court and in administrative review. That's an incredibly expensive time. It would be far better, in the Bar's view, for the PIC to have a forum where these reviews, which are dealt with without the presence of the claimant or lawyers, have those reviews, those decisions reviewed in the PIC rather than having to go off to the Supreme Court. They're the four things that the Bar wishes to address, but can I just say one last thing? And I want to talk about costs, and I know you're looking at me and you're going, well, lawyers, of course they're going to talk about costs, this is all in their interests. And it is, I guess. We all get paid for doing what we're doing. But where the fees that are allowed are low, such that lawyers don't see it in their financial interest, in their benefit to take on the case, the claimants are unrepresented. So in matters such as disputes over statutory benefits, reviews of decisions, claimants are not being represented, and in the end, tackling insurance companies on their own. I come back to it, it's unfair. And that's the Bar's view, that it's unfair on the claimants in a scheme that is running at the moment way below the estimated legal costs. The scheme's not costing all that much. And partly, it's going to remain that way whilst ever claimants don't get representation. Thank you.
Excellent.
I will try and limit myself to three things and be brief about them. The first is that it has been extraordinarily busy 12 to 18 months in the motor accident sphere. There has been the statutory review of the scheme, and a lot of work went into that. There has been amending bills put before the Parliament in relation to both the PIC and the motor accident scheme. There's been amendments to the guidelines, and there's another iteration of amendments to the guidelines to come. There have been changes to the regulations. There have been consultations over authorised health practitioners and how they work. It has been an extraordinarily busy time. And I wanted to acknowledge and thank CIRA for their consultative approach over that period. On every single one of the things I've just mentioned, the legal community as a stakeholder, and in our case the ALA as representative of the interests of the injured, have been consulted. We've been shown drafts of bills, we've been shown drafts of guidelines, we've been shown drafts of regulations. We have been consulted consistently throughout, and whilst we've not always agreed on where government policy ought to go, I cannot fault CIRA for their approach to consultation, that I think in fairness reflects the attitude of the Minister. That has been outstanding, and I want to thank Dr. Petrina Casey and her staff for the extent to which they have been willing to listen and to consult, and we would like to think that there have been some better policy outcomes as a consequence. But they have been exemplary in their attitude towards consultation over the vast majority of issues. The second is to reiterate the ALA's support for the totality of the Clayton Utes recommendations. The better part of half of them have been adopted either through guideline changes or the bill that I understand passed the Parliament last night. And again, we had some input into that process, and I'd like to think that the bill that eventually passed was a little the better for it. There remains work undone. There are categories of things that further work needs to be done on, and we've addressed some of those in our submissions to this committee, and we encourage this committee to stay on the task of looking at, well, these things have been recommended, where's CIRA up to with them, and why aren't they being further pursued? And indeed, I think there were even two things, if you run through the CIRA submission, where they've given an update on where they're at to with various of them. I think there were two that they indicated were going to be in the bill that in fact ended up not being in the bill because they were more complex and more time's being taken on them. So we very much encourage this committee to stay on task of looking at how this bill can be further improved, and the journey of injured people through the motor accident scheme can be made better, faster and fairer through the implementations of the Clayton Utes recommendations. The third thing I wanted to address was the PIC, and I do that with some degree of trepidation. We made a submission, we made passing mention of the obvious delays that are occurring within the system, and we ventured the opinion that there's more than one cause for them in terms of it's more than the pandemic. That drew a response from the PIC, the president of the PIC, that ran to some 16 pages. A copy of it, well, it was sent to Mr. Dale, the New South Wales president of the ALA, but it was copied into this committee and much more widely. I assume from that it was intended that this committee take it into account. We have not responded directly to the president, but rather, given that it was supplied to this committee and given that we're before this committee, we thought the appropriate response was to respond to this committee. And in the space of a week, and without the sort of secretariat that the PIC has, and we're a volunteer organisation, we have provided a response that was provided to the committee last night. We have no issue with that response being published on the committee's website. If I was in court, I would seek to tender the document before this before this collection. I'm not sure as to whether I simply ask leave to rely on the submission or simply say you have it and we'd like you to publish it, please. I'll leave others to guide me as to the correct procedure for a late submission. I'm not necessarily sure that today is the day for this committee to debate the relative merits of the arguments in those two pieces of correspondence. There clearly are delays. The cause of them, we've asked for we've raised a whole lot more questions as to the whys to try and get a better understanding of the data and the causes. I think it could well be a topic for the first time this committee meets on its next review in the next Parliament to have a more detailed look at that, perhaps with the opportunity for the PIC registrar or president to come forth and be heard on the subject, just as we would seek to be heard on the subject, preferably with a lot better understanding of some of the data issues that have arisen. We have at all stages sought to engage in good faith, both here and with the PIC. We attend PIC stakeholder meetings. We make our contribution at those. and we seek a continuing constructive role in trying to ensure that motor accident victims have a fair and fast trip through their journey. All we want is for the system to work and work efficiently. Those are my opening comments.
Thank you. And the committee will make a decision shortly about whether those items of correspondence are to be made public or whether they're to be handled as submissions, and we'll be in touch about that. Did you want to kick off, Mr. Longley?
Thank you, Chair. And through you, Chair. Can I return to the point that was just covered? And it has been a basis of some reflection of the committee today and will be later on. And still on the point, can I ask Mr. Davidson, with respect to the Law Society, I understand that Ms. Joanna van der Plaat, the President, was provided with a copy of the correspondence being referred to. Are you aware that that's the case, that she did receive that?
Yes.
Yes. And did she then forward that to you or provide that to you, knowing you will be a witness today?
Yes.
And you've read that piece of correspondence?
Yes.
In terms of that correspondence, and this is a sort of an open question, what do you believe the intention of that correspondence was?
It's a bit difficult for me to comment on the intention of it, I'm sorry. I think the idea behind it is to potentially just provide some insights into what the PIC say the cause of the delays are.
Is it usual for a judge to correspond directly with the Law Society with respect to expressing views about a particular matter which are currently before a parliamentary inquiry?
Not to my knowledge, but I can take that on notice if
you
like.
can take that on notice. Does the Law Society intend to respond to the correspondence from the judge?
Again, I think we were just copied in on it. I think it was more for our information to be aware of it. To my knowledge, it's not the intent to respond to it, no.
Okay, well, I ask you on notice to raise that with the President of the organisation.
Yes.
Mr Turnbull, the same to yourself. The Bar Association, specifically the President, Ms Gabrielle Bashir SC, was CC'd into the correspondence. You're aware of that?
That's my understanding, yes.
Yes. And did she speak to you about that correspondence or provide you with a copy?
She provided me with a copy. She did not speak with me.
And with respect to the provision of that copy, of that correspondence, you've read that correspondence?
I have.
And would you like to express a view about that correspondence and its, and if you believe a purpose behind that correspondence?
Well, I'm not sure I can speak about the purpose behind it, although it seems tolerably plain that the author of the document, Judge Phillips, was seeking to answer criticisms made of the PIC, made, I think, by the ALA. That's my opinion, but I certainly haven't spoken to the author at all. Can I just make one comment, though? You asked Mr. Davidson whether it was usual for a judge to correspond in that regard. I would think the answer is
that's directly with
the Law Society, or perhaps you're going to ask me the same question about the Bar Association. The answer is, my understanding is no, it is not usual, but on the other hand, Judge Phillips is not actually acting as a judge, he's acting as the head of the PIC, and the head of such committees, to my knowledge, it is not unknown for them to contact various stakeholders.
Well, pressing you further on that, I mean, this was a substantial contribution by His Honour, the judge. He was acting, was he not, for and on behalf, with the correspondence on behalf of the Personal Injury Commission in his capacity?
That's correct.
Yes. So he was speaking for the Commission, and that was the purpose of the correspondence, was it not?
I assume so.
Yes. So what other examples can you provide the committee whereby he or others in a similar position where you say are not specifically a judge corresponded in writing in such a way with the Bar Association in regards to a matter?
I can't give you an example of corresponding in writing, but I'm sure they exist. But for example,
Well, on notice, can you please...
I can find that out. I can tell you, though, that the head of NCAT, for example, who I think is a federal court judge from memory, does correspond with stakeholders in the capacity of the head of NCAT. Those sorts of bodies are the heads of those bodies tend to be judges, but not be acting as judges, but acting as the head of the appropriate tribunal which they lead.
Thank you. And I bring you to, of course, Stone, which, of course, if I could put it this way, the centre of, or at least the submission of the ALA is the centre of the correspondence in terms of its purpose and comment and reflection. Can you explain how the correspondence was brought to your attention?
Yes, Mr Dale circulated it to the State Committee of the ALA.
Right. And the correspondence is dated the 10th of November, so I presume that was done and it was probably distributed electronically. And I've got the actual correspondence here, probably on or about that date?
It was last Thursday or Friday.
Last Thursday or Friday. And with respect to its distribution to the said group of people, the committee, was there any comment about it, or was it just circulated for information?
It was circulated with the then discussions within the ALA as to what we would do by way of response to it. And we held a committee meeting on Monday night and had discussions as to what the response should be. Various people worked on the draft response that we got to you as quickly as we could, but that was last night.
And with respect to the provision of the correspondence that was received, discussed at the committee, and you're welcome to comment on the considerations of the committee if you wish to do so. Did the committee form a view about what the purpose of this document was in terms of its distribution, not to just the ALA, but as you're well aware, to a whole range of other stakeholders?
I don't know that it's either appropriate or constructive for me to speculate as to the PIC President's motives and whether they are singular or multiple. I think that's got to be a question for him. It can only be speculation on my part.
Okay. Well, I've got more questions on that matter, but perhaps other colleagues might wish to.
Thank you, Chair.
Roberts.
Let's go to the elephant in the room then, Mr Stone. Your submission, page 4, paragraph 6.
Our original or our supplementary submission?
Your original submission.
Yes, thank you.
And I'll be honest here and say I did receive your late submission last night. Now, I have skim read it this morning, but I haven't had time to absorb it completely because of our workload. But let's go back to the original one, and I'll draw your attention to one particular sentence, and I'd like you to comment and expand on it. I think we'll all find it useful. And that is, the PIC is beset with delays.
Yes.
I'm unaware of that. I'm concerned it's been brought to our attention. I'll give you the opportunity now to expand on it and take it a bit further.
Okay. Let me, in fairness, because I think part of the criticism of our submission by the PIC President was miscommunication over an issue. The biggest challenge has been the pandemic. Readily acknowledged that it for a period of time meant that there were no face-to-face medical assessments, and given that the system is so heavily dependent upon medical assessments, it for periods of time was catastrophically disrupted. Our question is that, and train strikes and flu and floods and behaviour by plaintiffs' lawyers the sole cause of these difficulties, or are there other structural issues which we have identified? And that's why we said that, and in particular the capacity question, are there enough doctors willing to act in the system to meet the demand? And it's very difficult when you get, for example, a reduction in the number of psychiatrists, but the President says, yes, but these people have more capacity. Terrific. The President says, we've added 5 new psychiatrists to the roster, but doesn't at the same time say over the period of the 5 were added, how many have dropped out? Now, if the answer is none, then terrific, we're up 5. If the answer is we've lost 6 over the corresponding period, then major alarm. It's difficult when you're only given half the information to understand the nature and extent of the problem. But the best way I can illustrate the system, as we said, grinding to a halt, is if you have in hard copy available the CIRA submission of 27 September 2022, or can access it. And I'll pause and people tell me either go on or I'll wait while you bring it in front of you. It contains a table as to dispute application and finalisation timeframes.
What page is that, please?
The page, yeah, Mr. Stone.
It's page 25. I'm sorry, I didn't bring multiple copies of the page.
No, we'll have it here. Certainly will.
Yep,
I know
got it.
the Deputy
CIRA
Chair
submission 27 September, page 25, contains a table.
Yes.
We got it.
Yep.
You have it, thank you. And if I can take you down to the third set of boxes on that table, you will see that the number of dispute applications for medical assessments has been, since 2020, has been in the order of 2,000, 3,000, 3,000 per year. And you're then given the number of disputes being finalised, and that's increasing every year. But the final two columns is how long those disputes are taking to finalise. And it's the 26-week finalisation rate and the 52-week finalisation rate. So in 2022, only 26% of medical disputes were being resolved inside of 6 months. And you can see how precipitously those numbers are dropping. And in fact, they drop across every one of the dispute categories. Then in relation to 52 weeks, you can see that there are still 36% of people lodging a medical dispute who don't know the answer to that medical dispute within a year. And that's people where the dispute might be, I need ongoing psychiatric treatment, and that's 12 months that they go without it. Or I have a minor injury, the insurer's asserting a minor injury, and I've been cut off from wage support and treatment support, and I need a minor injury psychiatric dispute determined in order to access wages. Or it's a hold-up in their damages claim because there's a debate about whether they're over the 10% whole person impairment threshold and can access general damages. Now, again, I emphasise, there has been a pandemic. That has made it phenomenally difficult for everybody. But are there any other issues that could be addressed to try and get these numbers looking more healthy? For example, should the doctors in the system be being paid more to encourage more of them to come into it? Is there anything more that can be done to recruit them? What can we do to get back the people that the dud computer system drove out because they just didn't want to deal with it anymore? There's a variety of those questions, and the concern is that we still haven't cleared the backlog of 2021 filings where people who filed in December 2021, if I understand the President correctly, may not have their medical dispute resolved for a year and 3 quarters until the 3rd quarter of next year. And we've cut off the definition of the backlog as being 31 December last year. Is there a new backlog emerging? And again, we just don't know. It might be that there isn't. It might be that they've kept up with filings in 2022, or it might be that there's a new backlog that we don't yet know the size of, where people could be waiting until 2024. And these are some of the issues we've addressed. We don't have clear answers on all of this. We just know that we don't have data that lets us know that everything is under control.
Well, further to that then, I'll put this proposition to you and you can either accept it or reject it. Would it be your assertion then that you want to get to the basis of it and not see the pandemic used as a masquerade to sort of patch over or use as an excuse for maybe faults in the system if they exist? Because I've been critical of ICAC using the pandemic as an excuse for dragging out the deliberation or final reporting things. So would my assertion be correct that you'd like to see the real reason and not just the wholesale answer as, oh, we've had a pandemic and that covers everything?
I want to choose my words carefully.
Certainly.
The pandemic is a real reason. It is a very real reason. And it may account for 100% of the delay, or it may account for 70% of the delay and we're not looking at the other 30%, or it may account for 50% of the delay and we're not looking at the rest. It's hard to know without the additional data that we have identified in our supplementary submission that would drill down into exactly where the delays are. As we've suggested in that submission, it's not that hard to work out, can you meet system capacity, which is you look at, for example, in the field of psychiatry, which was one of the areas where there's been delay, although it should be one of the areas of least delay for one reason, which is it doesn't require a physical examination. It can all be done by AVL. On the other hand, because of the pandemic, there's great demand for psychiatrists, and between us, we can't get a medico-legal examination with a psychiatrist before June next year either. There's real demand problems. But to come back to your question, yes, are there things beyond the pandemic is what we want the answer to. And I was saying the way you do that is you say, all right, on average, we get 100 requests for a psychiatric examination coming in per month. We know there will be a certain non-attendance difficulty rate. That means we in fact need 120 appointments to meet the demand. Have we got psychiatrists willing to make 120 appointments a month available to us? That's basic time and motion study to make sure that you've got the capacity. And again, simply saying we've done 700 appointments this month doesn't answer that question for me, because it doesn't say we needed 800 or we needed 600 and we've got spare capacity. The simple assertion of there's 700 appointments this month doesn't get to the time and motion element. So we're really just trying to ask the questions to better understand the issue. And we thought CIRA's doing a statutory review, but they are not going to get anywhere near that level of detail. And to be blunt, that's not their skill set to do it, which is why our recommendation was from an external management consultant. And to be blunt, if they are operating to maximum efficiency, if everything is working perfectly, then there should be no fear of having an external management consultant have a look at it and say, yep, you've got it nailed, it's perfect, you've got the capacity, you don't need to pay doctors more, you've got enough doctors coming in to cover the doctors dropping out, you've got enough hours available to meet the appointments, and you've got a period of time where the backlog will be cleared, and here's the orderly way of going about it. But at the moment, we can't get an answer to the question of, if I lodge an application today for a psychiatric assessment, or that requires, in a variety of specialities, when will that be listed for determination, and when will I have a certificate? What is the time frame for an application filed today? As in, if I go into the back of the queue, when will I reach the front of the queue? Disneyland can manage that. When you join the back of the queue, you get a sign. I'm 2 hours away. If you walk into the RTA registry, they will tell you, here's your ticket number, here's your ticket number, here's the approximate processing times. Now, of course, what the PIC does is way more complex than those two things. I acknowledge that. That's unfair. But we just can't get an answer on, I'm at the back of the queue, when do I reach the front of the queue? So there's a lot of questions, but in some ways there's a pile of other things I would like this committee to be talking about, and I'd like this to perhaps be the subject of a more detailed study when we all, wishing you all well in forthcoming events when we all come back.
Yeah, I'll just to move away from the PIC for a moment, if I can. I'd probably more to the Bar Association, but I think you mentioned that the whole person impairment currently is between 5 and 10%, and that
sorry, that's not right. At the moment, if you have a neck or back injury that is assessed below 10%, it is nominated as a minor injury, and that limits what you can get, greatly limits what you can get in terms of benefits. The Bar Association's position is that it should move from 10%, the lower limit, down to 5%, so that those between 5 and 10% of who have an injury that is identified under the relevant American Medical Association guidelines, between 5 and 10% can access the greater level of benefits that those who are assessed over 10% get.
And I suppose the question I had was that one issue that we saw with the previous scheme was that there were significant cost increases in the scheme, and the scheme did become quite unaffordable towards the end in terms of premiums. Do you think that by reducing the WPI down to 5%, that it would increase costs significantly to the scheme?
There are two answers to that. Firstly, no. Firstly, no, because it's only going to affect a relatively small number of people, but it's people with serious injuries. Can I just make this comment, though? Number two, one of the big differences between the previous scheme, the Motor Accidents Compensation Act, and the current Act, Motor Accidents Injuries Act, is that under the previous scheme you could get care, you could get damages for care, damages for treatment. That's provided for now in a statutory benefits scheme, and all you can get in common law in that court case is damages for economic loss and non-economic loss, pain and suffering. That has been, as I understand it, a huge cost saving to the scheme. To come back to your question, is lowering the threshold for neck and back injuries from 10% down to 5% going to dramatically increase the cost? No, it won't. And of course, I've already taken you to the figures to show that the costs are far less, about a third, in fact, of what they were predicted to be.
And what about moving from doctors currently making an assessment to the suggestion of, I think you said, a court or a tribunal? Would that, how do you think that would play out in terms of cost to the scheme? I mean, it would increase legal costs, I assume, but reduce medical costs. Any observations on that from a cost perspective?
Yes, it may well increase costs. I wouldn't think dramatically. I mean, not every case is going to have, and in fact most cases will not have a causation argument. But there are a small minority of cases where doctors have to make essentially a legal decision, and that is, was this injury caused by the accident? And there is, in any injury, there's going to be usually a number of factors at play. But as I say, the majority of those matters are not contentious, so there won't be a hearing. The point is, if a claimant wants to, I suppose if an insurer wanted to argue about it, these are standard arguments that are run in any court case involving personal injuries. Issues of causation are dealt with by a court or a judge after hearing argument. No, I don't think it would greatly increase it, because there would not be, it's not every case that's going to occur. In fact, I would think it would be a small minority of cases.
And a question to all witnesses. Do you think that there's any benefit in moving from a third-party scheme to a first-party scheme?
Can I perhaps add something to Mr Turnbull's last answer and then come back to that question?
Yeah.
In terms of causation, to give you the extreme example, an ALA member alerted me to this week a case where a medical assessor had made a decision on causation. It had gone to a review panel. I think that put the person over 10% whole person impairment. The insurer sought a judicial review application. They decided the review panel had not understood causation, set aside the review panel decision and sent the decision back to be made again. The second review panel made a decision contrary to the claimant's interests and said under 10%. The claimant, dissatisfied with the reasons there on causation, went back to the Supreme Court. The Supreme Court set aside the second decision. It went back to what was by then the PIC, now for its third round of panel deliberations on causation. The panel met in April, and 6 months later they are still waiting for the panel decision. Can't blame that 6 months on a pandemic. That's taken 3 years and a vast amount of costs. I strongly suspect a lawyer addressing questions of causation through a relevant chain of appellate mechanisms would have resolved that issue remarkably faster. The PIC president, in his correspondence, supports causation being done in the workers' compensation style legally rather than medically. He compliments the Bar Association on their submission and impliedly or directly criticises the ALA for not being on board with the Bar Association submission. What the president overlooked was that back in 2000, as we've mentioned in our submissions, this is not a new issue. Back in 2010, all three groups at the bar table had recommended to this committee, and this committee had put forward a recommendation that CIRA explore having causation issues decided by a lawyer rather than a doctor. This is not a new issue. Delighted to welcome the PIC to the party in terms of their view on it. The people they're going to have to persuade is CIRA, because it's CIRA who for the last decade have been firmly of the view that causation has to be decided by doctors rather than lawyers. That's where the fault lines on the debate for that are. If I can move forward to first party versus third party, and I may hold a different view from the other two, it's what you have to sacrifice to get to first party. If you're going to pay first party damages to everybody, then you have to double premiums. If you're going to pay, we're currently paying first party statutory benefits now up to 12 months on the basis the scheme can afford it. everywhere you want to expand that, you have to find something else to pay for it, or premiums go up. First party versus third party is ultimately a rationing mechanism. It's that we've got a certain amount of money in the CTP pot that we're prepared to put up with as the price of premiums to the public. And fault is a distribution mechanism. It says we give this group, we preference this group ahead of that group. And I think I've given exactly this evidence to this committee before. The more you expand first party, the more you have to reduce benefits elsewhere. And we say that as a rationing mechanism, that those who are genuinely innocent victims of what has occurred should get prioritised in terms of lump sums for their pain and suffering and a full compensation for their wage loss over those who caused the accidents and were injured in causing an accident. But I fully accept that's a rationing mechanism from a finite pool of money being what we deem people being prepared to pay.
From the Bar Association's point of view, we do not support going to a first-party scheme. It's not something we're putting forward. I agree with Mr. Stone that the fault scheme, if you like, does filter out, and a lot of cases that if you bring them in, it's going to be incredibly expensive. As Mr. Stone says, if you want to have a first-party scheme, you're going to have green slips going through the roof. So it's the Bar Association's position. We do not support it.
I might just add to that. My understanding is that in other parts of the world where there are effectively no-fault schemes, which is what you have with a first-party scheme, that there's a raft of problems that come with it, in addition to reduced benefits for all, problems such as increased fraud and people making claims in those circumstances. So there's, I think, quite a lot of considerations with a first-party no-fault scheme in addition to the overall cost that make it an undesirable model to move to.
Mr. Davison, any observations?
Look, the Law Society hasn't got a current position on it to my knowledge, and I'm happy to take that on notice, but I will say this in my personal capacity, that a first-party scheme comes with a host of problems that particularly from an uninsured liability perspective. So people of lower socioeconomic groups, even in a compulsory scheme, tend to be left uninsured in certain circumstances. So you will see a rise in a first-party scheme of uninsured vehicles simply because in a third-party scheme you've got broader coverage. So I think you just need to be alert to the fact that you will have, whilst we have a nominal defendant scheme now, how that would operate in a first-party scheme could be quite challenging. So just food for thought.
Sure. I had a question. Oh, Mr. Diadam? Yep.
Yeah, look, I just wanted to ask, last year, I think CIRA clawed back $90 million using the TEPL. I wanted to ask the panellists what they thought this reflected in terms of how the scheme is actually operating and whether it's operating as intended.
If I might go first, because we specifically addressed that in our submission, we would dearly love you to ask CIRA this afternoon where the 91 million has come from. Now, the short answer to that is insurer profits, but why? That's profit above the 10% or so of the premium dollar that they're allowed to keep as profits. It's what I've, for the better part of a decade and a half before this committee, been calling super profits. Now, that's come from somewhere. Effectively, the insurers put in a premium filing that contains within it a budget of what they think they're going to have to meet. And that budget has to, first of all, calculate the predicted number of accidents and then has to do a breakdown of costs. So, for every premium dollar, we'll spend X amount on claims handling costs, our 10% for profit, we'll pay X in treatment, we'll pay Y for wage loss, we'll pay Z in damages, we'll pay plaintiffs' lawyers, we'll pay our contribution to the hospital scheme, etc. And there's effectively a budget of where the money goes. So if there's a spare $91 million, and there will be more than 91, that's only their first clawback out of year one. I anticipate that they're into their next TEPL process and there will be further clawback out of year one. Where has it come from? Now, if it's that there were only 8,000 accidents rather than 10,000 accidents, then I've got no more questions. Then that's just, we got accident numbers wrong, that's led to excess profit. On the other hand, if it's that we got, 9,000 accidents and half of it's due to the accident number, but the other half is because we only paid half the amount that we anticipated on treatment expenses, then that raises a whole host of questions, which is, are people accessing the treatment expenses which you thought they would? Why has there been a dramatic drop-off in people accessing treatment expenses? Or if it's, for example, because we budgeted for 5,000 first-party claims for statutory benefits, which was predominantly motorcyclists coming off their motorbikes. There wouldn't be a damages claim, but first-party. And in fact, people aren't taking up their first-party entitlements because those motorcyclists don't want to have to report to police that they've been involved in an accident, which is one of the reporting requirements, or because they don't know that they've got first-party entitlements. So it's trying to find out which parts of the scheme did this money come from to understand, in effect, why has it not been spent where we thought it would be spent.
But is it perhaps not just the case that you're better off, if you're one of the providers, to be overestimating than underestimating, because it's always better to have the money in the bank and have to put it back as opposed to not. So is that perhaps not just a more simple and reasonable explanation as to where the money's come from?
Well, no, that would be saying that in effect they'd built the builders 10% for contingencies into the budget estimates, and we're now clawing back the 10% because in fact everything worked as anticipated. And if that's the answer, then that can be the answer. We've overestimated everything. That may be one of the available answers. Or it may be that accident numbers explain all of it, or it may be that underclaiming explains part of it, or it may be that we've made it so hard for people to access benefits that people aren't accessing the benefits that we intended.
Or it's it's a little bit of everything.
Most likely it will be a combination of all of those things, but you can understand why from our perspective we're deeply concerned if a part of the answer, and a sizable dollar part of the answer, is people not accessing benefits to which they are entitled. Because they're either not aware of those benefits or we've made it too complex and painful for them to access those benefits.
And so if I recall correctly, sorry, and I'm not sure who was questioning.
It was Mr. Diadam.
Oh, apologies. I'll.
It's fine. You can go.
Oh, sorry. Sorry, I get sort of engrossed in these sorts of things. I find it fascinating. But
join me in the nerd club.
I am there with a hat and bells on. In relation to, I guess, the view that it could be any number of those things, and part of it is that perhaps people aren't claiming their statutory benefits. We've heard submissions from everybody at the table about the costs that I think $1,800 you said, which is allowed under the scheme for that legal representation. And I remember, I think last time we had this issue come before us as a committee, there was the point made that, with the money being returned out of the scheme back to, that's not claimed, part of that could be rediverted to increasing that legal representation fee, which would then in turn, I guess, address the point that Mr. Turnbull made, that, you don't actually have a significant enough figure there for a lawyer to want to take the case on, because it's in effect a loss-making exercise for them.
Agreed, and yes.
Yeah, I don't know any lawyer that is going to disagree with increasing the amount of money that's put towards legal costs. But
and I don't know any claimant that wouldn't appreciate and doesn't appreciate the assistance they get from their lawyers to bring their claim.
Yeah, that's, I guess, one way to provide clients with the opportunity to further understand their rights and benefits. Would it be perhaps another way that would be just as beneficial to make the scheme simpler and easier, so that a self-represented person could easily access and understand their rights and benefits, so that they could then approach the scheme and the providers and say, this is X, here's the evidence, this is what I'm entitled to. Is it? I think I've heard, much about how complex the scheme is.
If
maybe
you'd like
it's
to
too
try and make
complex.
it simpler, I think we need 6 months of very smart people sitting down to do it. To give you some idea of the complexity, if you are a small business person who is injured in an accident, then in order to work out your weekly wage loss, which for many small business people is not an easy answer, the insurer has found that sufficiently complex that some insurers don't even try and work out the answer. They immediately bring in forensic accountants to go over the person's books to work out the answer. And of course, whatever the insurer's forensic accountants comes up with as the answer, that person is likely to be disputing that issue on their own if they disagree with the forensic accountant's assessment, because for $1,800 we can't take on forensic accountants to assist them in responding. So that is just how complex day-to-day issues in this scheme become and how quickly they become that complex.
Sorry, if I could just add one thing. That's actually an unpaid dispute. So it's not even
right.
1,800.
Oh, sorry, that's not the 1,800. Yes,
No.
that's nothing.
So lawyers actually do that pro bono effectively at the moment to help injured people out. So there's no...
And sorry, can I just address your question too, member? The answer to your question is yes. It would be great if the scheme was more simple. And I go back, I'm sorry to say, I started the bar in 1983 and I remember a much different scheme. Yes. And it was a simple scheme and people understood their rights and lawyers acted for parties, and if they won, they got paid. If they didn't, they didn't get paid. The scheme now is incredibly complex that requires all sorts of decisions to be made, not as in days of yore when a judge would make a decision, but by doctors, by panels, by that sort of thing. That's the complexity in the scheme. If you could make that less complex, yes, of course, that would be a good thing for claimants, because at the moment I can tell you that lawyers find the scheme difficult to navigate and complex to navigate. Lord knows how a non-legal, a lay person is going to do that.
Yeah, and I think
but the scheme...
Yeah.
I'm sorry to interrupt, but
Come on.
The simple answer is yes, but as Mr Stone said, it's going to take a long time to redesign the scheme and make sure that it remains as cost-effective as it currently is.
Yeah, and I've deliberately put this question, I guess, to the panel of lawyers, legal experts, and people that have skin in the game, because obviously there's a circumstance that I guess a percentage of the income that your members would make would come out of this scheme, but you've obviously made the submission that at the moment the scheme doesn't allow enough for that to be, I guess, a substantial part of the work, and that one solution is to increase that. I guess I'm looking at it as what I think should be and could be a much simpler, fairer scheme might actually be achieved by making it less complex, less legal, more focused on the person, and providing them and enabling them to be able to do a lot of this themselves, to make the system equitable. And I think that's, if there's agreement from this panel that might be, one way to look at it into the future, then I think that's perhaps an endorsement of at least looking at that.
Of course. Can I respectfully say, if it was that simple, we would have done it by now.
And we use the same line.
And can I particularly take you up on simpler is not fairer? The way you make things simple is you are arbitrary. Fairness requires complexity. So, for example, that small business person that I just talked about and trying to calculate their weekly loss, the way you make that simpler is you say everybody gets paid a living wage of $600 a week or $700 a week, and you eliminate looking at their individual circumstances. That's simpler, but it's grossly unfair because that small business goes under, and quite possibly that person loses their family home because they've built a life that doesn't live on $600 a week. So,
but however,
fairness comes at a price.
Yes, but there's also, I guess, a philosophical issue that where a scheme is too complex, fairness only comes through advocacy and legal representation, and that will exclude other people. So that doesn't make it fair either. So I think it's a philosophical argument. I'm just curious as to whether we've perhaps made the scheme so complex, so technical, that that is the barrier to fairness, not the actual representation and making it even more legalistic and representative.
Where we may be looking at different aspects of fairness is there's fairness of process, and fairness of process comes at a cost, and fairness of outcome. And to simplify process almost invariably involves more arbitrary outcomes.
I'm just sorry, Mr. Roberts does have a final question.
Sorry,
because we actually only have 2 minutes left, so we are very much running
I'll
out
make
of
it very
time.
quick.
Yeah.
To you, Mr. Turnbull, in your submission, page 16, recommendation 4, in terms of merit review, I'm very interested in that. Myself, along with the chair, are on the ICAC committee, and we're currently looking at a merit review system for ICAC decisions, and I won't take that any further because that's confidential at this point in time. However, we've heard evidence that to take a merits review of the ICAC, for example, leads you only one course open to you, and that's the Supreme Court, which is daunting for some and very expensive for all.
Indeed.
Can you talk to your recommendation for and why you say that perhaps PIC could do a merits review rather than the Supreme Court, and what the benefit that would be to claimants?
The first thing is that PIC is a far less formal forum. That's going to make it easier for unrepresented litigants, and there are a lot of them in this scheme, to present their argument. Secondly, you would hope, but not necessarily, that it would be a quicker scheme, partly because it is less formalistic. Thirdly, it would be no doubt a much cheaper scheme. Starting from, you don't have to file a summons in the Supreme Court, which costs $2,000 or $3,000. And you could have the scheme such that if the claimant loses, he's not then going to pay, he or she is not going to pay the insurance company's legal costs. Those are all risks in going to the Supreme Court in the administrative division. I've done it many times. There is no certainty of outcome. Claimants are very hesitant to do it, and lawyers say to them, if you lose, this is going to cost you $30,000, $40,000, $50,000. If you do it in the PIC, one would hope it would be like the way assessments are run. They take generally 2 or 3 hours assessments of damages or liability. They generally take 2 or 3 hours in a relatively informal setting, but the plaintiff, the claimant, then gets to see his or her complaint put forward, argued and dealt with. It doesn't need to be the Supreme Court. That's the ideal, but the Supreme Court is expensive, there are time delays and the like.
Might I just add to that a significant problem is the lack of any knowledge of the availability of Supreme Court proceedings. And if there was a process in place that was known to the participants of the scheme and readily accessible, then that would be a significant improvement on an available review that they don't even know about and can't access.
And sorry, can I just add one further thing? If you go to the Supreme Court, you can't argue the merits of the decision. You can only argue there's been legal error. That's, in my view, unsatisfactory. If you go to the PIC, the idea would be to have a review where you could actually attack the merits potentially.
Unfortunately, we have run out of time, but committee members are very welcome to put questions on notice, supplementary questions, should you wish to respond to those, as well as any additional answers you've taken on notice today. I'm not sure, there may have been a couple, that be returned within 21 days, and the Secretariat will contact you in relation to these questions. So thank you so much for joining us.
Thank you for evidence.
So thank you so much for coming today, and sorry to keep you waiting. So I'd now like to welcome our next witnesses. Could each witness, starting from my left, please state their name and position title, and then swear either an oath or an affirmation.
Chris Butel, Chair of the Motor Accident Insurance Scheme Committee at the Insurance Council. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Zoe Wang, Chair of the Claims Managers Association of Committee of the Insurance Council of Australia, CTP Insurers. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Estelle Pearson, Actuarial Advisor to the Insurance Council's CTP Committee. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. And I'd like to invite any of the witnesses to make a short opening statement.
Thank you. I'll make a statement.
Thanks.
Thank you for inviting the Insurance Council of Australia, ICA, to appear at today's hearing. The ICA is the representative body for the general insurance industry, and our members include the 5 insurance groups that underwrite the New South Wales CTP insurance scheme. My name is Chris Butel, and I chair the Motor Accident Injury Scheme Committee at the ICA. And alongside me today, as mentioned, is Zoe Wang, Chair of the New South Wales Claims Managers Committee, and Estelle Pearson. The recent 3-year statutory review of the scheme found that overall, the scheme is meeting its policy objectives as outlined in the Motor Accident Injuries Act 2017. These objectives inform the design of the scheme pursuant to the 2017 reforms, which insurers operationalise to drive optimal health outcomes and recoveries for injured people in motor vehicle accidents in New South Wales. As outlined in the ICA's submission to the Standing Committee and the review, the scheme has realised the objectives of early and ongoing financial support for injured people whilst delivering significant reductions in CTP premiums for the motoring public. We believe that the internal review process facilitates the achievement of several important customer service benefits within the scheme, including access to simple, cost-effective and efficient process to review decisions without the need for legal representation or escalation to the Personal Injury Commission. We note that in the most recent financial year, ending 30 June 2022, 80% of internal review decisions had the initial claim decision affirmed. In its submission to the review, CIRA has put to the Standing Committee that the internal review process resolves nearly a quarter of disagreements between insurers and injured people, thereby removing the need for those injured persons to lodge a dispute in these matters. We confirm our support for the position that ILARs should not be introduced into the scheme in its current form, which both the ICA and CIRA set out in our supplementary submissions to this review. We share CIRA's view that the introduction of ILARs would result in a significant departure from the original scheme design and pose a potentially high risk to the sustainability of the scheme overall. Insurers are committed to the continual improvement in performance and service delivery to ensure the scheme is implemented to meet the best needs of injured people. The ICA appreciates the opportunity to contribute to this 2022 review, and we are happy to answer any questions the committee may have.
Thank you, and that's on behalf of everyone.
Yes.
Thank you for that opening statement. I'll start with a couple of questions, and then I'll hand over to my colleagues. Just to start on a few items raised by the lawyers in the panel just before. I'm not sure if you caught any of their evidence. One suggestion was that the WPI be reduced from 10% down to 5%, in particular for neck and back injuries. And there was a question about potential costs to the scheme that might be added if that was the case. Any thoughts or comments on that particular suggestion from the lawyers?
So there are two separate decisions that are made by insurers in relation to injury severity that do impact entitlements. One is a WPI assessment that provides access to a certain type of common law benefits called non-economic loss. And there's a second decision, which is a minor injury decision, which is a decision that impacts entitlement to statutory benefits. Minor injuries are designed to cover injuries which are expected to resolve within a shorter period of time. The original design of the Act was to have statutory benefits available to people with minor injuries for 26 weeks. That has been amended through the bill last night, and we are supportive of the extension of statutory benefits for people with minor injuries up to 52 weeks, because we believe that this will provide coverage for the small proportion of people who don't recover from those injuries, such as soft tissue injuries, within that 6-month period.
And one of the other issues that was raised was that, which was mentioned in the opening statement as well, but that the PIC be used more effectively rather than going to the Supreme Court. Was wondering if you could make some comments on that as well. Are we using the PIC effectively at the moment, or should it be used in the future?
I don't think that we have a position on PIC versus the Supreme Court, and we're supportive of the process that is in place for escalation of matters from the PIC. I think our opening statement was in relation to internal reviews, which is a review of a decision within the insurer and provides an opportunity for a quick resolution within 28 days at a maximum for the insurer to reconsider a decision that a claimant does not agree with.
And what about the suggestion that at the moment that there's assessments are made between doctors, and that one of the proposals put forward by the lawyers was that potentially it would be better if it was done by a court or a tribunal, rather than the current scenario where doctors make the assessment.
At the moment, my understanding is that medical assessors at the PIC are involved in decisions which require some degree of medical knowledge, so decisions in relation to treatment and care, minor injury assessments, etc., and that lawyers are involved in other types of decisions, or arbitrators are involved in other types of decisions. We have no position at the present that is not working or should be changed, but we do acknowledge that there has been difficulty with access to medical assessors, particularly due to the impact of the pandemic.
And just a final one from me. The Clayton-Utz review that handed down, I think it was 49 recommendations, of which some have been already implemented or in the process of being implemented. Would appreciate your thoughts on those recommendations in a broad sense. Not, obviously you don't have time to go through one by one, but any things that you particularly welcome or things that you're particularly opposed to that came out of that review.
Yeah, I think generally we're supportive of the outcomes of that review and the government's response to the outcomes of that review, including what's included in CIRA's submission as to their response to various recommendations. And we'll continue to work with CIRA and other stakeholders on the implementation of various aspects of that review.
Questions from committee members?
Yep. My colleague Mr. Adams got in. I did have one. I just have to.
I might start then.
Yep.
I wanted to ask about.
Yep. Go on. Please proceed. Yep. I've got one now. Yep. Go on.
About the operation of TEPL, and I don't know whether you heard the earlier evidence in relation to Mr. Stone's assessment of how TEPL is operating. I just invite the panel to make comments about this perception that the premiums are being set too high, necessitating the invoking of TEPL and the recovery, the clawback of super profits.
Yeah, I think it's important to recognise that when premiums were set for the new scheme in 2017, it was an entirely new scheme. There was no experience to base premiums on. So all the numbers of the premiums, about the numbers of claimants, what sorts of benefits they'd be entitled to, what their average benefit payments would be, were all estimates and based on quite a lot of actuarial judgment. So it shouldn't really be anticipated that the actual costs would the actual costs being inconsistent, or in this case lower than what was estimated, isn't really a reflection of conservatism. It's a reflection of the uncertainties in those original estimates. The TEPL was put in place to, I guess, ensure that should the estimates be proved to be too conservative, then insurer profits would be capped at 10%, and that's how that is operating. I think it's more important when looking at the scheme and how the scheme's performing is it meeting its objectives in terms of, is it affordable, is it efficient, are injured people getting treatment and care and weekly benefits in a prompt fashion.
So is it fair to say that as the scheme matures, that you expect that the clawback will be less and less?
The clawback will be each year will be impacted by the specifically what occurs for that year. I think what I can say is that as the experience has matured, the premiums do reflect now more the actual experience of the scheme. However, we have been hit with things like lockdowns, which have reduced the number of vehicles on the road, and so things like that will happen and impact outcomes as well.
Okay, thank you. I'll hand back to my colleague.
Thank you, and thank you for your two submissions. Just a couple of areas before I pass on to colleagues. With respect to Sarah's submission to the inquiry, and you may or may not have access to it. I'm sorry, had no notice I was going to ask you this question, but in any event, there stands as submission number 3 to the inquiry, and specifically on page 25 of Sarah's submission number 3, there's a table which is called table number 9, or cited as table number 9. And it contains various headings. I don't know whether Mr. Burrell, you've got that submission there or have access to it. Sarah's submission number 3 to the inquiry, or at least, thank you, one of the committee secretariat will just lend you a copy. Can I take you down the left-hand column? Starts at total. Can take down to medical assessment, and then if we move across, you've got first of all the years in chronological order, and then 1 column, 2 column, 3 columns, and the third column after the years says the percentage of finalised disputes finalised within 26 weeks since application, and the immediate next column says the percentage of finalised disputes finalised within 52 weeks since application. And you'll see, let's deal first of all with the 26 weeks. If we take 2018 as the baseline start year, you'll see the figures dropping, in fact dropping precipitously, whereby you go from 100% down to 26%. And then in the next column, what I would also argue is quite a precipitous decline from the baseline 100% to 64%. Now, this obviously ties directly back to one of the comments that you made in I think responding to one of the earliest questions about the processing efficiently and it's taking into all relevant considerations for the determination of a matter. Can you respond to those two columns, and specifically your view about reasoning, if you can, or reasons, or give us insights into why you believe those percentages are what they are, and perhaps in some sense, more importantly, your thoughts about how they could be significantly improved quickly.
So these disputes in that table relate to disputes at either the DRS or now the Personal Injury Commission. They're not referring to the internal reviews that are undertaken by insurers, and I'd draw your attention to page 27 of CIRA's submission, where they talk about internal review timeliness, which insurers have control over.
Right.
And that if you look at the fourth row from the bottom there, 98.3% of disputes are completed within timeframes by insurers in the 12 months to 30 June this year, and those timelines are different by dispute type, but are 14, 21 or 28 days. So quite timely disputes, 98% of them done within timeframe.
So just jumping back to table number 9 then, your submission is that they're not relevant really to
Not saying they're not relevant. I'm saying that we understand that the Personal Injury Commission has been impacted by the COVID lockdowns, unable to do face-to-face medical assessments, and that's what's driven that decline in dispute timeframes that are done through the Personal Injury Commission.
But in terms of the impact on the individuals affected, which results obviously in the delay, I mean, that you surely would have to acknowledge that has significant implications for those individuals.
It's certainly not ideal that individuals have to wait that long for their dispute to get resolved.
Well, let me be even more blunt and challenge you to say that less than ideal is a little bit qualified, is it not? I mean, it's quite serious, these delays. I mean, being frank about it, is that not the case? For the individuals affected and looking at the scheme meeting what are our expectations.
I agree it's not a great outcome for the individuals involved, but as you're aware, with the COVID lockdowns, unfortunately, things did get delayed through the Personal Injury Commission. And
well, to the extent that you attribute those results to COVID, I mean, would it be reasonable to say that there could be other factors contributing to the
I think
results
that there are a number of reasons for the delays. The Personal Injury Commission has provided us with updates to talk through the strategies that they're using to work through the backlog. We believe that they have made some progress with working through the backlog, and we would support and participate in any initiatives that the PIC has to work through that backlog more quickly.
So what are the update? What update are you specifically referring to? You just mentioned that update from the PIC.
The Personal Injury Commission has met with us to assure us that they are working through the backlog.
When did they do that?
The backlog is coming down.
I'd
have to take that question on notice in terms of the precise date.
And on notice, can you provide the committee with a copy of those guidelines?
This was a verbal update that was provided by Judge Phillips.
Right.
I don't have any written guidelines, I'm afraid.
So, in fact, there were no guidelines provided. This was your assessment that what he was saying were a guide to, how the thing would be managed better. Is that the case?
Yes.
So there were no guidelines provided.
I would have to take that question on notice.
Right. So were you actually at that meeting with the judge, with the president?
I was in attendance at a meeting online. I haven't been in attendance at all meetings.
No, that wasn't my question. At the meeting where, in the first instance, you said the guidelines, which we now think may not be guidelines, in the discussions with the president, were you present at that meeting?
I have been present at a meeting where the judge has provided us with information that he is attempting to work through backlog at the Personal Injury
And with
Commission.
respect to the information, is that notated somewhere? Was notes taken of that meeting?
I would have to take that on notice. There were no notes taken by myself.
Okay. Well, on notice, can you discover whether notes were taken and on notice provide them to the committee? Can I ask you also this, that with respect to what got delivered as reflections or comments or suggestions or an overview or information, however you might like to form it, by the President to the organisation, was there a request or a suggestion that this explanation of his should be circulated more widely, or was this directed to yourselves as the big organisation?
Sorry, can you repeat the question?
Did the judge intend for this discussion to be with yourselves directly, or something that you would then communicate more broadly to your membership?
This was a discussion with insurers. It was not a discussion specifically with myself. My understanding is that Judge Phillips does engage with stakeholders within the industry, including insurers.
I'm talking about this meeting that you attended, that you've just described, and the judge, the President, was giving you the information and what have you. Were any other insurers or individual insurers there in attendance?
I believe so, yes.
Yeah. Well, I noticed if you can provide us with a list of those insurers. Was this a meeting that you sought to convene, or the President sought to convene?
I believe it was convened by Judge Phillips.
Right. And just time's running out, but when did this take place approximately? This year?
Yes, it was this year.
Yeah. Can you give us an approximate, a month?
I would have to take that question on notice.
Okay. My time is expired. I've got more questions, but might have to pass on.
Mr. Roberts, no. Mr. Fang?
Probably not as narrow a focus, but probably a wider focus. And I don't know if you caught some of the earlier sessions where we were questioning some of the other panels, but I put to the legal panel that was just prior to your appearance that where they've indicated that the scheme is complex, that the scheme would the complexity is largely legal, that applicants would benefit from more legal representation, particularly in the initial stages, and that the sum available for legal representation isn't sufficient to significantly motivate enough legal representatives to actually take on those cases, because it's in effect a zero-sum gain, or in effect some cases a loss, they said, given the amount of work that's required. Is that the experience that you would have with the cases that you've, I guess, had some sight on? And do you have a view as to, one, the complexity, two, early legal representation for claims, and three, what those costs could potentially, what those costs should perhaps be?
So we believe that the scheme is working as intended at the moment. There is no doubt that there are some aspects of the scheme that are complex, and we would welcome any consultation in terms of streamlining or simplifying the scheme without impacting the fairness of the scheme. Mm-hmm. Over 96% of claims are accepted in terms of the first liability decision, and that means that people have access to treatment and care and income support from the time that the claim is lodged. We support the principles of that CIRA is using to review legal costs in the scheme, and would support any implementation of changes that come through that review of legal representation.
Okay.
I might just add to that and I think it was in Sarah's submission, that I think it's quite a high proportion, maybe in the 70% of people actually start receiving treatment and care before they've even lodged a claim.
Yep.
And I think it's up to 95% within 4 weeks. So the scheme by its design was intended not to have early legal representation, because for the vast majority of claims there shouldn't be that complexity, and people should be able to navigate the scheme, get access to benefits early, etc. And the stats that come out show that is actually occurring in the vast majority of cases.
And so I think, in a way, I was playing devil's advocate with the question, which is why I was trying to frame it in a certain way, because I think I would say I would advocate for a simpler system, which I know, Ms. Wang, that's exactly what you sort of alluded to, that you'd be happy to engage in seeking to where we could streamline and simplify the scheme. So I guess this is this divergent path from this point where legal representatives are saying that they need a higher rate or a greater lump sum in order to provide legal advice earlier, which, again, devil's advocate, that's what they're going to say. That's their bread and butter. On the flip side of that is that, whether somebody who has suffered, an injury should be able to navigate, for the most part, it themselves. Now, you've said that there's 96% of claims that are accepted initially, and then the point that they've made to that is that there's quite a large sum of money that's being, the super profits, to use the ALA's term, is coming back because they're not being spent. Now, in that instance, the legal panel prior to you said that is an indicator that people aren't receiving the benefits that they are entitled to. So where it's a case that 96% of people are accepted in the first instance, whilst not all costs are the same, and I understand probably the 4% that aren't initially accepted are probably the really complex ones that are probably also really expensive. If there's 96% of people being accepted into the scheme, but there is still money that's coming back that's not covered by the profit calculations within the scheme, are people who are initially accepted not accessing their full entitlements? And if so, why not? Because I can only see that is the outcome of where these two divergent paths are. That if there's 96% of people being initially accepted, but there's a lot of money coming back, they're not accessing everything.
So maybe I'll try and put a couple of answers to that. So, as I said at the outset, the original premiums were set, they were estimates. There was no experience to base them on what entitlements, how much entitlements people would have under the scheme. But the fact is that all the claimants who are accepted have almost immediate access to reasonable treatment and care, and we see that a lot of them get access to that very quickly and to weekly benefits. But everything was always just an estimate based on sort of an old scheme that was entirely different to the current scheme. So the fact that the numbers are different to what was estimated, I don't think you can't assert from that people aren't getting what they're entitled to. So the 96% of people who are accepted in the scheme should be getting what they're entitled to under the scheme in terms of treatment and care and weeklies. There's several different processes where they can raise concerns. So there's the internal review process, and I think about 20% of internal reviews are overturned in favour of the disputing party, whether they're legally represented or not. So I think that's an indication that there's a a process that works for people without representation. And then obviously if they're still not satisfied, they then move on to the external dispute resolution process. I did also want to make a comment about the numbers in the Bar Association's submission about comparing the annual legal cost with the legal costs spent in a year. And I'm not sure that it's quite an apples with apples comparison. It might be a question best put to CIRA, because I know it was their actuaries who came up with the total. But the important thing to know is that about 35% of all statutory benefit claims have legal representation, about 65% of non-minor claims do, and 90% of damages claims do. Now, even in the first year of the scheme, there's less than half of the total damages claims have been paid out yet. Therefore, the annual cost of legals will keep going up as the scheme matures. So I think maybe that comparison that the Bar Association did was not quite apples with apples, and maybe isn't a full explanation or a proper explanation of, where does the $91 million come from?
I think that's partly where, again, playing devil's advocate, I sort of put to them that perhaps it was a case that the overs that are coming back to the scheme are in fact just over. I mean, if you're going to provide an estimate, you would typically overestimate than underestimate, and so I think that was potentially one of those factors, but also that. In the case where I think they said it was about $90-something million of legal fees, where the statutory review said 270 million odd, so about three times as much as what was estimated. It's the fact that that the cases aren't mature yet, and so they're not actually seeing the full legal impact of the scheme under a standard load as we progress into the future.
I would agree. And one other thing is I can also let the committee know is that we have seen on statutory benefits a year-on-year increase in the average amount of statutory benefit payments. And we see that is due to a greater proportion of claimants utilising treatment and care benefits every year that are available under the scheme, and also we see some increase also in the utilisation of weekly benefits. So it may also be the case that, as people get more used to the scheme, people will utilise more of the benefits that are available. In the meantime, the TEPL provides a guarantee that to the extent that they don't utilise all the benefits that they can, that money doesn't go to insurers' profits, it gets returned to motorists.
Thank you. I think I've had a good crack, but I'll pass back.
Just a sort of broad question. How would you rate the performance of the current scheme, and how would you compare it to the previous scheme before the reforms came in, prior to 2017?
So I think we've already touched on some of these points earlier, but the new scheme is getting benefits to injured people far quicker than the old scheme. We're seeing the timeliness of both treatment and care and weekly income benefits greatly quicker in the new scheme. What we're also seeing is where there is a decision, we didn't have internal review in the old scheme, so where there is a decision that has been made by an insurer that our claimant disagrees with, there is that fast avenue to seek resolution where there is a disagreement.
I think we're also seeing one of the concerns with the previous scheme was the efficiency, so that the amount of the premium dollar going to the injured person. And I believe in CIRA's submission they've identified currently, or their current measure for the first year of the scheme is that it's 59 cents in the dollar compared with 44 cents in the dollar in the previous scheme. So I don't know exactly what makes up the other part. That would be a question for CIRA, but there has been a strong improvement in efficiency. Of course, the other thing that we were seeing in the previous scheme was a big escalation in the number of claims every year, despite a falling number of road accidents, and leading to the ultimate conclusion that there was fraud and unmeritorious claims in the system.
And any observations, or maybe if you could provide a few comments on the ILAR's aspect of the review as well. I know you've put some of that in your submission, but maybe if you wanted to talk to that, because that's the other part of the review that the committee needs to look at. And then I'll hand to Mr. Donnelly. Yeah.
As we said in our submission, the ICA does not support the extension of ILARs to CTP claims dispute resolution, as it could result in more complex adversarial and drawn-out processes as proceedings become more formal and legalistic, which we believe is contrary to the purpose of the reforms and the objects of the Motor Accident Insurance Act.
Thank you, Chair. Through you, Chair. So effectively, we've got two organisations represented here. We've got the ICA and we've got Affinity Consulting. Is that right? There's two separate organisations. Affinity sort of consults directly with the ICA.
We are appearing here as the Insurance Council today.
Okay, no, that's fine. That's fine. On the 10th of November this year, a piece of correspondence under the name of the President of the Personal Injury Commission, quite a lengthy piece of correspondence, was circulated. It was a piece of correspondence seeking to address some matters that had been raised by a submitter to the inquiry, addressing and seeking to explain or respond to some of the items that had been raised. I'm wondering, and it was, as I said, issued under the name of the President of the Personal Injury Commission. Did the ICA, or first of all, did yourselves actually receive that piece of correspondence electronically or otherwise that you're aware of?
We haven't seen that piece of correspondence.
You haven't seen that piece of correspondence. Can I, on notice, get you to just, so take this on notice, can you check to actually see whether the ICA itself, organisationally, did receive a copy of that correspondence, perhaps the CEO, and provide detail of the date upon which that was responded to? And thirdly, on notice, whether or not there was any response given by the ICA to the President of the Commission. So just take that on notice. Thanks.
Yeah, we'd certainly be happy to take that on notice.
Thank you.
Any further last questions? We're pretty much right on time. If not, thank you so much for appearing today and for your evidence. Committee members may have additional questions for you after the hearing. The committee has resolved that the answers to these, along with any answers to questions taken on notice, be returned within 21 days, and the Secretariat will contact you in relation to these questions. Thanks so much for your attendance today.
Thank you.
I'd like to welcome our next witnesses. Could each witness, starting with you, Mr. Harding, please state your name and position title and then swear either an oath or affirmation.
Thank you. Richard Harding, Chief Executive Officer for iCare. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Dr. Alsop.
Nick Alsop, Group Executive Lifetime Schemes at iCare. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. And would you like to make a short opening statement, Mr. Harding?
We would, if that's all right. Just a nice short one. Thank the committee for the opportunity to appear today. iCare welcomes the chance to offer our observations to help ensure that the Lifetime Care Scheme remains fit for purpose and comprehensively supports those who unfortunately find themselves as participants in the scheme. Lifetime Care is performing well and provides important quality of life outcomes for around 1,740 people across New South Wales. The scheme has continued to grow, largely as expected. And throughout that growth, we have focused on the continuity of service, financial sustainability, and remaining agile and responsive to people's requirements and needs. This is a complex space. Participants come to us after challenging and life-changing journeys. They require a range of services and support, from equipment and living modifications, physical and psychotherapy, vocational and educational assistance, exercise therapy, and of course, most significantly, attendant care. With this in mind, we strive to ensure that the complexities of the scheme are simplified such that obtaining support is not another hurdle for people to overcome. As service provider for the Lifetime Care and Support Scheme, iCare understands the importance of our role in providing empathetic, inclusive and accessible individualised support. We ensure every participant has an individual point of contact to help them design a tailored program based on their specific life goals. We are proud of the fact that respondents of the most recent Lifetime Care Participant Survey observed how the assistance they had received through the scheme contributes so significantly to the quality of life. From a financial perspective, the scheme is sound. However, we continue to manage inflationary and market pressures consistent with similar schemes around the country. Attendant care costs, which account for about 70% of the scheme's expenditure, as well as competitive tension in the care provider workforce, are matters we are watching closely. iCare is also pleased that the Compulsory Third Party CTP Care program will commence in December. The open and collaborative approach between the State Insurance Regulatory Authority, CTP insurers and ourselves should lead to a smooth transfer process for participants from the existing private sector CTP scheme to the new CTP Care program. However, we note that the risks borne by the scheme's infancy and the associated uncertainty around its cost base. Levy collection is the sole revenue source for this program, having received no seed funding at its establishment. For that reason, it will be critical to quickly develop a comprehensive data set around the type of injuries, complexity, duration, the number of clients, to ensure the future sustainability and success of the scheme. I again thank the committee and look forward to taking your questions.
Just had a question about the relationship between CTP and lifetime care. Are there any issues or tension between when someone moves from the CTP scheme to the lifetime care scheme, or at what threshold someone would need to reach in terms of the severity of the injury between CTP and lifetime care?
Dr. Alsop answer this.
If I may. Great question, thank you. And I guess the short answer would be there is generally not a lot of tension in that. It doesn't, I'm not saying it doesn't happen, but in the main, the nature of the injuries that are required to get into lifetime care are fairly well defined and well specified. So the majority of the participants that enter the scheme do so after passing through one of the brain or spinal units around New South Wales. So it's fairly clear the nature of the injury and the lifelong impact of that injury on that participant when they are transitioning out of that institution into the support of lifetime care. There are cases where there is some question around whether or not the participant meets the threshold for inclusion in lifetime care. These tend to be on the moderate brain injury side of the spectrum, but they are usually well resolved with appropriate clinical guidance and don't generally result in conflict. There is a 2-year period in which people entering the lifetime care scheme are treated as interim participants, because it can take a number of months or even years for injuries to stabilise. So during that interim period, people are assessed, and when they reach the end of that 2 years, a lifetime eligibility decision is then made. And then they either remain in the scheme in perpetuity from that point, or would transition back to the CTP Care insurer. One of the great things with the advent of CTP Care is that for those people who will have a lifelong treatment and care need but may not meet the eligibility criteria to stay in lifetime care, they now have the opportunity through an early by agreement arrangement that we have with CTP insurers to remain under the guidance or supervision and support of iCare through the CTP Care scheme, to avoid them having that experience of being part of lifetime care, then bouncing back to their CTP insurer, and then coming back into CTP Care at the 5-year point. So this provides greater continuity of support for these people and a more seamless experience in terms of not having those multiple transitions.
So it's sort of something in between. It's not really lifetime care. It's not really CTP. It sort of fits in between the two schemes in many ways.
It picks up that cohort of people whose injuries are severe enough to warrant ongoing treatment and care after 5 years, but aren't severe enough to end up in lifetime care. So it's a great initiative in terms of providing people that support in terms of their ongoing health-related needs beyond that 5-year point, and in some cases where it's agreed earlier than that, rather than the old CTP scheme where a lump sum was provided and people were essentially left to fend for themselves through the health system to try and understand their needs, obviously in conjunction with their GP, but without that sort of expertise that CTP Care can provide to support them in accessing those services.
Other issue I was interested in was the relationship between workers' compensation and CTP / lifetime care. Probably just more for the committee's benefit, if you could explain how it works in terms of someone that's in a vehicle for work. Do they fit with the workers' compensation scheme? Do they sit with the CTP scheme? I know there are sometimes times where one scheme might be viewed to be more generous than the other, and there is a bit of a tension between an injury at work versus an injury in a vehicle. Just for probably more background or context for the committee, if you could give some provide some thoughts on that.
Yeah. From a lifetime care perspective, it's usually fairly self-evident how the injury's arisen. One of the other great initiatives that iCare has put in place is what we call the Workers' Care Program. So this is where somebody sustains a workplace injury that is of a similar nature to the injuries that get into lifetime care. They're provided support in a similar structure, obviously allowing for the slight differences in the legislation, but the same sort of case management approach, the same support structures that we offer people in lifetime care are offered to those catastrophically injured in the workplace as well. So from a treatment and care perspective, people are offered that same level of support regardless of whether the injury was a road injury or a workplace injury. Richard, did you want to add anything?
No. Yes. Questions from committee members?
Well, I'll just go first. Well,
Yep.
I see my colleague scribbling notes there, so I'll give him a chance to catch up.
Thanks, mate.
Thank you both for attending, first off. Draw your attention to your submission, probably page 5 and 6 would be the pertinent parts. I have questions about the funding ratio for the lifetime care scheme. What's the current position at the moment?
So as at 30 June, the economic funding ratio, I think, was 110% from memory.
And if I'm reading that right, Dr. Alsop, we're now into what you classify as Zone B.
So that the capital management policy is based on the insurance ratio rather than the economic funding ratio to take out some of that volatility that arises and that you see in those graphs in our submission that comes purely from interest rate movements. So the insurance ratio is the basis of our capital management policy, and our target there is 140%. We are sitting below that at the moment. The latest information I have is that we're at about 133%, which is below where we'd like to be, but not so far below that it's a risk to the financial security of the scheme. But it's obviously something that we do want to address over time to ensure that we are in Zone A of our capital management policy.
Well, to that further then, in your submission, it says management action plans to return the insurance ratio to Zone A are in place. What are those plans?
So the thing about lifetime care is that it is set up to provide treatment and support for people with lifelong injuries. What we don't want to do ever is compromise that in any way. So that removes the ability or the option of changing benefits or reducing services to people in terms of ensuring the financial sustainability of the scheme. We also invest the levy income and assets of the scheme to ensure a robust return over a long period of time to make sure that, again, the burden on road users of the state is minimised through that investment income. So we have a fairly aggressive investment approach there. We do target returns over the long term because we believe that is in the best interests of motorists and the scheme in general. So there's not an option to change investment strategy materially to address that gap relative to the target in the capital management policy. So that really leaves expenses and levies as the two options that we can look at. As an organisation, iCare is constantly reviewing its expenses and looking for ways to provide services more efficiently and more effectively. So we are keeping those as lean as possible. But in the short term, our option really is to move the levy to address that gap in the capital management policy and the associated insurance ratio. Now, we don't want to do that aggressively. We want to take a long-term approach to doing that. So we have put a sustainability margin into the latest levy request that we have filed with CIRA. And the intent of that is to address that funding gap, or that gap between the current insurance ratio and the target position in the capital management plan over a period of 10 years. So as I say, we're not looking to do this as a shock impact onto motorists. We're looking to do it gradually over a period of time while we monitor investment markets as well, because we may see returns improve, and that may give us some comfort that we will get back above that 140% target faster than we anticipate. So we review those levies on at least an annual basis, and we're in the process of committing to CIRA to go back to them every 6 months with updates on how we're tracking relative to the capital management plan as well.
So you say, and I'll just put this in layman's terms because none of us here are insurance actuaries, we need to move the levy. I'm assuming the levy is the money you receive from CTP premiums.
Correct. The levy is added to the cost of CTP premiums, yes.
So the management action plan then that you have is to increase the levy?
To ensure services to injured participants in the scheme are not compromised, yes, that's correct.
What other strategies have you got other than bump up the levy?
So the challenge with the lifetime care scheme is that although it only has 1,700 participants in it, it's very expensive to support those people.
We understand that, Mr. Alsop, and that is not in dispute.
Yep.
And I take that you said that you don't want to reduce services either. No one wants that, right? So the only strategy that you're telling me at the moment, though, to balance the books, if you'll have it, is to increase the levy.
Perhaps if I can help, Mr. Roberts.
Please, Mr. Harding, because we really need some help to understand this.
Well,
because let's be honest, going forward, we talk about we're going to watch our investment returns. Well, as far as I can see, there's no sun on the horizon for investment returns for the next year or two at least.
Well, exactly, which is to Dr. Alsop's point about the fact that we take a very long-term view of this scheme, right? The participants in this scheme are there for life, for the rest of their life. A lot of them come in quite young, and we collect a premium up front, which is, the premium accounts for probably about, let's call it roughly 20% of what their needs are, and the rest is earned over the period through that investment return. So the investment return is fundamental to the sustainability of the scheme, but also the provision of the services. What Dr. Alsop was trying to say, so in other forums I've talked about there being 4 basic levers for us to pull on any scheme. You know, we can manage claims, so reduce benefits or tighten up availability of benefits, or get more effective at managing claims. We can change investment returns or change investment exposures. We just talked about that. We can manage our own costs, which in this case account for quite a small portion of the overall pie. But we are always, as Dr. Alsop said, we are always focused on managing our own costs and keeping those as low as possible. And the last...
That doesn't include building Imaginariums, though?
Absolutely. Well, it's a slight distraction from your question, but...
Well, not really.
One example...
Not really at all.
The Imaginarium at the moment is being replaced with a dust screening facility for dust disease.
Much better spending of people's money.
Exactly. And in doing that, we're saving the cost of close to $3 million of rent that we were paying down in Pitt Street. So we are focused on those sorts of costs and finding better ways.
Probably perhaps because this committee's raised that in the past.
Well, I think it's about our focus as a management team. We always
there was no focus before.
We always appreciate the input from the committee, Mr. Roberts. Don't dispute that, and we always are looking for ideas and help to think about it, how we can improve what we do.
And with that comment, Mr. Mookie will come bounding through the door shortly.
I'm surprised he's not here.
But the fundamental focus is keep our costs as low as we can without impacting services, because as Dr. Alsop's pointed out, the fundamental thing here is we want to get those services to the injured people. And that largely leaves the last lever, which is premiums, right? And lifetime care premiums, so from 2011 to 2023, they've gone from $82 to $87, roughly. We can round up the cents. So in that time, it's quite a small increase that we've talked about over those 13, 14 years or 12 years. So that is the current option we've got to address what is a shortfall in the funding ratio driven by, as you've pointed out, short-term economic impacts to the scheme. We're hopeful that the economic impacts will recover over time, and as that does recover, we will review the need for the premium sustainability margin. And that's the goal, right? We'll always review our cost base, and we're always working to make sure we get the services to injured people in the best form we can. So I hope that creates a bit more clarity.
Not really. Let me just put this to you then. In your own document, you say management action plans to return the insurance ratio to Zone A are in place.
Yes.
You've told me basically, and I'll use my words, and correct me if I'm wrong, that you've trimmed the fat out of your system.
Yeah.
You don't want to reduce services to the end user,
That's
understandably so, because bearing in mind that's your role. So then the management action plan that's in place, the only management action plan that's in place, is to perhaps increase levies.
Well, that's pretty much the options. There are four,
I know. Well, let's just stop
parts
there.
to this that
Well,
we can...
why then do you tell us that we have management action plans in place?
Well,
why don't you just specify in your document and be upfront and say the only way that we can do this is to increase levies?
Well, I think we have later in that document.
On the questions asked in advance, we have provided that clarification, but when we submitted the original submission, we were still in the process of discussing the levy impact and response with CIRA. So we didn't want to provide information that perhaps was inaccurate due to the ongoing nature of those discussions.
I think the key message that we'd like to for you to take away is this isn't a knee-jerk, the investment markets have gone down, so therefore we're hiking up levies. We're very conscious of not putting additional pressure into the CTP premium pool. That is about us taking a long-term view and making sure that those sustainability margins reflect that and that we continually review it. So the management action plan is actually our focus on our own costs, our focus on the investment markets and how the returns from T Corp are travelling and what we can do there to continue to improve those or drive better outcomes from those. How we can work with CIRA to manage the levy impacts, and that means in the short term a small increase to that, but spread over the 10 years to create a sustainable outcome. Our goal here is to balance all those things together, right? This is not a either or. We can't have our cake and eat it too. We want to try and make sure we're balancing across all four of the elements that we're trying to manage to get the best outcome for the injured person. We've got to keep the premiums affordable. We've got to keep the benefits realistic and achievable. And how we manage the money in between to achieve those things is the key.
It's critical.
Outcome. Critical.
But
I'll leave it at that point. Thanks.
on the sort of similar point, but the main driver behind the levy needing to be increased surely is the increasing costs to catastrophically injured people. I would assume. I mean, we've seen the NDIS costs, for instance, spiraling out of control. The levy has gone up by about $6 or something in the last 5 years. But I assume the drive is mainly the increase in health costs or care that would need to be provided.
Absolutely. So as I stated in the opening remarks, and Dr. Alsop can talk to this in more detail, but over 70% of the costs of the scheme are the attendant care costs, the costs of having an individual look after somebody, help them do their activities of daily living, help them achieve their life goals in a very personal way, a personal carer. And those costs have gone up, as you've pointed out, Chair, resulting from the NDIS and its pressures in the system. So the NDIS is the main acquirer in the marketplace of attendant care services. But it's also impacted by the recent changes around aged care and the proposals from government around aged care, because they are all similar capabilities and resources that go to service the aged care services, disability services, and attendant carers. And that's in my opening remarks, I made the point that we were watching that because it is 70% of the cost base. And we have seen, we normally budget for around about a 4% increase in the cost of that year to year. In the last year, I think Dr. Alsop is 9%, roughly. So that's where the pressure absolutely is coming from.
I think Mr. Donnelly on a new line of questioning.
Yes, thank you, and through your chair, thank you both gentlemen for coming on today. As you're aware, the inquiries we conduct have a broad remit in terms of its or their responsibilities in terms of the supervision of the operation of the insurance and compensation schemes in New South Wales. So accordingly, I'd like to go down this line of questioning, and I'm doing so just to be very clear, to get some absolute clarity and certainty about a particular issue that received some ventilation in the Parliament this week, and specifically, Mr. Harding, the matter of your remuneration increase.
Well, Chair, I'll take a point of order at that point. I would just seek to refer members to the terms of reference.
Yep.
And note that this, yeah, well, it's not within the terms of reference. I have the terms of reference here in front of me. So that in accordance with Section 27 of the State Insurance and Care Governance Act 2015, the Standing Committee on Law and Justice be designated as the Legislative Council Committee to supervise the operation of the insurance and compensation schemes established under the New South Wales Workers' Compensation and Motor Accidents legislation, which includes the Workers' Compensation Scheme, Workers' Compensation Dust Disease Scheme, Motor Accident Scheme, Motor Accidents Lifetime Care and Support Scheme. In exercising its supervisory functions outlined in paragraph 1, the committee does not have the authority to investigate a particular compensation claim and must report to the House at least once every 2 years in relation to the scheme. Those are the terms of reference.
Correct,
now, in relation to remuneration of members, I would argue...
Not members.
Executive of...
Yeah, but not members. So for Hansard's clarity, we're talking about members, we're talking about executive officers, yeah.
Sorry, yes. The members appearing before us in this panel, I should
the CEO,
for clarity, yes. I would argue that whilst salacious, perhaps, it is not a function of the terms of reference for this inquiry, and therefore the question should be ruled out of order.
Well, Adam, to the point of order.
Well, I mean, it's quite clear that the CEO and their salary is a component of the administration of the scheme. If we'd accepted that logic, then the whole inquiry around our last workers' compensation inquiry, where we delved into the administration of iCare, would have been outside the terms of reference, and clearly it wasn't. It was clearly appropriate because that's a component of the scheme's administration.
I will
further to the point of order.
Mr. Roberts, to the point of order.
I don't know, Mr. Donnelly's big and ugly enough to look after himself, but this fits clearly within the terms of reference. We've just heard from the witness saying that that the scheme is doing everything it can to reduce costs. Mr. Donnelly's alluding to an increase in costs, and I think it's well within the terms of reference when we're looking at the operation of the scheme. And the operation of the scheme comes from internal costs inside iCare.
Mr. Donnelly.
Well, let's be very clear. I mean, the Honourable Member Norris Fang has quoted the terms of reference. That's exactly what I referred to when I commenced my comments as a preamble. And it provides to deal with, this is the remit of this inquiry, this committee, with respect to these inquiries, for the Legislative Council Committee to supervise the operation of the insurance and compensation schemes established under New South Wales, etc. Now, the question is perfectly within order. This is to do with the supervision of the scheme, and it cannot be reasonably argued in my submission that questions over remuneration fall outside matters to do with the supervision of the scheme. We're talking about nothing short of the Chief Executive Officer, who ultimately is at the pointy end, the top end of the supervision of the scheme.
So I think that based on the previous line of questioning, administration costs or the drivers behind the costs of the scheme, that the question is in order as executive rem is a component of the costs to the scheme, albeit a very, very minor part, I would assume, of the cost to the scheme. That is, as in lifetime care, not CTP. So the question is in order, but I will refer the member to the terms of reference.
No, I'm grateful. And Mr. Harding, to be clear, and I don't want this to be misunderstood, this is to just get some clarity over something that's been ventilated both inside the Parliament and outside the Parliament over the course of the week. Now, you're well familiar with the attention it's received. I presume that is the case. You're aware of the way in which the matter of, let me put it this way, your increase has been explained by the Minister?
Look, I'm not in gross detail, but...
Okay. Yep. Well, I'm referring to what is the answer, one of the answers given by the Minister on Tuesday this week during question time in the Legislative Council. And I'll quote directly from it, just so you're clear about what the Minister said. And this was actually a multiple question, and he dealt with it sequentially in parts. He said that in relation to the first part of the question, the board advised me that the package, that is the package for yourself and the others who received an increase, but specifically this is focused on yourself, available to the CEO was, and this is the language he used, a recalibration of the remuneration framework for yourself and the executives. Now, the term recalibration was not further explained by the Minister. We were sort of left to, dare I say, draw our own conclusions about what recalibration means. But presumably, and if I'm wrong, please correct me, that your package, and indeed that of others at the executive level, involved a fixed component part, let's call it your salary, and a bonus component. Now, the recalibration that we understand that what it meant was that there was money, a notional amount. Obviously, the increase was $246,000 or thereabouts, $247,000 thereabout. That access to that amount in the bonus presumably was removed for you and added to your salary. That's the way I understand recalibration. I mean, it was an ability for you to access more in salary by recalibrating bonuses available payable to you. Now, is that a fair explanation of what the word recalibration would mean to a reasonable person? Or if that's not the case, can you explain what you would describe did happen with what was the configuration of your package, which involved salary and bonus?
Look, whether I would use the word recalibration or not, I think is irrelevant. The minister's made an attempt during question time to explain the changes to the overall remuneration structure for executives at iCare, not just for myself.
Indeed.
The gist of what you're saying is largely correct. What I would just highlight for you is that perhaps what the minister's getting at, though, is the total available through the incentive program was significantly more, almost double, what was then attributed to our fixed salaries as the change in outcome. So the board looked at this in a very detailed way. They took independent advice. It's an appropriate thing for the board to do, and it was one of the recommendations from the McDougall review that the board should consider the remuneration structure for iCare executives. McDougall found that the remuneration structures for iCare executives at that time were not inconsistent and were in fact below those of similar public sector and certainly far below private sector executives running similar size and complexity of businesses. The work that we do at iCare is, as we've just talked about with Mr. Roberts, it is fundamentally important. It's not just the nominal insurer issue. Lifetime care, looking after 1,740 critically injured people and making sure we get their services, the investment of over $8 billion worth of lifetime care money.
I don't want to interrupt, but the minister went through all of that last Tuesday in the House.
Yep.
Yeah.
I think it just goes to over 80% of the workforce that we're talking about here, the executive workforce, comes from the private sector. We want to attract the best people to do those jobs, and we need to have competitive remuneration. The board has taken advice, and the board's made the decision to balance that out with the notion that iCare is a government agency and that we have a different approach to that than the private sector. Removed some of the bonus and attributed the remainder to our fixed salary so that we have no longer access to the incentive program that was there before, and as a result, the base salaries have increased.
So just to be clear, that the bonus arrangement that existed, that we're talking about in the first instance, has now been completely separated, and it's not available to yourself.
Not available to anyone at iCare. No, there is no executive who will be earning a bonus,
right?
And no executive earned a bonus for the last 3 years.
Now, with respect to the bonus scheme, what was that bonus scheme?
Well, it's different for different levels of executive.
Right. And what was yours?
Well, mine was up to 50% of my fixed remuneration.
Right.
Which is about comparable with other,
which is very similar.
Major
perhaps
insurers.
if I share with you, for the benefit, Mr. Donnelly, of some of the challenges of retaining staff and competing in this marketplace. An example of an executive who recently left.
I've got limited time, sir, and what I'm doing is I'm being very precise, and I do understand that this is not an easy line of questioning. I appreciate that for obvious reasons, but I'm trying to get to...
I'll just add the point of order that Mr. Harding is seeking to clarify some of the the evidence that he's providing. I understand there is limited time. However, in the circumstances that we are not actually, I would say, addressing the wider issue of how we are going to manage CTP and lifetime care, that we're focused on the man's salary, he at least be given the opportunity to clarify that evidence, given that he has come here to provide evidence around, like I said, lifetime care and CTP. We're asking him about what bonuses he received.
This has already been ruled on.
There's no point of order, Chair. Let's move on.
You're just trying to waste time.
Mr. Donnelly, I will let you continue with your line of questioning. If other members, to Mr. Fang's point, if other members of the committee want to ask different questions regarding the lifetime care and support scheme, let me know and I'll give you the call. But
I just thought that was sort of the focus of and why we're here today, not his, not Mr. Harding's salary. But I mean, if that's what members.
Well, look, we haven't agreed on fixed time for each member. We're having a free flowing approach at the moment. Mr. Donnelly is questioning about salary and bonuses, which I'll hand back to him on. But Mr. Fang, if you wanted to,
I would like to,
given the
limited
limited time,
I would like to focus on the things that are important to the people in New South Wales, which is how the scheme's operating and what we're going to do into the future.
You'll get your time to ask questions.
I'll hand to you next, Mr. Fang, and Mr. Donnelly, if you've got another
thank
question
you.
or two, and then just to spread it around, then I'll hand over to.
Well, I just lost about 5 minutes, but with respect, which was the purpose of all that, with respect to then the what is effective now the removal of the bonus available to yourself and executives, how was the figure then of 246,000, 247,000? How was that figure calculated as an amount? Because presumably what we're dealing with, and I thought it was actually a removal of an element of notional value from the bonus across into dollars to be paid to yourself and other executive members, and a figure was determined. Thank you, you've clarified it now, the bonuses are no longer available, but it still beggars the question, the figure of $247,000, how did that figure get created?
Well, Mr. Donnelly, I've mentioned earlier the board, and really this is a conversation that I would recommend you have with the chairman of the board, because I think that's where the decisions are made for this.
No, I do understand that, yes.
The board took advice, and I've explained earlier that this is about balancing our ability to compete in the marketplace for highly skilled capability to manage a very complex business that does important work for the New South Wales community.
We understand
we service over 3 million
Mr. Harding,
workers.
I think the question was directed to how the figure was arrived at, not the context of the consideration
I
of the
will
board.
get there,
It's
Mr. Diadam.
basically a matter of fact that we're seeking to elucidate here.
I
So if
will
you
get
could
there,
perhaps
Mr.
direct
Diadam,
your
if you let me
answer to
finish.
Yep. Please continue.
So, my point was the work that we do, and the work that we do servicing the people of New South Wales is important, but it is also complex in nature.
We understand that.
And we're talking about actuaries, accountants, underwriters, lawyers, doctors. We're
We
not
understand
talking
that.
about clerks. The board took advice, and it's about balancing up the need to compete in the marketplace to attract and retain that highly skilled capability, and to meet the expectations from a public sector point of view and of the community of New South Wales. And that is how the board, I believe, has made that decision. If you want more detail, I wasn't there at the time when the board made the decision to strike the conversion rate, and you'll need to talk to the chairman to get to the bottom of that.
You personally, as a CEO, have no idea about how that dollar figure was struck. Is that your answer?
So the basis of it, Mr. Donnelly, I have communicated to you, the board sought advice about achieving a balance.
I'm
And
asking
that
you the
is
question.
a decision that the board made. I wasn't in the room.
You've already said that, yes, I know. Yeah.
But you must know,
But
Mr.
the
Harding,
question
you must
I'm
know where
asking
the
you
figure
very
comes from.
directly is...
Oh, point of order. There's two people talking. Hansard can't record that. I just asked one member to have the call, and one member to put a question to the witnesses. It's not fair to have all of this
Mr.
tag
Donnelly
teaming.
currently is questioning the witnesses, And we'll soon move on to Mr. Fang and Mr. Diadam, who
mean
haven't
move on to the
contributed
things that are
yet.
important to the people of New South Wales?
And they will have their turn, and we are running out of time. So, Mr. Donnelly, maybe if this is your last question.
Well, I'll ask it again. It's a very direct question to you, Mr. Harding, and I think you would understand how direct I am being, that with respect to the figure of $247,000, whatever it is, that you do not know, were not told, not informed about, first of all, the figure that was going to come your way, if I could sort of use that vernacular. You weren't aware of that in advance of the board making its final decision, number one. And number two, you don't know how that figure was struck. So there's two parts to the question.
So I can say, in respect to your first question, absolutely not. So the chairman and the committee that reviewed this process and made recommendations to the board excluded me from that process quite early on. I did provide some advice to the board at a very early stage, and then we decided that there was a clear conflict of interest in that conversation. So I was asked to abstain out of the room, and the board made its own deliberations with advice from the external provider. And what that conversation was, to part B of your question, and about reaching the decision to get to a particular level of conversion from the gross entitlement of the bonus to the net increase in the fixed remuneration. I don't have that information. That's information you have to talk to the chair about in terms of the deliberations the board went through. I'm not sure what exactly it is you're looking for, Mr. Donnelly. Is it you're looking for the conversion rate? I can tell you the conversion rate.
Yeah, please do.
But that's irrelevant without the context.
Well, the conversion rate, as I understand it, is that the essential expunging of what was the then payable bonus to zero, or the reduction of it to zero, to dispense with it, had a notional figure attached to value which got converted to an increase for yourself and the other executive.
Yes.
My question is, with respect to this value figure that was struck of $247,000, I'm trying to establish how that got calculated and what was the basis of that as a conversion of the bonus.
So I can tell you that I think we've actually provided it in our media statement on our website, that the increase equated to 60% of someone's entitlement under their performance incentive plan. How that was determined by the board is a question for the board. I wasn't in the room at the time, and it was totally appropriate that I wasn't in the room at the time. The basis of it was, as I said to you, the board took advice from an external party, Gurdon's, who provided them with a significant assessment of market rates relative to different roles across the organisation. The board took advice and made that decision. About as much as I can tell you.
I'll just conclude on this as an observation, or as a question. I would have thought, for a person of your experience and background, the actual idea of, as I understood your earlier answer, you presenting at an initial meeting of the board a document or a proposition or a statement or an explanation about conversion or the increase that you would receive, and that discussion, which was at that first preliminary meeting, is quite an extraordinary thing to happen. That at a board level, a CEO puts presumably a document, correct me if I'm not right, a document on the table which is laying out a proposition with respect to the calculation of what their salary increase would be.
Well, that wasn't the proposition I was putting forward.
Right. That didn't happen at the first meeting.
No, as I said to you, I attended the first meeting, and I provided the board with advice about the strategic issues that I saw of retaining people and driving the performance of the organisation. iCare, as we know from history, Mr. Roberts raised the issue of the McDougall Review. I've talked about the McDougall Review in respect to this issue. We know that there is an improvement to be done here, and we have a very large transformation program going on across the organisation. The ability for us to execute that transformation program is heavily reliant on our ability to attract the right people and to get the best people to iCare. That was my advice to the board, and in that conversation we talked about the relative strategic value of incentives versus fixed remuneration. It wasn't in a conversation of X% or Y%. It was the broader conversation, and that's why when the board moved to have those conversations, I was logically excluded from those, which is entirely appropriate. So maybe I've mischaracterised it in my earlier comments, but that's the nature of that engagement.
Maybe what would be useful is that we have a table with, given we look at the CTP and the lifetime care and support scheme in this inquiry, that the different insurers, whether it's IAG, Suncorp, QBE, Allianz, and then iCare, who looks after the lifetime care and support scheme, we categorise in the table the base salary and the bonuses of each of the different CEOs, so you can see the comparison.
Well, I don't think that's a fair comparison,
I
Chair,
thought-
because let me put this to you, Mr. Harding. Incentives are not a good thing to have at iCare because nobody ever meets the targets. The KPIs are never met. The return to work things, all these targets that iCare have are never met. The financially going down a black hole into a gurgle, right? It's just an abyss that you're standing on the edge looking of. That's why nobody wants incentives, because you never meet them. And tell me this, you brought up, we compete against the private sector. If you're the CEO of a private sector insurance company,
which I have been in the past, Mr.
Yeah,
Roberts,
you have been in the past, no doubt. Answerable to shareholders.
Yes.
And we are the shareholders. We act on behalf of the shareholders in New South Wales. If you didn't meet your KPIs in a private enterprise and it was going backwards on a financial basis, how long would you be the CEO for?
Look, I reject the characterisations you've made about the current state of play at whether it's the nominal insurer or whether it's lifetime care. What I would say, and what I've earlier said to Mr. Donnelly, is there is work to do at iCare. We've been on a program of change.
Why are we concerned, though?
Well,
bearing in mind
can
the
I finish
history
my
of iCare.
answer, maybe? There is work to do. So I'm not suggesting to you there isn't work to do. You know, there is a reform program that we have in place. We have 157 recommendations from Mr. McDougall that we are midstream implementing. That is a 3 to 4 year program of work, and we're into it about 18 months. So there's a lot of work going on at iCare to improve outcomes. But none of these schemes are short-term in nature. To fix a motor insurance scheme in a private insurer is around about a 12 to 18-month period of time because it is a short-tail business. To fix a long-tail business like workers' compensation or lifetime care, you have to take a long-term view. The average duration of these claims is 4 to 8 years. It isn't going to turn around in 1 year. And I've had that conversation with Mr. Mookie a number of times. This has to be viewed as the worst outcome that I could provide to you and to the community of New South Wales is to make a whole bunch of knee-jerk reactions in year one, increase rates and premiums, reduce the amount of claims benefits that people are receiving, and then tell you it's all right. Because that isn't what the job is. The job is about balancing the needs of the people of New South Wales to be there to provide them with the services that they crucially need. People who are injured in workplaces or injured in motor vehicle accidents, as Dr. Allsop's team look after, they are vulnerable people who need help, and all of the people at iCare are there to do that work. We have to improve how we do it. We have to make that more effective. But to make knee-jerk changes in that environment will not serve the people of New South Wales. We have to take a long-term perspective of this change process and recognise that it will take us time to get there. Your conversation about whether I should or shouldn't be paid is a conversation to be had. Is a conversation to be had with the board. No one at iCare has received a bonus for the last 3 years. No one at iCare will receive a bonus going forward. However, you do want the board, as they have done, to make a very strategic decision about structuring the ongoing and forward remuneration of the organisation to make sure we keep the best people there and that we attract people who want to help deliver those valuable and extraordinarily important services to the vulnerable people in our community. And I think that is what's being missed at the moment. The purpose here is fundamental.
I'm going to hand to Mr. Fang, who's been incredibly patient. Wes?
I'm renowned for my patience, Chair. And just before I do go to some questions, I'll just provide you the opportunity to clarify two things. Mr. Harding, Could you advise who the chair of the board is?
I think everybody knows Mr. Fang, but the chair of the board is Mr. John Robertson.
And he's a well-associated member of the Liberal National Party, is that right?
I think Mr. Fang, you will know, he's a former member of the Labor Party.
Oh, that's right. He was a leader of the State Labor Party, is that right? So
The reality is, I would recommend if the community want to understand this issue in more detail, that the best person to talk to is the chairman of the board, because that's where the decision is made, and that is the entirely appropriate place for the decision to be made.
I guess what I'm alluding to is that this isn't a political decision, is it? The person that made the decision around your salary is a former leader of the Labor Party.
100% agree with you, Mr. Fang. It's not a political decision. It's, as I was just trying to relay to Mr. Roberts, this is about ensuring iCare has the best people available, ongoing in the future, to continue the transformation that we've got underway and to ensure it's successful. We all of us want the same thing, ultimately, the people sitting in this room and the people of New South Wales. We want a set of schemes, whether it's the nominal insurer, whether it's the lifetime care scheme, the dust disease care scheme, the other 8 schemes that iCare operates on behalf of the New South Wales Government. We want all of those schemes to be operating well and delivering valuable services to people who need it day in and day out in their life.
Right. Having provided you the opportunity to clarify those points, let's move to the substance of why we're here today, which in your instance would be the lifetime care scheme. And
can I just take a point of order?
Yes, Mr. Donnelly.
The reference to political decision, which was in the members' exchange
a couple of minutes ago, but yes.
Yeah, no, a couple of minutes ago. I don't believe that that's understood by the witness. He was led through a series of questions, and the phrase "political decision" was dropped in. It was never explained what political decision meant. So I think what we have a real prospect before us is the witness responding to a question where the underpinning point about political decision was never explained, or it was left to his own.
I think you're going to have to explain to me what I meant by political decision, given that you're putting so much emphasis on it.
No.
What I was doing.
No, I haven't finished my point of order.
Oh, okay.
So the issue of my questions were nothing to do with political decision.
Of course
they were
not.
matters of fact.
Of course.
So to impugn, there was dropping into the line of questions political decision as part of my prosecution of my questions. I think it's highly problematic, and the witness has been led down the merry path about a political decision when in fact the questions were matters of fact.
Can I make a point to the point of order? Yeah. By the very nature of the fact that I said it is not a political decision, indicates that I'm saying it was not political. So whatever Mr. Donnelly is seeking to imply by using the term political decision, what I am saying is that my indication that it was not a political decision, that it was an independent decision, devoid of politics, would render Mr. Donnelly's point of order mute.
I don't think any of you were saying that it was a political decision. I think you were asserting that it was not a political
That's exactly
decision.
what I'm saying.
Mr. Harding agreed that it was not a political decision.
Which is exactly what I'm saying.
Donnelly was never said it was a political decision.
So
you're all sort of in fierce agreement with each other. Anyway, I don't
understand why my time has been wasted the way that it has.
Look, there's no point of order. Mr. Fang, continue with your line of questioning.
Gentlemen. Back to the lifetime care scheme, and obviously we've spoken about some of the challenges that exist in a long tail scheme, and I know that at previous hearings we heard about some of those challenges, and perhaps that the nominal insurer who had taken on the nominal insurer cases wasn't best geared to to take on some of those long tail cases. Could you provide some insight as to how, moving forward, long tail schemes are managed, will be managed, and what you see as the future of those lifetime care cases that will be before iCare into the future, and how perhaps those costs can be amortised without leading to large premium increases in the short term.
Thank you for the question. Great to be able to talk about the future of the scheme, because you're absolutely right. Lifetime care, being such a long-term scheme, will continue to grow for at least another decade before it even begins to hit a steady state. So while we have 1,700 participants in the scheme at the moment, that number will double or potentially even triple before it gets to a stable position. So it's absolutely critical that we look at how those services are provided. At the moment, what we deliver is a very bespoke service. So we do a lot of individual one-on-one planning with participants of the scheme to make sure we understand their life goals, what their situation and circumstances are like, how much support they have around them, so that we can provide the right levels of assistance to achieve maximum quality of life for them and improve their rehabilitation prospects post-injury. What we need to do is make sure that we're set up to do that in a scalable and sustainable way going forward as the scheme continues to grow. So to that end, we're investing in or examining technology and how that's emerging. So, for example, we've seen some great work that Royal Rehab's doing around assistive technology. And we're looking at how we potentially leverage some of that for our participants, how we trial it in our participant groups, so that we are providing more personal empowerment and reducing that reliance on support workers or attendant care potentially in the future, especially given the constraints that we're facing in that market. We're looking at the attendant care market itself, how we better support providers in that market. So we know it's demanding work, we know it attracts a certain cohort of people who are prepared to do the work, but they struggle to remain in that workforce because of the pressures of it. It can be difficult to deal with people who have challenging behaviours as a result of their injury. So what support can we provide for the employees of these attendant care organisations from a mental health perspective, from a wellbeing and resilience perspective, that will hopefully allow them to remain in the workforce longer, doing the work that they're passionate about and find so rewarding. Alongside that, it's how we encourage people into that career path. So are there different training or accreditation opportunities that can be pursued? Are people even aware of it as a career path? As the nature of work changes and we move more towards personal services being the career growth opportunities, how do we make people aware of the rewards of providing support work and encourage them into those occupations? Sorry, I interrupted.
Oh, no, I was just listening to your answer, and I guess there would have to be some level of modelling or assumptions made that the scheme as it currently is presented to us will improve as it goes on. What are those assumptions? What is it that you're relying on for that scheme to improve its financial position into the future? Is it the scalability? Is it the ability to amortise costs over a greater number of participants? Is it that there will be efficiency dividends that will be found into the future? There must be some of those assumptions. What are those assumptions, and what are the risks to those assumptions? Because let's be honest, in the long time that I've been dealing with, insurance issues with this committee, I've come to the conclusion that sometimes the assumptions are exactly that, and that they have a large variability. So what are your assumptions? What are the risks to those assumptions?
Yeah. So we're very cautious about the assumptions we make, especially around lifetime care, because the scheme is deeply committed to providing the services that people who are participants of the scheme need. We're conscious of not assuming that we're going to be able to reduce those services at any point in the future. In fact, if anything, they potentially expand. So where we are making assumptions is around how much digitisation of our own work processes we can do, how much we can strip out the manual support that goes behind the providing of those services, thereby enabling people to provide that face-to-face support that the participants of the scheme need and get value from. So
Can I just jump in there though? That didn't work well last time, did it? That you tried automating some of the systems.
So we're very cognizant of the need to do this in a way that will work for the participants of the scheme.
Yep.
So when you're dealing with people who potentially have cognitive challenges as a result of brain injury,
yep,
providing them with an app to better manage their time or their appointments and things like that may not be the best option. So we're looking at how we can provide self-management services or self-service options
yep,
that will work for our participants of the scheme.
Yep.
But some of our back office processes we know we can improve, and some of it is just about the actual process itself. It doesn't need to be systems or technology based, but we can continue to make improvements there, and we're absolutely looking to do that. And we've baked those into our budgets, our forward-looking budgets, as assumptions.
Okay. What would be the fallback position if you're not able to achieve those efficiency dividends that that you're banking on? Like, is there a plan B?
There's always a plan B, absolutely. It's a person-based plan B. So if we can't achieve those efficiencies, then it will require more people to support the injured participants in the scheme. Because again, the last thing we will ever do is compromise the service provided. So if we need more people, we will get more people.
I guess the question I was asking though was that if you're not able to find the efficiencies, which will have a flow-on effect to the costs, what's the plan B in relation to managing the costs of the scheme into the future if you're not able to rely on the assumptions that you've made in order to bring the scheme, I guess, more into line into the future? Is there a plan B for that aspect of it?
So the first and foremost, as I said, is ensuring that we provide those services to injured people. Once we've worked out the cost of that, then the cost of delivery of that will be a function of our ability to do that efficiently and effectively. But ultimately, all of that cost has to be funded through the levies.
Yep.
So should the need arise.
Perhaps if I can jump in.
Yep.
And I think these are the sorts of questions that we have a conversation with our board during our planning processes and trying to understand, right? And from a management perspective, our goal is we set ourselves assumptions, as you've pointed out, or targets around improvements in the outcomes, whether that's cost outcomes or outcomes for individuals, participants in the scheme. Naturally, as the world evolves through time, because we are talking, I've made the point that these are long-term schemes, we also see technology evolve, and we also see application of technology through the health sector increasing. One of the examples that I think is relevant is the monitoring capabilities. Now, I mean, most people now have an Apple Watch that can tell them about their heart rate, etc. For a lot of the people in the lifetime schemes, we can look to the technology of the future to help support them with their needs, helping create ways for that they can be more independent. The monitoring services and devices are actually critical in that for a lot of these people in terms of thinking about timing for medication, standards of blood pressure and so forth, other issues. So I think the outcome here is that we're always looking for ways that we can use technology better, whether it's in our back office to remove manual processes and automate that. And you've made a reference to the history of iCare there in terms of our ability to automate it. Well, I can tell you that we are already automating it. We've just done an incredible amount of work to launch and to make the CTP Care capability available, and that was done on time and on budget by Dr. Alsop's team, and it's a real role model for us internally as to how we want to run programs to enable us to make sure we do deliver on those changes. So I think there's an ongoing process here, that's what I'm trying to get at, of continually refining what we do to meet those assumptions. It's not about giving up on those assumptions, it's about refining the options that we've got in front of us every time we look at it.
I'm going to go to a point that the Honourable Rod Roberts made during his questioning, which was that you talk about management, I guess, options looking forward into the cost for the scheme, but also that, in effect, when you're looking at this scheme, I'm a simple bloke, and I see that this is a pretty simple operation. If costs are going up, there's only two ways you can really manage that. That you put the premiums up, or you reduce the costs to the scheme to make everything in equilibrium. Now, you've talked about the assumptions that are going to help improve the bottom line moving forward. Have you made assumptions around costs increasing for certain things? For example, given that it is a long tail scheme with a long period of operation where participants are obviously involved for years, decades, etc. Where there are advances in medicine, and in the same way you've spoken about technology advancing the opportunity to provide cost savings, the technology improvements that we'll see in medicine will no doubt ultimately result in participants living longer, participants living, accessing the scheme for longer, and therefore increasing the cost, but also that those technologies will cost more to keep those people alive. So it's a double impact. What assumptions have you made around the increasing cost of the scheme? Not just and how do you factor those in?
Yeah. And you asked a question before about risks, so I'll touch on that as well. But you're absolutely right. People are living longer, which is a wonderful thing, and people with catastrophic injuries are also living longer, which is also a wonderful thing. Now, that is allowed for by our actuaries in their modelling of the scheme, so they do make an allowance for life expectancy because the modelling is done at an almost individual level because of the bespoke nature of the injuries and the support required. So that is factored in. You asked about whether or not we allow for medical advancements and technology and things like that. Unfortunately, that's incredibly difficult to do. So the answer is no, it's not allowed for explicitly until we see evidence that it's having effect. But it can go both ways as well. You mentioned the cost of some of that technology. Absolutely, it could be very expensive when it first rolls out. But if the impact is it reduces people's reliance on, say, attendant care support, and that's 70% of the cost of the scheme currently, we may actually see a cost benefit from it. But what's most important is that people get the right support and they get the right quality of life outcomes aligned with their goals and things like that. So if we have a participant who's particularly keen on testing out equipment and things like that, we look for ways to do that under the legislation. Yeah. And if we can find a way, we'll certainly help them to do that. But one of those key risks that I think needs to be called out is the attendant care cost pressure. We're 2% of that market, but it's 70% of our cost base. So we don't set the price there. So all those pressures that Mr. Harding talked about in terms of the rising rates paid to workers in the aged care sector that may lure people out of the disability sector, the challenges with not having as many overseas students come in who used to fill a lot of those roles. So we've got a real supply side crunch happening. Mm-hmm. The expanding reach of NDIS and their need for workers for the participants of their scheme all creates a real risk point for us, and it's something that we're closely monitoring and provides sleepless nights for myself, certainly.
We only have 5 minutes left, and I know Mr. Diadam and Mr. Martin have a couple of questions each. So,
do you mind, Anthony? I've just got one to pick up there on Mr. Allsop's last answer given.
Yeah.
You just mentioned Mr.
Nice to
Allsop.
leave me some time.
Okay, I will. I'll go. You just mentioned Mr. Allsop about the NDIS and the struggles with lifetime care. Do you mind just expanding a bit more on the relationship between the NDIS and lifetime care? The struggles as you just started to touch on.
So I wouldn't characterise it as a struggle between us. Sure. They are a large consumer of resources in the same market that we operate in, and so there is that natural challenge that we face in terms of making sure that we get the support workers we need and the engagement that we need for our participants. But we do collaborate with NDIS. We have almost 140 participants that are in both our scheme and the NDIS. So we talk about those individual participants on a regular basis to make sure that they're getting the right support from each of the two schemes. In the main, they get most of their support from lifetime care and support scheme. But the NDIS does help them with recreational travel and other aspects that aren't covered under the lifetime care scheme. So we're in regular discussion around that. We also collaborate around things like the attendant care market and the challenges that we're facing there. So we are having ongoing discussions about what we can each do to improve the number of workers and the quality of the workforce there.
Thank you. Look, I should probably hand over.
Yeah, Mr. Diadam, sorry to leave you only
Thank you.
4 minutes.
Mr. Harding, did you receive the letter sent by Judge Phillips from the Personal Injury Commission in response to the ALA submission to this inquiry?
I did, Mr. Diadam, but I unfortunately don't have it with me, but let's try and...
I'm sure they're not
That's
gonna
right.
ask
Did
you
you
about
read
the
it?
details of it. I'm sure they're going to ask you some
Yes.
You did. Okay, that's good. And so what was your understanding of why you were CC'd into it?
Well, I believe the judge wanted to make sure we were aware of his points of view in respect to the issues that have been raised by the ALA.
And so do you have a view about the ALA's contentions around delays in the dispute resolution side of the PIC's work?
Look, we have found that the PIC has operated very effectively in what has been a very challenging environment for them in terms of the COVID issues that prevail there. And there's been a lot of work that they've done to deal with that backlog. And my understanding is they've largely addressed that. There is some outstanding work to be done. And we generally find that the processes that work there from a workers' compensation point of view work extremely well, and that people get their outcomes in a very constructive way. So I don't really have much more to say on the ALA's point of view.
Okay, look, I might just quickly, because I've only got a few minutes left, ask about the attendant care issue. I understand the contracts for the panel of attendant care providers is up for renewal. How many providers are there currently on the panel?
I'm going to let Dr. Alsop answer that.
Yeah. So I think we have, and don't quote me on the exact number, around 80 members of the existing panel. But you're absolutely right. We're going through a tender process to engage a new panel of providers, and the level of interest has been above that current provider number.
And just in terms of the spread, how many workers are engaged by those 80 providers? What are we talking about in terms of the numbers of?
I'd have to take the exact sort of number on notice, and to tell the truth, I'm not sure we actually have that. But we've got some very large providers in there, the likes of Southern Cross, and some very small providers on the panel as well. So it ranges in terms of the number of support workers in each of their organisations. But I can have a look and see if we have the figure, but we may not have an exact number.
So is it fair to say that the sort of 5 largest providers would represent perhaps 80% or so of the attendant care workers, or is it more distributed than that?
Yeah, it's a little bit difficult to quote an exact figure, and it will depend whether you're looking
On
at...
notice, if you could provide that data, that'd be useful.
Certainly from...
Just in terms of the spread.
In perspective for
I
our
wanted
participants, yes.
wanted to ask about, because in your submission you cite the issues around the increases in the Social Community Home Care and Disability Services Industry Award as being a factor that's placing pressure on other providers of attendant care. You make a qualification that because your funding model is different, that's not as much of a concern for the lifetime care scheme. Why is that?
So I think the reference we're making there is the minimum hours of support and the split shift requirements in the award. So some of the changes to the award recently have required that people where they're providing a single hour of attendant care bill that essentially as 2 hours. because most of our programs, or a lot of our programs, are quite large in terms of the support provided, that's less of an issue for us than it might be, say, for the NDIS, where they may have a broader spectrum of people with different injuries who may require different levels of support. So they may have more of those short blocks of time than we do in our programs. The other component was around the split shifts. So where you've got a worker that comes in the morning to support somebody with the start of their day and then comes back in the evening and supports them again at the end of their day. That's now structured differently, almost to the point where some of the workers have to be employed by different agencies to be able to provide both of those shifts without incurring significant additional cost. And again, for us, because we are set up to fund people based on their needs, that's exactly what we'll do. The difference, I guess, between us and the NDIS is many of the participants of the NDIS receive a package of funding and then have to source their own workers. So this is creating additional complexity for them and challenge in terms of how far that package of funding goes. Whereas we don't have those same
That's not
challenges.
the case then. Right. So in terms of the participants in the
Last
scheme,
question, Mr.
they
Deanna.
don't
Sorry.
get to decide which attendant care provider they access. Is that the case? They don't actually get to decide that.
Absolutely. Wherever we can, we provide people with choice because it is a very personal service. So we are really dedicated to trying to support people to access workers that work for them, that fit into their family life, that they get on well with. It's not always possible, unfortunately. Especially if people are living in regional and remote areas, the choice may not be there. But wherever we can, we work with our participants to ensure that the support workers they have engaged fit into their family life and provide that quality of care that they're seeking.
Yeah.
I
Unfortunately,
want to ask one more question.
okay, very quick. Yeah.
I just wanted to ask if you could provide us with some details about the how you ensure these attendant care providers are meeting their industrial relations requirements. So how does Lifetime Care and Support satisfy itself that these providers are actually paying award rates of pay and
How does that relate to the terms of reference?
industrial?
Wasting time. Please.
Well, it's on notice.
Yes, we're happy to take that on.
It's about the administration of the scheme. I think it's quite clear that there's an issue there.
Witnesses have taken that on notice. Thank you so much for attending today. Apologies that we've run out of time, and any questions on notice, like the last one, as well as any additional questions that committee members may have, if you could provide them within 21 days, and the Secretariat will be in contact. Thanks so much for attending.
Thank you. Thanks for your questions.
I'll start by getting you to state your name and your position title, and then swear either an oath or an affirmation.
Thank you, Chair. My name is Simon Cohen. I'm the Independent Review Officer. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Would you like to make a short opening statement?
Thank you, Chair.
Thanks.
Good afternoon, and thank you for inviting me to appear here today. The Independent Review Office is in our second year of dealing with complaints by persons injured in motor accidents about CTP insurers. Since 1 March, we have received some 1,500 complaints, most commonly about injured persons' access to weekly payments and treatments. These complaints often allege delays, wrong decisions, and poor case management by insurers. Our complaints work can solve many of these matters quickly. Almost 50% of the complaints were solved with the injured person receiving a benefit or the insurer taking an action. And over 90% were finalised within 15 days. A key reason for this is that insurers take IRO complaints seriously. They have experienced case managers who deal with our complaints. They respond promptly and, for the most part, thoughtfully and constructively. Without this, we could not effectively perform our role. Our submission reflects on common issues for these complaints, and we believe there are opportunities to improve the CTP scheme to ensure claimants are properly informed about insurer decisions and their rights, to better specify timeframes for making key decisions, and to allow claimants to progress claims where insurers do not make timely decisions. Our submission also seeks to inform the Committee's review of legal assistance for claimants in CTP matters. Current arrangements that largely exclude paid legal assistance until a dispute is lodged with the Personal Injury Commission are not striking the right balance and disadvantaging injured persons. Conversely, if legal assistance is available earlier, injured persons are likely to benefit, with the right decisions being made sooner and reduced need for costly and time-consuming dispute processes. One option to address this is to have a modified independent legal assistance and review service, or ILARS. Our submission notes that with appropriate modification, ILARS is a model that can address unmet legal needs in an effective manner. There are very recent submissions to the committee that also address this issue, including the Bar Association and Law Society submissions that are supportive of a modified ILARS in CTP, and the ICA and CIRA submissions that are not. Given they've only been recently published, I'm limited as to the comments I can make. However, there are a number of matters in the CIRA submission that concern me, and given time constraints, I'll make brief comment on a few of these. The executive summary states that CIRA agrees ILARS should not be expanded into the CTP scheme. One reason given is that premium prices would be impacted and risk scheme viability. This appears to be based in part on an actuarial assessment that has not been released and is subject to a range of uncertainties. It also appears to be based in part on a work value assessment that is incomplete, based on a small sample of files, and that has not been released. It's therefore difficult to provide any informed comment on this reason. A second reason given is that the implementation of options that enable end-to-end support for injured people is underway and will be the subject of public consultation. Information in the submission suggests the model is an enhanced CIRA CTP assist and increased CIRA regulation. It is unclear what additional legal supports are proposed. As the statutory reviewer Mayer noted, CTP Assist cannot replace the role of a lawyer who can both advocate for the injured person and provide advice about their individual circumstances. And while active regulation is positive, it cannot replace the role of a lawyer. A further reason provided by CIRA is that ILARS has not been tested through an independent review process. The submission notes two external assessments of ILARS conducted in the past 2 years, one by Nous Group and a second by a review committee of experts, independent of the IRO. These reviews have been largely positive about IRO and ILARS. But in addition, though, there are regular reviews of the personal injury compensation systems, including the role of IRO and ILARS conducted by this committee. And there are now financial audits, internal audits, and user experience surveying, all conducted independently of the IRO. There are a number of inaccuracies, omissions, and misstatements in the submission. As just one example, there is an overstatement of the increased costs of ILARS since 2015, which has increased by 75% and not 175% as stated. And the submission provides no context to this increased cost and the drivers for it. The CIRA submission also states there is a conflict of interest in IRO providing legal services and setting legal costs. This statement fundamentally misunderstands ILARS. IRO does not provide legal services. We only fund those services. Independent, private lawyers provide the service. Perhaps the matter of most concern, however, is that before consulting on the outcomes of the legal support review and making available the evidence for stakeholders to consider and comment upon, CIRA states that ILARS should not be expanded into the motor accident scheme. If that view has been formed without the opportunity to complete evidence gathering about the various options and to engage and consult with stakeholders and properly deliberate, then it does not reflect the careful consideration recommended in the statutory review and may call into question the outcome of the CIRA legal supports review, which in my view would be regrettable. I welcome the opportunity to discuss these and any other matters with the committee.
Thank you for your opening statement. Just on the issue of ILARS, so you've taken a look at the Insurance Council's submission?
I have.
think you said, yeah. I'll just read a part from it and then maybe get you to respond with your view, which I assume will probably be a counter view. So they've said the introduction of the ILARS into the scheme would increase administration and legal fees paid for through higher CTP policy levies and could introduce a more complex, adversarial and drawn-out process as proceedings become more formal and legalistic, contrary to the purpose of reform and objects of the MAI Act. I know you addressed some of this in your opening statement, but if you could maybe respond to that paragraph from their submission as well.
Perhaps if I could address the last element first. So the statutory review of Mayor considered this issue and I think concluded that simply by enabling increased access to legal assistance for people who are injured in motor accidents does not of itself therefore result in an adversarial system between people injured in accidents and insurers. So I don't agree that there's a corollary between enabling people to have access to expert advice and a consequent increase in the adversarial nature of the system. And in fact, conversely, where injured people have the opportunity to be properly advised, to be assisted in the investigation of their matter, to see whether they have got an appropriate matter that can be taken forward, to assist them, for example, in making an appropriate internal review request with all the relevant evidence that may be persuasive for an insurer, may in fact reduce levels of disputation and result in matters being finalised before they need to be referred, for example, to the Personal Injury Commission. And I point, I suppose, to the example in the workers' comp system, where most of the matters that are finalised by way of by way of an agreement or a decision of the Personal Injury Commission are actually able to be finalised before they land at the Commission. And a key contributor to that is because the lawyer's been able to properly investigate the matter and been able to provide a compelling case to the insurer that enables them to make an informed decision in relation to it. So I suppose those would be my comments. In terms of cost, I suppose in part it depends on exactly how the scheme's designed. And I think it's acknowledged that if whatever form of additional legal assistance might be put in place and however it's provided, it really depends then on when that access will be provided as to what the ultimate costs of that might be. And there may be an approach that's different in CTP to workers' compensation. I think that would need to be the subject of detailed and appropriate consultation.
Any views or thoughts about the performance of PIC?
Certainly the Personal Injury Commission's been upfront about the challenges it's had in terms of working its way through matters, particularly where medical assessments are required during the pandemic. I guess I'd observe that one of the things that they've sought to do regularly is to give information to the various parties about whether there might need to be cancellations or delays or different ways of providing those, how that might impact on the availability of those services, and that there's no question that those matters, particularly the movement restrictions and the public health restrictions, have had an impact on the ability of PIC to be able to get through those medical assessment matters. So I certainly am aware that there's an active program of work to try and increase the velocity of matters through the Personal Injury Commission. My understanding is it's much more likely to affect CTP matters than it is workers' compensation matters, where there's a much less of a queue or backlog of matters.
Might hand over to some of my colleagues. Mr. Donnelly.
Thank you, Chair, and thank you, Mr. Khan, for the submission and coming along today. Just got a number of questions, or relatively small number of questions given the time to go through, so I'll need to move quickly. But
of course,
they're in no particular order. But the first one's this, and this has come up in the context of some questioning earlier today of some witnesses that you may or may not, because of time commitments, had a chance to become aware of. But can I ask you that there is, or there was, a piece of correspondence dated the 10th of November 2022 on the letterhead of the President of the Personal Injury Commission. Quite a lengthy piece of correspondence dealing with some matters that he saw and believed of concern with respect to a submission made to this inquiry by the Australian lawyers. Sorry, I've just got the name wrong. Missed the ALR, Australian Law Association. Lawyers are ALA, Australian Law Association. Now, we're aware that you were CC'd into that piece of correspondence. Is that correct? You received that?
I did receive that correspondence.
Yes. And in regard to that piece of correspondence, did I presume you have a chance to read and review it?
Certainly, I read the correspondence in the context also of reading the ALA submission and preparing myself to appear before the committee today.
Yes. With respect to the judge's correspondence yourself, His Honours, what did you understand it was trying to do? I mean, it was sent to you, CC, carbon copy. What did you believe the intention of this was directed to you?
Well, I guess I can't speak for the
no, but in terms of
the judge or the president.
You received it, and you're obviously the independent review officer. So it was sent to you in your capacity. What was its effect on you?
Well, my understanding was that it sought to respond to some matters that had been raised in the ALA submission to the committee, and to put on the record steps being taken by the Commission to effectively manage the cases that it was dealing with before it, and to do that in a way that was open in the context of being made available not only to the committee but to a range of other stakeholders in the personal injury compensation space, for want of a better way of putting it.
So your sense of this, and sorry for going through this, but it has been a basis of some discussion today, that it was received by you and you saw it or received it as something in the form of a piece of correspondence trying to inform people about views and to place them on the record.
That was my understanding
the way you understood it.
That's right.
And you were aware that it was CC'd, his correspondence, to a number of other people, including yourself?
So when I received the correspondence, I saw that I was at the back of the correspondence on the list of a number of people who had received the correspondence.
On notice, I'm wondering if you'll be able to provide a committee with that part of the email, or that email sheet or cover sheet, which has got the complete list of who was CC'd into it, if you could do that.
Of course.
Thank you. So having read the piece of correspondence, forming your view that you've just described and explained helpfully about the purpose of it, what did you do with respect to the correspondence? Did you do anything in response to this? Did you write back, say thank you? Did you speak to anyone about, had they received it as well and what their views were, or how do you deal with it?
So at the time of receiving it, I was contacted by the judge to let me know he was forwarding it to me for my information.
So this is before or after you'd received it? To the best of your recollection.
To the best of my recollection, it was on the day.
On the day.
Whether it was before or after, I can't
Okay,
say.
that's fine. And what did he say to you, can I ask?
It was the conversation was in respect to let me know that he had written to me about it. But also then he also wanted to speak to me about a proposal that the Commission was looking at to limit the number of pages of evidence that might be permitted to be lodged by parties in proceedings before it. And that was the primary purpose of our conversation, to discuss that proposal.
So the conversation, and sorry to keep going down this rabbit hole, but the conversation had more than one element to it. It was to let you know, or to confirm a piece of correspondence was to be emailed to you. Did he explain to you what was going to be in that correspondence? To the best of your recollection?
So that it was, the best of my recollection is that it was responding to matters raised in the ALA submission to the committee.
Right. And what did you say in response to that? Did you comment about what he put to you about what the purpose of the letter was, or you said you'd have to wait and see, or how do you handle it?
I said I would review the correspondence.
And did you indicate to him that you would get back to him in regards to your response to his correspondence?
No.
No. So with respect to the second part of the telephone conversation that you've referred to, did that tie back into the first part of the conversation with respect to the correspondence, or was it treated as a separate, discrete point he wanted to discuss with you?
A separate and discrete point.
Right. And could you just repeat for the purposes of our clarity that particular point that he raised with you in that conversation?
Yeah, so it concerned a proposal that I understand the Commission is exploring about whether to limit the number of pages of evidence that a party might lodge with an application to resolve a dispute with the Commission, to limit the number of pages to 500 pages as a measure to increase the efficiency of the Commission and its dealing with matters.
So if I could sort of use this phrase, it was a conversation, and after dealing with the first matter, moving on to the second, he was just sounding you out, or asking you perhaps to think about it and come back to him about that?
Well, more really informing me about it being a matter that the Commission was considering through its rules committee, the reasons why the Commission was exploring that, and also in that context, I asked some questions about trying to understand, the number of matters that might be impacted upon it, whether that was a practice that was used in other jurisdictions to inform my understanding of the proposal.
And did he invite you, or did he provide you with the opportunity to sort of give some further thought and reflection to this part of the discussion and to come back to him, or was it just a bit of a back and forth on the phone to give you a bit of a heads up?
I think it was more the latter, to give me a heads up about the Commission actively considering the matter.
And did he indicate to you that this was something that he was broadly canvassing with others?
So he indicated it was something that was going to be considered by the Rules Committee. The Commission has a Rules Committee, and that includes a range of stakeholders. So it was in that context.
And as far as you could understand from the conversation, this was something that was imminent. It was moving towards some settled position, and this was a case of just discussing it with you.
My understanding was that it was something that was going to be considered by the Rules Committee this year.
Right. I do have some more, but I've been going through a bit here. Sorry. I've got plenty more, but...
Yeah, if I could just continue on that line of question just for a moment.
Of course.
And first of all, thanks, Mr. Cullen, for coming along today again and providing your detailed submission. This is the first time I've heard of this, right? I'm just a little bit perplexed as to why a commission of any type or any tribunal would want to limit the amount of evidence that was placed before it and it was making a determination on something. In your experience, could it be necessary in some cases to provide more serious and complicated matters, more than 500 pages of evidence to accurately outline a position?
So I'm not across the details of the proposal. My understanding is that it would allow for exceptions or circumstances where that might be necessary, but that one of the key issues it's seeking to address is where large amounts of information that might not be necessary for the Commission to deal with are being placed before it. So large volumes of clinical notes, repeated copies of reports. So one party might lodge a report and another party lodges the same report, and those types of matters. So that's my understanding, is that it's something where there would be permitted to be exceptions to it, but it was thought to be something that would remove information that might not be necessary for the Commission to consider in arriving at its determination.
Okay, thanks. I'll go back, I'll change the course of questioning then. You said earlier, it may have been in your opening statement, perhaps, anyway, it's irrelevant. Since March, 1,500 complaints approximately?
So since March 2021.
Yeah, okay. Simply because, and I want to get to the basis of this, simply because somebody lodges a complaint, sometimes there's no substance to the complaint.
That's true.
On an average, what would you say? What sort of percentage is frivolous, or do we have 1,500 legitimate, definite complaints?
Yeah. So when we deal with complaints, one of the first questions we ask is it a complaint that's within our authority to deal with? So some of those complaints weren't within our authority to deal with. A common example of that was if someone said that they had property damage rather than a personal injury.
And I take to that, and I'm glad you've said that, because I looked at one of the charts you provided, and it's 198 complaints were about property damage. And I'm sitting here scratching my head when I was reading your submission over how could CTP have anything to do with property damage?
Well, they don't. And
okay, that addresses some of that then.
And we've actually taken steps going into this new financial year to reclassify those as inquiries rather than complaints, to be much clearer about that. But more generally, there might be complaints that we say to someone, if you haven't raised them with the insurer, you need to do that first. So we'll reject those complaints. But then most of the complaints we deal with, they do have a legitimacy to them. 50% of the complaints we were able to solve, the insurer paid a benefit, took an action. That might have been changing a case manager, assisting the person with a different medical examination, whatever it might be. Or sometimes it's just a matter of providing information. The injured person hasn't got all the information they need to actually be able to understand the decision that's been made.
And further to that then, and going back in something you said previously, and I've taken handwritten notes here, so it's probably not exactly what you said, but something along the lines of we need to inform potential complainants more about perhaps their rights or provisions. How should we do that?
Yeah, so one of the things that we think could contribute to that is when an insurer is making a decision, for example, to deny liability or to refuse a particular claim for treatment, to actually provide proper reasons about why they're doing that. And there's a model in Section 78 of the Workplace Injury Management and Workers' Compensation Act that really outlines in more detail about, a concise statement explaining exactly why you've made a decision and also providing the evidence that's relied upon to make that decision. So that's one example that we have.
Can I really interrupt?
Of course.
You say that's in the Workers' Compensation Act.
That's right.
It's not in the CTP Act then?
So there's not there's the provisions in the CTP.
Act, sorry,
the provisions for CTP aren't as detailed as they are. There are some good provisions around what needs to be given. We think they can just be made better, and we think that there's a good model in workers' compensation that could be drawn upon for that.
And I know this is probably an oversimplistic view, but, and again, you can stop me if I'm wrong, but are you suggesting and you're recommending perhaps that we look at transferring that component of the Workers' Compensation Act and taking it over into the Motor Accidents Act in terms of what the insurer has to provide in terms of, concise information backed up perhaps by some evidence?
Yeah, well,
may alleviate some of the complaints that you receive.
You're absolutely right. Some of the complaints we deal with, an injured person comes to us and says, I don't know why this treatment has been refused. There was an example of that in one of our case studies. And when we looked at the insurer's notice to say why it had been, it was literally a couple of lines. It wasn't comprehensive and didn't really legitimately explain why the treatment had been refused. When they were taken on internal review, much more detailed reasoning was included, and it was actually, for the injured person, there were some treatments that they were successful in having, and some that they were not. But they were happy just to get on with their recovery after that as well. I think that shows the value of people actually understanding the decisions that are being made that affect them.
I think we'd all agree that the provision of information certainly helps you in your decision-making process and where you go from that. Can I ask you this then? Is there one insurance company more so than the other that is, well, and, I'm putting you in a position, I know, but you are on oath to give evidence, and I'm not suggesting you're not doing otherwise. But we need to find out, and this is the idea behind these committees, is to inquire into the system. Is there one that's more rogue than the other, perhaps?
What I'd say is that we publish detailed information about our complaints in our annual report, and I'm happy to provide what information I can to the committee about the nature and types of complaints that we receive against insurers. CIRA also publish detailed complaints information, and including contextualising that against the number of claims that insurers have received. So you can see which insurers are getting more complaints.
But they might have a bigger volume of the market share or claims to start with.
And so CIRA does the job of actually adjusting for that. So you can see, I think it's the number of complaints per 100 active claims, and there is a difference between some of the insurers. So there's no question that some do better, and but what I would say is, in addition to that, is that our experience of CTP insurers when we're dealing with them about complaints has been pretty positive. They've adapted to our processes. They've been responsive to our complaints. By and large, they've been constructive in looking freshly at matters, and that's reflected in the high solution rates we've been achieving in those complaints as well.
Well, that's great, because in asking that question, it wasn't to pillar a particular insurance company. What I'd like to say is, if there was one that perhaps wasn't performing to the standard of the others, it's not about attacking them, it's about raising their standards up and saying, look, if these others can do it, perhaps you need to look at their... So that was the purpose. And, Chair, I'm aware that I've held the floor for quite some time, and I accede to some of my other members to ask some questions.
Anything from you?
Can I just,
Mr. Donnelly,
through you, Chair, Mr. Cohn, you very helpfully provided quite a detailed opening statement. Did you have a copy of that opening statement?
I do. I'm
wondering if that could be handed up through the Chair to the Secretariat, just because it contained, and through you, Chair, circulated to members. So I think it contains some careful, sorry, not careful. It'll also help Hansard for the purpose of the record, but it very.
I'm hoping there's no acronyms or shortcuts in there that can't be read. But I hope it's.
No, and that's why it
We
was
live
very
in a world of acronyms and shortcuts.
I can tell you, we got our heads around the IRO and CIRA and a couple of others, but after that it gets a bit murky. Okay? No, it was a very clear, and that's why I'm asking for it, because it's useful for us and Hansard, I'm sure. But in that opening statement, and this is what I want to get to, there were a few points that you did raise, and I'm running off my notes now as opposed to what specifically is word for word in your opening statement. But thank you. But there were some elements in it. So I'm just going to take a moment now to sort of just interpret what I said here. I suppose they were couched in terms of some concerns or criticisms of CIRA. And first of all, on the issue of their what appears to be strong, clear opposition by CIRA to the proposition for ILARs. Do you have a sense of why that is so, that their strong position? Has that, through your reading their material and their submissions and what have you formed a view about why they are so firm in their position in regards to opposition?
So my understanding from the submission to the committee is that the bases include that the cost of it would be a threat to scheme viability, that their support of legal assistance supports for claimants is suggesting other ways in which that support can be provided, and that the ILAR scheme hasn't been the subject of an independent review. And I think the fourth is that it's inconsistent with the original scheme design of the 2017 legislation. So they're my things. They're included in the executive summary of the CIRA submission to the committee.
So in regards to those points, have you formed your own view on each of those in your capacity, in your role as the independent review officer? Have you formed a view that acts as, or is in fact a counterpoint to those, either firm counterpoints or some question marks over their analysis in regard to those points? Because I further on in your opening statement, I haven't been able to get to read it. I do appreciate that you contested quite specifically some of the quite almost factual elements of part of the CIRA submission. So I'm just wondering, have you got a counterpoint to these that you would like to share with us? Or
well, I think the point I was really seeking to make to the committee is that, firstly, it is important that a review of legal supports has and is taking place. So I strongly support that. And I think there is strong evidence before the committee, and it's been before the statutory review by Clayton Newts, and I think it's also the review by Taylor Fry, indicated that there is a need for more legal supports than what are presently in place. So the question is, what's the right way to provide that? And the Taylor Fry review outlines 8 possible options that might be put in place. And the next step, as I understand it, is to consider those options in a considered way, and then to make the best decision about what's going to strike the right balance of all the competing pressures. Now, some of the information around that is not information that we're privy to at the moment. There's an actuarial assessment that's apparently been done that suggests a very high cost to introducing an ILAR style scheme. But we've not seen that actuarial assessment. We don't know the assumptions that inform the assessment. We don't know what sensitivity analysis has been done around different options that might be provided. We also understand there's been an assessment of the legal costs from a review of particular CTP cases that's not as yet complete, is examining as I understand it from the submission, a small number of cases and has some preliminary indication conclusions. But again, it's not complete and we've not been privy to that information either. So if I use that as an example, and I suppose reflect back, our understanding was that a legal supports review would include strong engagement and consultation with people who might be able to add to it, to give their views, to review the evidence, to provide submissions that then might inform the preferred approach. And so to arrive at a conclusion before that's gone through that ILARS isn't the right model suggests to us that has been closed off before the completion of the review. And I guess that's the part that I have concerns about. I have a number of concerns about the submission and some of the information in it.
Sure.
I haven't really had a sufficient opportunity to be able to complete those considerations. But I think just more generally, if there is an open mind about what's the best way to address this need, then to have formed views about that before all of the evidence is collected and you've had an opportunity to speak to key stakeholders, I don't know, it just seems to be maybe jumping the gun a bit, and it does then call into question whether there's a genuinely independent mind going to be brought to the conclusions of the review once all that evidence is assembled and able to be considered.
Well, thank you for your frankness in the response. It's much appreciated. Sorry, Chair, I just got... Chair might have some...
I've got one, but I'll have the last question.
Okay,
it's a broad question.
That's
if you're
right.
on a roll, Greg, you can go for it.
So
It's always on a roll.
a sausage roll. With respect then, and thank you for the answers, with respect then to the review and with respect to the informing, if we could use that phrase or that word, of CIRA, of relevant information and knowledge and expertise to formulate a considered response in regard to ILRs, was there ever any expectation that would be something that would be sort of, dare I say, put out there for stakeholders to contribute to? Was there any expectation about that? Or, in fact, what CIRA is doing is what essentially they're entitled to do as they see fit, consult and then formulate a position?
So I guess from my perspective, as an agency involved in CTP, dealing with complaints, having a role to inquire into aspects of the personal injury compensation legislation, including motor accident legislation, and also being the expert in ILRs, 10 years of experience in dealing with it, understanding a whole range of the issues that come with the day-to-day administration of that type of scheme. I suppose I did have an expectation that as the evidence was being assembled and views were being formed about the preferred way forward, that we would be deeply engaged in consultation as part of that. That might be an unrealistic expectation on my part, but certainly before a specific option that had been recommended for consideration by the statutory review, the Clayton-Utz review, and that where it had been recommended that there be considerable additional examination of a modified ILR scheme through the Taylor-Fry review, and it had some reservations about ILRs, albeit I have some significant reservations about its analysis of the scheme.
Yeah.
So our expectations may not be aligned, but certainly that had been my expectation.
So I'll just finish on this point that it's fair to say for an objective observer, based on what you've said and understanding your role as it currently provides for it, I mean, you've got a little bit more than a tiny bit of skin in the game here, haven't you? If there was almost anyone else other than those important contributors already to the information to help inform CIRA's consideration, you ought to be considered of being quite up the totem pole as being someone that you'd engage with to find out the thoughts about.
Yeah, and in many matters, CIRA engage with us very well,
Yeah.
and I don't want to in any way be
No.
suggesting that's not the case.
We're specifically looking at this issue.
Just specifically about this issue, I've raised my concerns, but it is such an important review because there is a significant unmet need, and it is actually impacting upon injured people and their access to their entitlements, be they treatment entitlements, be they weekly benefit entitlements, and that's having a real impact on them and their recovery and their families. So, yeah, it's an area that, to be honest, we're pretty passionate about, and we think it's a really important review. And whether it's ILARs or something else, what's really critical is that injured people have access to more support than they are receiving today.
Thank you.
Probably final question, but with in your capacities with regards to both the CTP scheme and the workers' compensation scheme, how would you compare the two schemes? What would you say is sort of the good things or the bad things about each of the schemes? Is one more adversarial, or is there more complaints that come your way from one or the other? How would you compare the two different schemes? Not that we're doing workers' comp today, but we had you in here recently in that capacity as well, so be of interest to committee members.
So I guess the beginning point would be, for us, the workers' comp scheme is a much larger scheme. In terms of complaints, we receive 8 or 9 times more workers' comp complaints than we receive motor accident injury complaints. And part of that could relate to the newness of our role. Part of it could relate to the CTP assist in the CTP space. There's only just the startup of something similar in the workers' comp space. Some of it, we think, unquestionably relates to there being a strong familiarity of us in workers' compensation. And so if I can caveat my views with that. But if I was to go and speak to the team that actually deal with both CTP and workers' compensation matters, my solutions team, probably what they would say is the biggest difference is that where we can't solve complaints, the options that we have for people injured at work as to those injured in motor accidents are very different. For people who are injured at work, we can often give a pretty seamless handoff in the context of referring them to information about ILARs so that they know that they can confidently go and see an expert, an independent lawyer, and get advice about their matter at no cost to them. Whereas in the CTP space, it's a much less certain handoff. We might need to, for example, send them to the New South Wales Law Society website to see whether they might be able to find someone who can assist them. And we can't provide them any assurance about the expertise of that person as we can in the workers' compensation space. And if their reflections to me as a team is that that's probably the biggest difference in terms of how they deal with complaints. I think the other thing that I'd reflect upon is that the element of fault in motor accident matters does give them a different complexion to many of the workers' compensation matters that we deal with, and that's something that is one of the unique elements of the CTP scheme as against the workers' comp scheme.
As in that it's a no-fault scheme.
That's exactly right. Yeah.
Okay, thank you. We've unfortunately run out of time, but thank you for your evidence today, and the Secretariat will be in touch regarding questions that have been taken on notice, as well as any additional questions that committee members might have. So thank you for joining us.
Thank you.
witnesses for today. If each witness, starting with you, Mr. Dent, please state your name and position title, and then swear either an oath or an affirmation.
Thank you. Adam Dent, Chief Executive of the New South Wales State Insurance Regulatory Authority. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Hello, Katrina Casey. I'm the Executive Director at the Motor Accidents Insurance Regulation Division of CIRA. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Excellent. And would you like to start with a short opening statement?
Yes, thank you, Chair. I begin by acknowledging the traditional owners of the land on which we meet, the Gadigal people of the Eora Nation, and pay my respects to elders past, present and emerging. I extend that respect to any Aboriginal or Torres Strait Islander people here today. Thank you for the opportunity to address the committee today. The CTP scheme today is very different to what it was 5 years ago. People injured in motor vehicle accidents have fast access to income support, treatment and care. This includes statutory benefits for those who are wholly or mostly at fault. The scheme also supports people to achieve optimum health and recovery outcomes. It is more affordable and more efficient as a result of the 2017 reforms. On average, New South Wales motorists are saving $153 on their annual green slip. Importantly, 59% of the premium dollar is being returned to injured people, as compared with 44% under the 1999 scheme. Towards the end of last year, approximately $91 million in excess insurer profit from the first accident year was recovered from insurers. The ability to claw back profits greater than 10% is a unique feature of the 2017 scheme. I will shortly make a final decision on a further assessment of profits covering the first 3 accident years of the scheme. In December 2021, the statutory review of the Motor Accident Injuries Act 2017 was completed. It considered whether the design and terms of the Act, regulation and guidelines continued to meet policy objectives. The review also considered recommendations made by this committee. The Motor Accident Injuries Amendment Bill 2022 passed last night in Parliament. I thank the members who were involved. The bill introduces a number of important changes, including extending and allowing speedier access to benefits and damages claims, increased access and availability of rehabilitation and trauma supports, as well as other changes to improve the operation of the scheme. We will prioritise the implementation of these changes and will remain focused on progressing the other recommendations, many of which are already well underway. Many recommendations didn't require legislation change and can be handled by CIRA administratively or through guidelines. CIRA was pleased to provide the committee with a supplementary submission regarding ILARs. The submission was informed by the findings of the Legal Supports Review, which was finalised in September 2021, the statutory review and initial actuarial assessments. CIRA doesn't agree at this point to extend the current ILARs model into the CTP scheme. Our submission outlines CIRA's commitment in ensuring that all people with a CTP insurance claim have access to appropriate legal and other supports while maintaining scheme sustainability, premium affordability and scheme efficiency. CIRA will conduct a public consultation on the proposed model for legal support in 2023. Another key legislative milestone commences on the 1st of December with people that need ongoing treatment and care transferring to CTP care, managed by the Lifetime Care and Support Authority. So, to summarise briefly, the scheme is performing as intended, premiums are lower, benefits and supports are being extended and improved, and more profits are being clawed back. There is always going to be more to do as our scheme matures, but the 2017 scheme is meeting its objectives. Dr. Casey and I thank you again for the opportunity to appear today. We look forward to assisting with your inquiry.
Thank you. I was wondering if you could talk more to ILARs. I saw that you're here for the previous witness, and I know you've got a difference of opinion based on your submission. Maybe you could talk more about potential additional costs that you believe might be added to the scheme if under ILAR, if ILARs was extended to CTP.
Certainly, and if I can first acknowledge that Mr. Cohen was in fact correct about a typographical error in our submission. The figure of 175% was incorrect. The increase is 75%, or the value has increased to 175%, not by 175. So I apologise for that. In terms of the additional costs that we're concerned, at this stage we're working with initial actuarial assumptions, which will be part of the overall process and in our consultation. The premium impact at this stage, if we were to introduce ILARs in its current form to the CTP scheme, would be around $16 to $28 per policy per accident year. That's a reasonably significant increase and cause for concern about whether that model in fact would work. So that ongoing increase of ILAR's fees in the workers' compensation scheme year on year also gives pause for thought around whether that model is appropriate in terms of the impact it would have on premiums. I'm happy to invite Dr. Casey to make any further comments too.
Thanks, Mr. Dent. I'll just add a couple of things. I think the fundamental difference with the model and its application in the workers' compensation system is that it's a front-loaded model. So it's not that there aren't aspects of the ILAR's model in terms of how it provides legal supports might be appropriate, and we would consider that and would be part of the public consultation. But the 2017 scheme changes, one of the fundamental approaches was that people are getting earlier access to care, statutory benefits. So the need for that front-loaded legal legal representation is at odds with the scheme design in the motor accident scheme. So I think it's just they're very inherently different in terms of their application. So I think that that's really important to add to the issues that Mr. Dent said around costing. I think that that's the main point that I would say about the differences in the models.
I think it's perhaps, Chair, if you don't mind, important to acknowledge at this point that in the brief amount of time we had to make a submission on this topic to the committee, we thought it would be inappropriate not to have a view at all. And so to that end, on the basis of the consultation we intend to undertake over the course of 2023, a view of a modified version of ILARs or a range of supports would certainly be on the table. We are absolutely committed to making sure the appropriate level of legal support is brought into the scheme while balancing that tension of affordability. But by the time we had to make a submission, we couldn't agree to where the terms of reference was about the current ILARs model to support that.
So you would be happy with a recommendation of CIRA to conduct a review of the appropriateness or effectiveness of ILARs within 2023? As an example, like
we would in the sense that is the work we're intending to do.
Right,
So we
okay.
would welcome that recommendation because we intend to be able to meet it. And we are looking at it from an end-to-end point of view. There's a range of points in the claimant journey that we would want to look at improving, starting first of all with minimising the reasons for complaints and disputes to arise in the first place. Then we move into when they do arise through CTP Assist, can we help claimants understand their rights and the benefits available to them. Then you have the option of the resolutions team at the IRO, and I commend them for the incredible work they do in resolving complaints very quickly before they turn into disputes. Then at that point, there's an opportunity for legal support. As the regulator across this scheme and others, we need to take an end-to-end view, and ideally we'd like to reduce complaints and disputes with a reasonable significant amount in the first place, rather than just addressing it with one piece of the journey.
In terms of the TEPL, so there's not really any incentive for insurers to attempt to make super profits, given that anything above 10%, has to be clawed back.
That's
to
correct.
use your term from before. I think you may have mentioned, but how much money's been clawed back so far through the TEPL?
So it was around 91 million. So last year was the first year we had the confidence to be able to claw back an amount. So each year we run 2 assessment processes to determine whether there's sufficient information that would allow us to make a decision with a probability of accuracy. Last year was the first year we'd reached our threshold of between 80 and 85% for 2018 accident year. This year, the investigation is about to be completed. I suspect we'll again return some funds from the 2018 accident year and start to look at the 2019 accident year.
And
so can I just clarify that 91 million was for the 2018 accident year, it wasn't for 2021?
That's correct. So it was the 2018 accident year. So one of the important things we have to consider, of course, is at the present time, the 20-month delay for lodging damages claims, for example. That means in the year that the accident occurs, we're not going to see those matters dealt with. So it takes a couple of years for us to be able to look at that accident year and say, all of the appropriate claims and benefits have likely been paid from that year. So we did that work in 2021, but it was for the 2018 accident year, not the 21 accident year.
That's just because of the long tail nature of the scheme, and the insurers probably would need to know how much money they would need to reserve for, put aside basically for future injuries, which I assume,
correct.
You wouldn't be able to know, on the 1st of January or the 1st of July each year based on the previous year.
Particularly given the 20-month waiting period that existed, it would take 2 years before there was any probability that those damages claims would even start to materialise. So it then takes a number of years for those to be settled. So looking back at 2021, looking back to 2018, we had a degree of confidence there would be at least $91 million in profit, and we brought that back. This year, with further claims maturation, we're able to look again at 2018 and say, we think there's actually still some more that we've now got sufficient confidence is profit, and we'll potentially draw that back too. But we're now starting to see the maturity in the 2019 accident year, where we have a degree of certainty that there's a small amount that we could also claw back from 19. And perhaps next year, when the confidence increases again, there would be a further drawback from 2019.
And
so you concur with the Insurance Council that the utilisation of TEPL will taper off as the scheme matures and the estimates are able to be more accurate in terms of the premium setting?
Absolutely, Mr. Adam. I think that it's appropriate that they made the point that in 2017, when the scheme was to be formed, that first accident year, there were a number of assumptions that had to be made given the lack of experience, and some of them were considerably higher than reality has played out. And as a consequence, insurers priced based on the best evidence available to them. What we've now seen is that pricing is shifting. I think, without trying to speak in detail because it's way too early, we are seeing the very, very early data from further accident years are indicating that pricing is becoming closer to reality. So eventually the TEPL mechanism probably won't have a lot to claw back as insurers' experience allows them to price their premiums more closely.
I just add...
What was the estimate? Oh, can I say, just following on to this line of questioning, then I'll yield. But what was it? Was the driver of that 91 million? What was the estimate that was wrong that meant that figure was so high?
Well, I think it's a combination of factors, and then I will invite Dr. Casey to contribute to her area. One of the things we certainly saw in that accident year was an unseasonably low number of casualties and subsequent claims. So I think that impacted that year first and foremost. We also saw the number of predicted disputes, which had to be based on previous experience of a very different scheme. That hasn't materialised to be the case in the new scheme, given the shift to statutory benefits. But so fundamentally, a lower number of claims has been a part of the driver, and the disputes that have arisen in those claims has certainly been part of it. But I'd invite Dr. Casey.
Thanks. I was just going to make the point as well that every year the premium guidance that CIRA gives the insurers updates the experience, so that will also contribute to, I guess, a more realistic pricing and contribute to the fact that there will be less profits in the scheme as the experience develops, so the pricing is more reflective of the actual experience, and that's recalibrated on an annual basis, which is a really important part of the pricing and premium guidance that CIRA gives the insurers, and then they have to follow that when they file on an annual basis.
And I suppose actuaries sometimes get it wrong as well. I mean, they get pretty close and they do a good job most of the time, but it's not 100. There's never 100% accuracy with pricing an insurance product that they're going to get it completely correct. Especially, I would assume in a new scheme that hasn't had time to run its course, which is what you said.
Absolutely.
Before.
And I think when we get to the 5 to 7 year mark, you would start seeing considerably more accurate estimates because that level of experience is what is needed to see how things play out, to see what behaviours emerge in the scheme in terms of the types of things that happen.
And sorry.
No, go.
I suppose maybe some commentary would be useful as well about pre-TEPL, so the old scheme, Because my understanding is that under the old scheme, that whether the actuaries got it wrong or the scheme was overpriced, but that there were those, super profits, to use some of the language that was that did exist in the old scheme that doesn't exist today, which was more a function of, my understanding, more of a function of reserve releases as well, as in that perhaps they didn't price the risk properly, and that in future years, they basically insurers over-reserved, and then that money went back in profit, essentially. It's sort of a reserve release basically is. But that can't really, you're not seeing that quantum. I don't know what the figure was, but you're not seeing that sort of quantum of reserve releases under this scheme that you would have seen in the old scheme. I assume that that's largely not a factor now, or would be a very small part of it.
Well, it's not really part of the structure of the scheme anymore. That's exactly what TEPL does. So insurers have to collect premiums in an accident year for costs that will be incurred over the life of that claim that happened in that accident year. And these are long tail claims, so it can be 7, 8, 9, 10 years before all payments related to that accident year happens. And under the old scheme, there was no structure to claw back those profits, so they remained with the insurers, as you said, through releases. In this scheme, that can't happen, that when there's enough certainty and enough experience as the accident years mature, the TEPL mechanism allows CIRA to make that decision, and then that money goes back to the policyholders. It's important that we try and make the decision as close to the accident years as we can. So now that we've done one, and the assessment for this third assessment that is underway, meaning that the money that's clawed back goes back to the policyholders that were more likely to be paying the premiums when it was collected.
Do you have anything more on TEPL, Mr. Diadam? Otherwise, I'll hand over to...
I did want to ask about the 10%, the logic behind the 10% threshold in terms of profits. I'm assuming that's statutory, is it?
So
that's,
yeah.
So the CIRA board makes a determination about what they think is a reasonable profit level. Now, I confess that I wasn't at CIRA when that was settled, nor was Dr. Casey in the role, so we could take on notice the detail of how that was arrived at. But it is a decision the CIRA board would make around what they think is reasonable, having given the market considerations, etc.
Yeah, I was going to, just to follow up on that, was just to ask about whether that threshold is going to be reviewed in light of a, much higher inflationary situation that might impact on the overall return on investments that the insurers are likely to get.
Are you suggesting an increase in the profit amount, Mr. Diadam? It's quite uncharacteristic of you.
I'm not suggesting it. I'm trying to work out whether that's on the cards.
Well, I mean, it is about profit. So if those costs increased, that would be taken into account. So if a claim was costing more to resolve, there would be less profit assumed by the actuaries. So, but I think the short answer is, if it did somehow actually cross over and start to impact, and that threshold was no longer reasonable, then of course we would review that. But it is an assessment of the profit. So that is after those increased costs would have been paid by the insurer. The other side of TEPL, which is also probably important and has not been necessary to this point in time, is it also deals with excess losses. So where an insurer makes a profit of less than 3%, which is where you're starting to get into the business not being worthwhile for them, then there's an opportunity to recover excess losses. We would look at that. But that's certainly not an issue anytime soon.
I might just add to Mr. Diadam's point, there's other avenues to deal with insurer costs. So we have claims handling expenses. Currently, we cap that. So if there are pressures, because we obviously want the insurers to have enough resources and attention in relation to how they manage claims, so there are avenues for us to increase the amount or the allowance that the insurers can spend in terms of claims handling costs, and that then gets factored into the premium. So there is an ability to be able to adjust that. So it doesn't necessarily have to flow through in terms of how much profit they can take out. There are mechanisms in the scheme to allow us to adjust that up or down depending on some of those cost pressures that you mentioned.
Mr. Roberts, Mr. Donnelly.
Yeah, I've
I
got
do
a
have
couple,
further
Chair.
questions, Chair, but come back to me later.
Okay, we'll do.
Yeah, look, I don't have a lot, but just I'll cover them quickly. You heard the evidence from Mr. Cohen, I think it was just before, because you're in the room, and we were talking about, what's the terminology? I can't even think of what it was. We're talking about transferring a provision in the Workers' Comp Act over to...
ILARs?
No, not ILARs. About the provision of information to in determining claims.
Mr. Roberts, I think you're referring to the letters in workers' compensation around when a decision is made, the level of detail. I think Mr. Cohen
That's
was
exactly
referring
what
to that.
I'm
Yes.
referring to, Mr. Denton. Thank you for helping me out. So you heard his proposition to a question of mine that it might be useful, perhaps, to transfer those sort of provisions that are contained in that Act over to this Act that we're dealing with now, the Motor Accidents Act. Do you have any comments on that at all?
I mean, only that it's a good idea, and I wish I'd heard it from Mr. Cohen before we got to a Law and Justice Committee hearing.
That's
I think
because
it's,
you didn't question him like I did, Mr. Denton, you see.
And I don't know that it would be well received if I tried. I think that's useful insight, and 5% of the motor accident active claims in New South Wales generate complaints from which Mr. Cohen can generate insights. So while it's only a very small subsection of the number of active claims, the IRO does get the opportunity to understand what's going on and where the pressure points are. CIRA does, as I think at some point Mr. Cohen did attempt to say, work well together with the IRO in the main. The resolutions teams share their data now through an MOU with CIRA on their complaints each month. We have access to understand those issues now in a way we haven't before. But certainly where the IRO forms a view around some systemic issues or possible solutions like that, we're very open to them, because from our regulatory role, we wouldn't necessarily see that day to day.
Sure.
But we can now take those sort of matters up with insurers. And it's not necessarily even a legislative change, perhaps. Dr. Casey has the opportunity to very strongly encourage insurers through our independent supervision process with them to be better on that. And I think that's a very useful suggestion we would take away from here.
Good.
And
Well,
engage
I'm
with insurers.
glad we've come out with something today, because it's just my concern that, and I'll use the term unsophisticated claimant, doesn't have access to that sort of information. And if they're provided with it, it certainly makes the process easier and smoother for all. And at the end of the day, I think that's what we all want, isn't it? Just to make it a more user-friendly.
Yeah, look, absolutely. And I think there are a number of things we do that tries to help that, and then sometimes you hear it doesn't cut through. So, for example, an insurer is required to tell a claimant about the existence of the IRO. Now, if that message isn't cutting through, that's useful information to know. Similarly, our CTP Assist outbound services contacts every claimant. We don't always get them call us back. So there's another opportunity where we could help around rights and benefits, but they're not being taken up. This sounds like a very, very simple and pragmatic way to add another arrow in that bow, if you will, to help with that problem.
And that was no criticism of CIRA. It was just something that we teased out talking to Mr. Allen.
And very, very helpful.
And I'm nodding to the chair to ensure that perhaps we might consider that in our final report. And if I may, I'll just take to another subject. And no doubt, I'm assuming you watched the bill go through the House last night.
Absolutely.
So you know where I'm going to come from now then, in relation to my amendment and my concern over the unfair and unjust treatment of taxis in the CTP scheme as it exists at present. Could you talk to us about that at all? Because you would have saw the amendment I moved.
Yes, of course.
And I'm assuming you know my motivation. I don't hold any shares in any taxi co-ops or anything. What I'm concerned about, and very similar to what I just talked about there, is fair and just for end users. So can you talk to me about the discrepancy between what taxi pays and what other rideshare operators pay?
Absolutely, and I can certainly acknowledge I've never watched 36 hours of Parliament in a row hoping to see that bill come through, so I was very pleased when we did see you stand up and the bill pass. I think the first thing to acknowledge is that over the last 5 years, The cost of a CTP premium for a taxi has already reduced by around $5,000. So the numbers have already dropped considerably. So I think it's really important to acknowledge that to the extent possible, some considerable work has already been done to bring some equity. Really importantly, by the next week or so, I expect Dr. Casey to provide me with the next round of our motor accident guidelines, which include our taxi hire and vehicle guidelines for me to sign off. We're looking in those new guidelines to have a non-prescriptive premium setting framework. What that'll enable is for us to set the minimum premium for taxis to be equivalent to a Class 1. So to address almost directly the concern you had yesterday, that will be the starting point for taxis. Most of the CTP premium will be paid by passengers when it comes to taxis and vehicles, and insurers will have the flexibility to tailor their premiums in line with the different needs and risks. So those guidelines are going to let authorised service providers who expect to carry out more than 100,000 fare paid trips collect from the riding passenger and then pay the insurer the point-to-point component of those premiums. So those new guidelines will go an incredibly long way, I think, to provide pricing equivalence, which was what you were certainly seeking, if I understand correctly.
If I can, Mr. Dent, and obviously, Ms. Casey, Dr. Casey, you've nearly finished those guidelines, but the push is just to have, if you're in a point-to-point industry, irregardless of whether you're Uber or Diddy or a taxi, you're all doing the same job. You're conveying a passenger from one place to another. Surely then, your insurances should be aligned. One shouldn't be paying more than the other simply because one's called a taxi and one's not.
Look, that's
where the issue comes from.
That principle, Mr. Roberts, is absolutely right. But insurers also need to factor in the general risk that exists, and the risks are often different by nature of the fact that a taxi might be driving all of the time, whereas a rideshare driver might be doing that work much less of the time. So you're right, absolutely. And the power we now have in the bill that passed in June 2022, which took some time to pass. It was with the Parliament for considerably longer than we might have all hoped, but that gave us the power to start this work on creating price equivalence, which I think your principle is absolutely right, that a vehicle doing the same thing with the same degree of risk should have the same pricing. And then where the risk is different, based on the amount of trips, the amount of time on the road, all of those factors, there's no reason that shouldn't be equivalent. So that's what we are absolutely aiming for.
And I don't want to take too much more time, but one sort of wrap-up question from that. And I'm assuming you listened into the evidence from the Taxi Council this morning?
As much of it as we could this morning, yes.
Look, and no doubt you will read the transcripts at a later date. So, but, you know, to your point, taxis perhaps is a higher risk, etc. Going further, as we know, Uber drivers provide, and rideshare drivers provide a service at a peak time normally when they can make more money. So traditionally, Friday, Saturday nights are their busiest time. But also the risk to road users increases on a Friday and Saturday night too. So to simply say one's in the industry more than the other doesn't necessarily correlate to the risk factor. Like if I only drive 2 nights a week, but they're Friday and Saturday night, my risk level is fairly high. If I drive 7 days a week, it doesn't really change that much.
Look, I'll invite Dr. Casey to speak with, but my first point on that would be we're not actuaries and we don't do the risk assessments. That's what insurers are very good at doing. But Dr. Casey?
Look, there is some evidence, well, more than some. We have been collecting data from 2018, and the reason I say from 2018, prior to that, we always talked about the risk of taxi drivers. So they're on the road more, so their risk of having a claim against the policy was higher than Class 1 vehicles. We now have information that allows us to know that a T-plate taxi is 9 times more likely to have a claim raised against it, whilst compared to a Class 1 vehicle, whereas a ride-share vehicle has 2 times the likelihood of having a claim raised against it. So there is definitely a risk profile to both the taxis and the rideshare drivers that need to be factored into the premium.
But can I just suggest this, and then I will withdraw, Chair, because I've got to share it with everybody else. The industry is now being deregulated.
Yeah.
So there will be now more rideshare vehicles on the road, point-to-point vehicles coming into that marketplace. And surely that risk of 2 times more is going to be much higher because they're going to be actively involved. So that's old data that's based off.
Look, I agree, and I think the deregulation, I agree, and we'll continue to monitor it. The deregulation also allows the taxi industry on a more competitive footing. So some of the deregulation allows them not to have some of the overheads and other things that they have. So the model that Adam just talked to, that starting point that the rideshare and the taxis pay starts at class 1 and then it goes up in terms of their individual risk, will give that pricing equivalence.
And just quickly to your point about old data, I mean, it's current in the sense we've been collecting from 2018 to now. We'll continue to collect the data.
You know what I mean, though, Mr. Dent? I don't want to play semantics with you. But
no,
now, once the industry changes, though, all those assumptions from back in 2018, 2019 will change.
Look, absolutely. Mr. Roberts, I agree with you, and we're still looking at those in 2022. And in 2023, as that risk profile changes, that data will be available and that will be able to be made use of in premium calculations. So it's a rolling and ongoing process, absolutely.
Okay, that was going to be my question, is that it will be continually monitored and reported on? I mean, will we just ask in this?
Yeah, I mean, yes, of course.
Look, there's no reason, and we meet, I think the Taxi Council acknowledge that we meet with them quarterly, we share the information, and that annual premium process that I explained to in relation to the TEPL, that also allows all that new information to come into the experience. So the model is never stagnant. You're always using the same information. So we'll be using a new set of numbers. The insurers will have a new set of numbers in terms of the risk from deregulation and from the new model going forward.
It's possibly worth noting, Mr. Martin, I've got the note here in front of me that says we also now have the power to ensure the information needed to determine premiums is provided, and failure to do so actually carries quite significant penalties. So our access to data will continue to improve over time as well.
Beautiful, thank you.
Mr. Donnelly.
Thank you, and through you, Chair, thank you for coming along and providing us the opportunity to ask you some questions in addition to the helpful evidence in the 2 submissions. Can I start, Mr. Dent, by just confirming with you that on or about the 10th of November this year, you were CC'd into a piece of correspondence from the President of the Personal Injury Commission?
I would have to take your word for the date, but I think I now know the correspondence you're talking to, so I will say yes.
Yes. Well, quite specifically, it was a piece of correspondence, quite lengthy. If you don't have it, I don't expect that you would have brought along anticipating this necessarily, this line of questioning. But it was a CCing of a piece of correspondence that the President of the PIC had sent to Mr. Joshua Dale, the New South Wales President of the Australian Lawyers Alliance.
I do have that in front of me now.
Thank you. Now, with respect to that correspondence, did you read that correspondence? Or that correspondence you've been CC'd?
It was CC'd to me. I have read it. It was voluminous, so I confess I didn't read it with the intent to be able to recall from it.
And I'm not going to interrogate you in detail about the content, but rather it was CC'd to you, and were you aware that it was CC'd to a number of other people?
At the point I received it, yes, because the list...
Because the list was there,
on the document, yes.
I'm just running on notice. If you can provide me with the committee with that list, that would be good, because we're looking to get a definitive set of those who received it.
Sure, I have no reason to believe it wasn't the same as what the list said. I can provide the document.
If you could do that, that would be good. But accepting that you're a very, very busy person, you probably worked through the document pretty quickly and skimmed and drew from it what you thought was most important. What did you find when you got to the end of the document? What was your reflection?
Look, I understood this to be Judge Phillips's essentially response to feedback that was in some way critical of the Commission and its work. By reading
Sorry, when you say feedback specifically from the ALA?
From the ALA, and I believe it related directly to the submission the ALA made to this committee. Sorry, if not this committee, sorry, the previous inquiry.
Yeah.
So I understood it was the judge's opportunity to provide some clarification on the matters that the ALA had raised. Certainly, my read of it would indicate that.
Did the judge have cause to ring you up and tell you this was on the way, or?
Yes, But let me clarify quite clearly. The judge spoke to me in relation to a particular section that he intended to include in the document. So we had a
And what was that?
conversation. It was around the piece around IT procurement,
Mm.
because he was he indicated to me that he would be including in this correspondence a section essentially refuting that the procurement had occurred by the Personal Injury Commission, and given that procurement.
Sorry. I thought that he may have contacted you around the time of this being sent.
Yes, correct. And so he called me to advise me that this letter would include content on that matter.
So he was anticipating some correspondence to you and indicating that there would be at least one element that he wanted to specifically touch on in this, and he told you about the...
Yeah, so the judge essentially called to say, I'm going to have to say in this letter I'm writing that there will be a section in relation to the IT procurement. The system to which he was referring was procured by what was then known as the Dispute Resolution Service, which was a part of CIRA.
Mm.
So out of courtesy, given that he would be referring to matters that were essentially now part of my history, he was calling me to advise that he would be saying in a piece of correspondence he was writing that he would be saying that the Personal Injury Commission had not undertaken the procurement, and he indicated to me that he would therefore have to say that that procurement to which the ALA referred was a matter for CIRA.
Right. And what did you say in response to that?
Well, I said he was absolutely right. He couldn't take account for a procurement that occurred in 2015 or 17.
Quite so. Okay, no, that's clear enough, I think, from your testimony. And did he discuss anything else with you about this letter that he was anticipating with you that would be sent in the relative near future?
Not in any detail, other than that he indicated it was in response to the submission to the inquiry and that there were matters that concerned him and he would be responding.
Mm. And did he indicate to you, because this of course was before you'd received the correspondence, that he was going to be communicating these concerns to others as well?
No, we didn't have that level of conversation.
Okay. So can I ask you this? After receiving it, having a chance to look at it and read it and absorb it, what did you do next in regards to the correspondence?
For me, there's nothing in my mind. It was copied to me. It was for information. So I've read the document and I've taken no further action other than to read specifically the section that referred to the IT procurement to ensure I was satisfied that I'd been represented.
So you didn't make contact with the President following the receipt of this?
Not in relation to this letter, no. I don't even know that my office would have sent an acknowledgement of receiving it.
And he hasn't made contact with you to follow this matter up?
No, in actually my recollection, I don't think I've spoken to the judge since then about any topic.
Okay, well, thank you for that. Can I move on then to the issue?
Sorry, Mr. Donnelly, would it be useful if we just attended this physical copy I have here now? Is that helpful? So you have the list?
CC, the
CC list?
Yeah, that would be... Oh, sorry, Chair.
Yeah.
So, thank you. So just moving on, just conscious of time and people, I've got others questions we should ask. One line of question I just want to quickly move through is that we had before us this morning the Australasian College of Road Safety providing some evidence, which was helpfully supplementing their submission, which was submission number 2. And they made reference to a trial that I understand was called, or thereabouts, the Young Drivers Telematics trial. A matter or a trial or
Yes.
a matter you'd be familiar with. Now, this I understand is a trial that commenced, and forgive me if I've got these dates wrong, but it started a little while ago, maybe 2018, 2019.
The 15th of July, 2018, if that assists.
That's perfect. Thank you very much. That's very good. So the testimony was, and I'm bowling this up for you to answer it because it probably would turn up in a supplementary question anyway, that it's now appeared to sort of moved into and been in a period of stasis for a while. It's like you go to the website, this is what the evidence was, and you click on whatever and it sort of takes you nowhere, and it's a little bit unclear from their evidence that anything's happening in regards to this. It's like it's sort of hit pause. Can you elucidate on that trial and where it's up to and features around it? Has it stopped? If not, why not? And take us through it.
Sure, I'll make some initial remarks and then ask Dr. Casey, who's far better versed in this than I. So yes, it was a short-term trial. CIRA is committed to funding a range of trials and research to prove new models and ways to improve both driver safety in the CTP scheme, and certainly in workers' compensation we do similar things to improve injury management. So for us to run a trial is not at all unusual or exceptional in the sense that we try to prove an idea to build an evidence base. On this particular case, the trial also revealed some really useful information. We had 30,000 hours of driving data covering 4.1 million kilometres. We saw a range of things that come from that trial. One of the things that was interesting about that trial also, though, was that around 50% of the participants stopped using the telematics device at a point during the trial. One might assume that a young person probably doesn't like the idea someone's really watching their driving. So there are a range of factors why that trial was both useful and also not necessarily perfect. Before I ask Dr. Casey to comment, I understand that a number of insurers are already using telematics products that are different to the one trialled and making decisions around incentives for young drivers on the basis of that. So the trial was to prove that telematics had an impact on driver safety, and insurers now have that information and are at their freedom to introduce those sorts of programs. But I'll ask Dr. Casey to make any further comment.
I'm not sure there's much I'd add to
Okay,
that.
may I ask then, in terms of trials can sometimes produce valuable information and insights. Is all of what you've said, was that actually published in a report with respect to the trial?
Yes.
Yes.
Okay. I'm wondering on notice if you could provide that.
Yes, of course.
And just, I suppose, a little hint from the Australasian College of Road Safety, they would be mightily interested to be invited to participate in a similar trial or like trials on these sorts of matters in the future. They were, I think, a little bit disappointed perhaps that the opportunity to participate wasn't sort of handballed their way. Anyway, I'd leave it at that.
I'd certainly be shocked if the opportunity was never available, but of course...
in regards to this trial?
Being the New South Wales regulator, we do an extraordinary amount of our work through the Transport for New South Wales Centre for Road Safety. We commit over $3 million a year worth of funding to that centre, so we are actively engaged and involved, and it's unfortunate to hear they
an invitation
feel
by
they didn't have the
email would have cost you
opportunity.
nothing. Moving on, with respect to the evidence from Mr. Cohen, which I think you heard at least some of, if not all of. He was our previous witness. I think, in fairness, Mr. Cohen strikes me as someone who's sort of very considered with how he puts things and explains things.
I'd agree.
And he would be aware of that. And I think that I was probably quite bullish in pushing him to provide perhaps some firmer language that they may otherwise he does use, which is what we do sometimes. But specifically on the issue of the ILARs, and this formed at least a reasonable part of his evidence. And I'm quoting actually from his opening statement here, which I've got the benefit of having in front of me, you don't, but it's a paragraph I'd just like to read to you, and I'll just sort of read it slowly and then sort of, if you don't mind asking your question about
Sure
it.
thing.
So he says the following, and this is the matter of the potential, as he sees it, of the utility of having ILRs in some form operating. And just, this is on page 6 of his opening statement. Perhaps the matter of most concern, however, is that before consulting on the outcomes of the legal support review and making available the evidence for stakeholders to consider and comment upon, Sierra, and this is in his statement, Sierra states that ILRs should not be expanded into the motor accident scheme. So it's a very definitive statement that he makes. In regards to the matter, and correct me if I'm wrong here, that the legal support review, that's the review that was prepared by Clayton Utes, is that?
No.
No, I'm getting confused there, I apologise.
Taylor Fry did a report for CIRA that was the commencement of the work that we're now doing. So the legal supports review that he refers to would probably be the Taylor Fry document.
Thank you. Sorry, so just for my edification, the Clayton Utes document or Clayton Utes report, could you just confirm what that is for?
The Clayton Utes report was one of the two components of the statutory review of the Motor Accident Act. So it was Clayton Utes and Deloitte that did that piece of work.
No,
quite separately.
thank you very much, and I appreciate the Honourable Chair's got more knowledge about this than I do myself. So with respect to then to his statement that I've just read out to you, CIRA states that ILARs should not be expanded into the motor accident scheme, and that's the view that he has formed. Can you tell me how that would square this concluded position with what you have said about the future in terms of the consultation, I use that term generically, in 2023? Because I have to say, without sort of sugarcoating it, he was a bit disappointed that perhaps the phone call wasn't put through about, would you like to sort of perhaps provide us with a bit of input into, this matter at this stage. Now, he may not have known about the general proposition about the considered or the prospective review or participation in the prospective review and consultation next year. So that may be the case, and I don't discount that. But he's got some pretty serious skin in the game, if I could put it that way, in regards to ILARs, and it is quite thoughtful. And clearly it acts as a counterpoint to what is essentially what I describe as the orthodoxy of CIRA at the moment in regards to this. So my questions are, what do you say about this and squaring it with the future? And why didn't you reach out and seek his participation at this earlier stage?
I'll start and again invite Dr. Casey as she pleases. So first of all, yes, CIRA absolutely did, in response to the question in the terms of reference about expanding ILARs into the CTP scheme, say we don't support that. ILARs in its current form as it operates in workers' compensation is not the appropriate solution for CTP. The question put to us, because of the terms of reference of this committee and that point in the Motor Accident Injuries Act, was about expanding ILARs. Were the question to be about a modified form of legal support that might look and borrow some of the elements of ILARs, that's a very different conversation. So I didn't, in the time we had, feel it was appropriate to explore a range of things that we had not yet consulted on in our response. So the question put was around ILARs being expanded in the CTP, and CIRA does not support that. Now, Mr. Cohen will be involved, absolutely, and it's unfortunate that he's formed that view, and I assure you there will be a coffee and a conversation in the immediate future where I attempt to redress that with him. First of all, the legal supports review was conducted by Taylor Fry. Mr. Cohen was involved in that. He actually raised some issues with Taylor Fry's views that they had formed in that view, which were quite reasonable of him to raise. He provided those to us. The review was being undertaken independently, so it was not for us to rewrite. We provided those concerns to Taylor Fry, and the report still was what it was.
Yep.
We have, at the time, said to Mr. Cohen that we would absolutely take his views into account as the work progressed. In the meantime, there are a couple of other elements that are being undertaken. So first of all, actuarial costings on the options provided by the Taylor Fry review were an important step. Some time ago, we had some actuarial costings done on this, and it was before my time, if I recall, when Mr. Shoebridge had first raised the prospect of extending ILARs in this place, and we saw that it was an expensive option. Subsequently, the Taylor Fry review did not recommend ILARs in its current form. They provided a number of other recommendations, which we've now gone and started the work to cost. So the actuarial assumptions that we're working with that have not been released, which is absolutely correct by Mr. Cohen to say that, are very recent, and that work is being undertaken on the basis of the review recommendations that we have before us. We've also started a piece of work around the legal costs and work value that is incomplete. That piece of work has taken a frustratingly long amount of time to conclude. Firstly, it took a little while to find somebody capable and competent to do the work as a cost assessor. Once we did, it then took an even longer period of time to get files from lawyers to use as part of that assessment. But it continues nonetheless. So by early next year, we anticipate we'll have something to construct a useful conversation about the potential options, and we will consult publicly and widely. But it is absolutely fair to say that Mr. Cohen would be somebody who would have considerable input to that review, and we would certainly seek that.
I just nearly finished, but with respect then to that consultation next year, you would appreciate that with respect to those who may seek to participate in that consultation, if they are provided with at least a lion's share of that key material that you've relied on to formulate your position, it's a bit like them contributing with arm tied behind their back because
I absolutely agree, and they
they'll
will be,
need to have.
Mr. Donnelly, if I may, they absolutely will be, and most stakeholders today commented on the extent to which CIRA deeply consults with them.
Yes,
In fact, sometimes we consult for so long and so deeply, I feel like we might never get somewhere, which is a frustration of somebody of my kind. So we absolutely will, and that information will be published and made available to people. It's not all complete, as Mr. Cohen appropriately pointed out. The work value assessment's incomplete. That's correct. So there's nothing to publish on that front, for example. So when Dr. Casey's team starts the consultation process, it will be full, frank, open and transparent, as we always are.
And this is one quick of a notice because my time's running out. With respect to the $91 million collector called the clawback we've touched on earlier today, on notice, are you able to provide an explanation with some specificity, if you can, because clearly you can, of the methodology used to come up with that figure? It obviously wasn't just plucked out of the air. In fact, knowing the organisation and the competence and the professionalism, there was obviously a lot of work done to come up with that figure. We're very keen, well, certainly on behalf of the committee, I'm asking a question. I'd like to know the methodology for coming up with that figure.
Yeah. We can certainly provide you a document called our TEPL guidelines. I invite Dr. Casey to talk in more detail about those, which basically sets out the methodology and the process that our team and the actuaries spend months and months and months working through. But
yeah, look, it's a very transparent guideline that's available on the website. We'll make a copy available. We'll make a copy available to the committee. The scheme actuary also has a process where we have a peer review actuarial assessment as well. There's an industry assessment that's undertaken, then there's individual insurer assessments that undergo. We've got a premium committee, which is a subcommittee of the board that are very involved in terms of ensuring adherence to the guidelines. So there's quite a transparent process that we go through. And in fact, our regulatory publishing policy that we recently released also sees us release when we start the process and when we've got to the different stages in the process as well.
Thank you very much.
I have a couple of very short questions, and Mr. Diadam, I think you have a couple of extra questions as well.
Just one more. Greg
you go.
Yep,
you go first then.
Look, I just wanted to ask, arising out of the evidence from the Motorcycle Council this morning, they again raised the issue around interstate accidents, and I'm assuming this applies not just to motorcycles but also to other vehicles as well. There seemed to be some suggestion around an inability for motorists to acquire additional insurance that would sort of overlap with the CTP policy that would give them coverage for accidents outside of New South Wales. I don't know what work, I suppose my question is, what work has CIRA done in relation to this, and is there consideration being given to some kind of top-up arrangement that would address this problem? It seems to be primarily a Tasmanian problem, but it's a problem nonetheless for those who are taking out CTP and not actually having, an equitable or equivalent form of coverage if they go interstate.
Look, I'll take some of it on notice, but it is a challenging area, and you're right, it's not just confined to motorcycles. We've worked closely with the Motorcycle Council to provide clarity for their members so that they know, at least when they're going interstate, what's covered and what's not. We also meet regularly as regulators, and it is one of the things that we do discuss is that sort of disparity and how we can provide more information so that it's clear to people what's covered, what's not. So that's something that we'll continue to work through. I don't know in New South Wales if there's anything we want to do in relation to the Tasmanian situation, but the approach we've taken with the Motor Council is to ensure that they've got all the information for their members, including videos and other information that we've given them.
But it's not really, I mean, the issue is not information, it's about the coverage. I mean, you take out a policy, you've got a registered vehicle in New South Wales, you're able to drive it interstate, that policy should cover you and should have a consistent level of benefits, irrespective of where the accident happens if you're using that vehicle. Is there no mechanism that can be that's within CIRA's power? And I'm assuming it's going to take legislative change, but
not presently, Mr. Adam, and I might humbly suggest that could be a recommendation for us to examine the feasibility and what might need to happen to address that issue. That might be something you could put to us to look into.
Yeah.
have you done work in terms of the sort of options that are available, and are you able to provide that work if it's been done to the committee so that we can?
I'd have to take
have
that
a
on
bit more
notice.
of a
We've
look?
certainly done work in terms of understanding all the different gaps, but to the extent to which we've looked at options, I'd have to take that on
I'd
notice.
expect the current answer is there probably aren't much in the way of options, which is why we've taken the path we have. So that's certainly something that we could take on.
Okay, thank you. That's all I've got, Chair.
It would be just on this line of questioning, because I think it's quite interesting given the nature of the federation. You're basically dealing with, I assume, probably 8 different schemes. Because I know the ACT's got its own scheme. I assume the Northern Territory does too. So you've basically got 8 different CTP schemes that all need to interact with each other. So you would have someone from New South Wales driving a New South Wales vehicle going interstate. I have no idea how the back end of all that would work if they're in an accident with someone from Victoria or
and
Queensland
all with different benefits as well.
Yeah.
And what if it's by scooter that I take out of Tasmania?
I was hoping you wouldn't ask that.
Just a couple of final ones for me, because we did start early, so we'll finish early. But CTP Care, so announcement a few days ago from Minister Tudorhope. It seems that it's going to fit somewhere in between, in many ways, the CTP scheme and the lifetime care scheme. Will it be sitting with you or with iCare? And in terms of the funding, is it going to come from the CIRA side of things or the iCare side of things?
So the short answer is it's funded through levies that iCare's board will determine each year that CIRA then undertakes to collect in the way we normally do. So the product sits with iCare. CIRA regulates CTP Care as the relevant insurer. But given that Dr. Casey has just spent the last 12 months of her role focusing on this, I'd invite you to answer that.
Thanks, Adam. Look, and again, I'm not sure what else I can add. That's exactly the roles, as Adam has said. We've worked very closely with iCare to ensure that the transition is smooth. So that happens on 1 December. We anticipate about 70 injured people will transition on that date. And yes, as Adam said, the levy is how it's funded. So and the iCare board are responsible for the levy, and CIRA will regulate CTP Care as a relevant insurer, so slightly different to the private insurers that are in the market, and their role is different as well. So they have a role in treatment and care, but obviously they're not collecting premium and they're not doing other things that the private insurers are doing. So we'll have an appropriate regulation and supervision of their role, and we've just issued a few weeks ago, the CTP Care guidelines, which are the guidelines that iCare must follow when they're managing claims for people within that scheme.
All right, so it works sort of a bit more like workers' comp. They sort of run it, but you sort of regulate it in that regard.
Yeah.
It's probably a bad way of phrasing the question, but
It's okay.
Yeah. Okay, I think that's.
I've got
Mr.
one
Diana?
more. Sorry, if I could ask this. So the other thing that was raised by the Motorcycle Council, which I think is interesting and worthy of putting to you, Mr. Dent, is this question about road system liability. So I think Mr. Donnelly asked some questions about potholes and road maintenance as obviously contributing in some circumstances to single vehicle accidents involving motorcycles, but I'm sure there's other sort of scenarios that we could imagine, and that question around whether the liability for that injury should be borne by those paying premiums when clearly the negligence or the failure is actually with the road system and its maintenance, and what capacity there is, if any, for CIRA to, I suppose, recoup those costs from the system, from the entities that are responsible for the system, for the maintenance, whether it's federal, state or local roads.
I'll ask Dr. Casey to take that if you don't mind, Mr. Diadam.
Thanks, Mr. Diadam. So there is a mechanism to seek recoveries for third parties that have played a role in the accident. That is the role of the insurers, and we set that expectation in the guidelines. And I can tell that we have, as a scheme, recovered over 30.84 million in recoveries. So those are recoveries from various schemes and other responsible entities for their role in the accident. So there is a mechanism to recover. There is a mechanism for us to ensure that insurers are doing that, and we are doing that. So I guess assuring that those recoveries do happen within the scheme, so they're not being paid for by the CTP scheme when there is another place that should bore that cost.
On notice, are you able to provide a breakdown in terms of, whether it's local government or where the recoveries are being drawn from?
I'm certainly happy to take on notice whatever we've got. I do know that it doesn't, it might not be as granular as that, but I'll certainly provide what we can, that breakdown of that 30.8 million, yeah.
Excellent. Thank you so much for joining us as our final witnesses for today. Committee members may have additional questions for you after the hearing. The committee has resolved that the answers to these, along with any answers to questions taken on notice, be returned within 21 days. The Secretariat will contact you in relation to these questions. Thank you for your time today, and that concludes today's hearing.
Thank you, Chair.
Thank you, Mr. Dan.